Pardon to them, sir.
Item number.
I mean, pardon to them, sir. So in my case, judgment may make and this one will make past my lord in my writ application. Since 18/8/2017, the judgment has.
Item 1, my lord. I pray for not press, my lord.
All right. Counsel, the petitioner states that you're not pressing the petition. Dismiss is not pressed.
Weekly list item number 2. But I'm for the respondent.
None appears for the
My
petitioner.
lord, I am for the petitioner, my lord.
Yes, please.
My lord, my case is that, my lord, in this writ application, the petitioner challenges Annexure 5, 8 and 14 issued by the Hindustan Petroleum Corporation Limited, inter alia on the ground that the power alleged to have been vested in them is not there as per the Caltex Acquisition Act, my lord. My lord,
Lord, I may point out, Lord, this Caltex Act, wherein he is challenging certain provisions and interpretation thereof, has already been repealed in 2016.
Oh,
My Lord, that is one. Second, my Lord, worse against me from 2013, my Lord. I would be treated as a trespasser on his property, my Lord. Worse against me. My Lord. For that, he needs to go to the civil court. Why a writ court?
correct.
This is the repealing provision. My Lord.
All right. Yes, Mr. Jana.
my lord, yes, my lord. My submission, my lord, is that to our own High Court judgment, my lord, I have given, my lord, your lordship may take it, please. Our own High Court judgment reported in AIR 1994 Orissa 103, my lord.
Yes.
The facts are exactly same, my lord.
That act has now gone, sir. So the facts have changed. The act itself has got repealed now.
My lord, I submit, yes, my lord. Even if the act is repealed, my lord, I say that the earlier action of theirs is, my lord, they are continuing public undertaking, government undertaking, my lord. I rely on two judgments, my lord. One is of AIR 94 Supreme Court 103, and the other is from this judgment, the Hindustan Petroleum Corporation went to appeal, my lord, and that has been reported in 1999, volume 4, SCC 450, my lord. So on the basis of the strength of these two judgments, my lord, my humble submission is that the writ petition is maintainable since they had already exercised, which is under challenge, my lord, their power under Section 7 of the Caltex Acquisition Act, my lord, that is 1976. So even if I have no information that has been repealed, my lord.
It was repealed in 2016, sir.
Yes, my lord. Even if it has been repealed, my lord, they exercise their power under.
No. Now it becomes a basic issue of trespass. You file a civil suit, sir.
My lord, what I humble submit, my lord, humbly submit in these two judgments, the Honorable Supreme Court, our court, and in the other judgment, my lord, special leave I have given from Madras, the third judgment, my lord, the special copy has been given, my lord.
Sir,
That
all
is-
of these judgments were interpreting provisions of the Act. All right.
Yes, my lord.
The Act itself doesn't exist anymore now.
My lord, the earlier action which has already been taken under the Act, that
Yes.
is under challenge, my lord.
Yes.
So a government undertaking, my lord,
Once the
after
Act is repealed, sir, once the Act is repealed, we cannot go back there and seek and interpret.
no, my lord, the Act is repealed, my lord, I humbly admit. But fact remains that
Yes.
they have exercised their power under that section. That is why I challenge that they have no power. They have no power under that section.
So
So
the flagged part.
I humbly admit that their position is a trespasser, and relying on the two judgments of the Supreme Court and our own High Court, my lord, a public sector undertaking dealing with a citizen cannot do this sort of act of things. That's why the honorable courts interfered with it and directed the Hindustan Petroleum Corporation to give the possession to the lessor within a period of time. And the latest judgment is also that special leave petition, my lord, I have given 6726 of 2021. They have the Honorable Supreme Court has gone further, adding that this conduct of the BPCL, in that case BPCL, in my case is HPCL, my lord. The action is unbecoming of a government undertaking, which is violative of Article 14 of the Constitution. That's why this Honorable Supreme Court in the second case, special leave number, not reported, my lord. They have gone further. They have directed for the oil company to give possession and direct and impose the cost of rupees 1 lakh rupees. And my lord, giving an opportunity to both the parties to file documentary evidence in support of their market value of the property. So, my lord, these decisions are there. The earlier action is there. The writ petition is of 2004. Therefore, my lord, my humble prayer is that by referring these two judgments, I pray that, my lord, Annexure 5, Annexure 8 and 14 issued by the HPCL may be washed, and they may be directed to give vacant possession to me within a specified time. And your lordship may, considering the enormous rise in the price of the land, give them direction to pay a certain amount, or your lordship may please adopt the approach adopted by the Supreme Court, giving the parties to file documentary evidence in support of their stand about market value of the land. So, my lord, even if that act has been enacted, the earlier action under the act is under challenge.
That was not even considered. That has not even been considered in this national company matter.
My lord,
The effect of repeal of the act has not even been considered because the appeal arose much before.
yes, my lord, the action has been taken under the S2I Act.
Yes.
The action, the HPCL, a public sector undertaking, has already acted in pursuance of the earlier act. So I challenge their action on the earlier act, my lord.
Yes.
I submit that, my lord. I humbly submit, my lord, the three judgments, our own High Court judgment, that is AR 1994 Supreme Court 103, and the second one out of this, my lord, the Supreme Court 99 4 SCC 450, and the third one is decision of the Honorable Supreme Court Civil Appeal number 6726 of 2021, decided on 11/11/2021, may be taken into consideration. My application may be disposed of accordingly, my lord.
What was the original period of your lease?
My lord, yes, my lord. My first lease was from 1963 to 73, my lord. Before just end of this, as per the renewal clause in 3, that is Annexure 1, my lord. My past lease deed is Annexure 1. Clause 3G of the lease deed says that if the Caltex India proposes or offers to get the lease deed renewed, it can have the power of renewal for 2 terms, one term being 10 years each. So, my lord, after 73, on the expiry of the first lease, they entered into a further lease, my lord. The further lease is annexed 2, my lord. That lease, in terms of the first lease, my lord, that is clause 3G of the lease deed, annexed 1, my lord, they got the land for 20 years, my lord, from 73 to 1993. And before just they wanted to renew it, but I prayed them that no, I am not agreeable to your rate and other things. So please vacate my land. So, my lord, this proceeding continued, and subsequent, lastly, my lord, by Annexure 5, they stated that they are exercising their power under Section 7 of the Caltex Acquisition Act 1976. So, my lord, I challenge this on the ground that I will place reliance on the one, my lord, only one, my lord, how the writ petition is maintainable on the.
No, 1 minute, sir. Just let's get the facts fully correct, sir.
Yes, my lord, facts,
If
my
you
lord.
don't mind. So the
Yes,
30th June letter, they exercise the right for renewal for another 20 years.
Yes, my lord.
So during this 20 years that ended on 31st October 2013.
No, my lord, 1993, my lord.
No, 1993 plus 20 is what?
My lord, that second lease deed does not contain any renewal clause. The
No,
act
sir.
kept.
I
Yes,
think
my
you're
lord.
missing the point. You're missing the point, sir.
I may be, excuse me, lord, please.
Kindly come to page 38,
Page 38 of the.
paper book.
Yes, my lord.
Just read the last line.
Yes, my lord, page 38. Yes, my lord. 1 minute, my lord, I may be, excuse me, lord. Yes. My lord, page 38, last page. Accordingly, we hereby exercise our right to renew the lease for a further period of 20 years, commencing from 1/1/93.
So how, what,
These acts, my
no,
lord,
1 minute,
yes,
sir.
my
Just answer the question. Just a minute. Are you in a
Yes.
hurry, sir?
no, sir, please.
What if we add these 20 years to this date? What date does it take us to?
My lord,
If you add 20 years to 1/11/1993, what date will you reach?
my lord, they exercise it after
Why don't you
93.
answer the question?
Yes, my
don't
lord, I am
understand. What is
submitting.
your-
Yes,
what is
my
your
lord,
difficulty in answering this question?
my lord, my answer is that they have no power under section of
Sir,
the.
there's something in your favor. You're not catching on to it. It's such a sad thing. I'm sorry to say this.
Yes, my lord, sorry,
You're
I am.
trying to say something in your favor and you're not catching on to it.
Please, sorry, sir, sorry, my lord. This
If you add
93,
20 years to 1/11/93, which date will you get, sir?
my lord, 93, from 93 to 20 years, my lord, I humbly agree with your lordship.
What do you agree? Why don't you answer? What is the date you will get?
My lord, what is the?
What would be
I'm
the
sorry,
date?
my lord, I am from hearing problem, my lord. I may pardon, my lord.
What would be the date for the 20 years lease which was renewed
2030.
from 1st November 1993? It would be 2013.
Don't let him answer, sir. What is this? Why you can't hear this?
My lord, I agree that it is from 93 up to 2013, this 20 year, I agree, my lord. My lord, I challenge.
1 minute. 1 minute. Now you answer the second question, sir.
Yes, sir.
Have they issued any further letter after this? Further renewing after 2013?
Yes, my lord, 1330. By that time, my lord, the writ petition has been filed challenging their action.
I don't know. I think you, sir, you're just not refusing to listen to questions, sir. I don't know what this argument kind of advocacy is. Here is a court trying to help you, but you do not want it.
I'm sorry, my lord. So, Millard, my humble submission, my lord, is that on the basis of the three judgments, my lord, which squarely apply to my case, may your lordship may dispose of the case. My lord, my submission is that under section 7 of the act, that is annexure 5.
All right, sir. You're just not in the mood to listen, but still your client should not get affected. We'll ask the other side now. Yes.
Yes, ma'am.
Yes. Sir, did you exercise any right after 2013?
But there are communications.
What communication? Tell us.
But the communications, unfortunately, are not on record.
No.
Page
You
7.
show us any letter after 2013.
But kindly take page 31 of the lease deed.
No. Did you write a letter?
Yes, my lord. Letters are there. Unfortunately, they're not.
No, unfortunate. You did not file a counter also in this?
No, it's not been.
Then you don't have a case. So your case is finished as of 2013. You never exercised any right, even on your own showing, you can't continue after 2013.
Milord, therefore, Milord, my humble submission would be that if you take the lease deed, Milord, at page 31, which he's referring to, Milord, there is a clause in the lease deed which says that it will be extended, Milord. The lease would be extended, or he would offer it to us for purchase.
He has not.
Milord,
Neither has he done.
Those are
no. There's no perpetual lease clause.
No, Milord, here this is a unique case, Milord, where there is a clause for offer of sale, Milord.
Yes.
And Lordship takes, Milord, for a moment, page Milord 38, Milord.
No. What is the clause? Let's see the clause.
Milord, this is page 31, clause number. Milord, it's at internal page 7. It is clause number F, Milord.
Yes.
The lessor hereby grant onto the lessee an exclusive right at the lessee's option to purchase the desired premise on the same term, on the terms and conditions subject to the market title, etc.
Not etc., sir, please. Are you in a hurry?
No, not at all.
Then read F carefully and slowly,
Milord,
if you are relying on it.
Milord, the lessor hereby grant onto the lessee an exclusive right at the lessor's option to purchase.
Lessee's option, I thought.
Milord?
Is it lessee's
To the
option?
lessee's option to purchase.
I think, Mr. Das, you're in some hurry. I don't know.
Not in a hurry.
Just read it carefully, slowly. You can't mix up the terms lessor and lessee like this.
Milord,
Read it again.
the lessors hereby grant onto the lessee an exclusive right at the lessee's option to purchase the desired premise.
Demised, sir. Demised premises.
On the terms and conditions, subject, however, to the marketability of the title of the lessor in the demised premise and at the same price as any bona fide offer for the demised premise received by the lessor and which offer the lessor's desire to accept.
Get onto digital medium.
Milord.
You're able to zoom in.
Milord. Milord, in fact, I carried a magnifying glass, just because the print is typed and old.
Just try. Keep your tablet.
Milord.
Just try it. Scan your papers.
Milord.
Just try it. It's much easier. Yes.
The lessor shall immediately, Milord, intimate to the lessee in writing the details of such offer, including the relationship of the offer with the lessors and the
Name and address of the offerer.
offerer.
That is, there is some other offerer,
Milord.
and they are asking you want to better it.
Milord. Milord, my humble submission is, Milord, according to instructions, is Milord, they continue to negotiate thereafter.
No. I see there is the last letter which he read.
Milord.
That does not say sell it to us. Read that letter again. Annexure 5.
Say
No, it
31.
doesn't say. It doesn't talk about 37, 38, Milord, because this was during the period of the subsistence of the lease.
Whatever, sir. So the question really is, and the clause as it reads, it's entirely up to the lessors if they want to offer it to you for sale. It's not the other way around, where you cannot put the gun on their head and say, better sell it.
Very true.
So that hasn't happened. He's made his intention clear. He wants you out. All right.
Milord.
You've not asserted your right to continue
Milord.
after 2013.
Milord.
So you just tell us by which time you vacate and what have you been paying in the meanwhile?
Milord, I'll obtain instructions to that effect, Milord. I do not have up-to-date instructions because the matter was old, Milord. And if your lordship gives me 2 days time, I'll obtain the up-to-date
You
instructions.
say the present the prayer in the present petition is for declaring that the continuation of Hindustan Petroleum Corporation Limited, bracket HPCL, in the premises of the petitioners on lease, pursuant to a lease, which according to the petitioners was being renewed in purported exercise of the powers under sections 5 and 7 of the Caltex bracket acquisition of shares of Caltex Oil Refining bracket India Limited and of the undertakings in India of Caltex India Limited Act bracket 17 of 1977 unquote is illegal. The consequential barriers for the eviction of HPCL from the premises. Although the petition has been pending in this court for about 18 years, and notice was issued way back in 2005 itself. No, notice has not been issued formally. Okay. No, notice, yeah, in 2005 itself. Till date, no counter affidavit has been filed by HPCL. Paragraph. Mr. Jena, learned counsel for the petitioners, that at the outset, you say Mr. Aditya Das appearing for HPCL drew the attention of the court to the Repealing Amending Act 2016 passed by Parliament on 6th May 2016, whereby among the several enactments that have stood repealed is the aforementioned enactment of 1977. Stop. The contention of Mr. Das, therefore, was that the only remedy available to the petitioners was to go for a suit for eviction. Paragraph. Mr. Jena, learned counsel for the petitioners, on the other hand, relied on the judgments in Srimati Dolly Das versus HPCL, AR 1994 Orissa 103, affirmed by the Supreme Court in HPCL versus Dolly Das 1999 4 SEC 450, and the recent judgment dated 11 November 2021 of the Supreme Court of India in Civil Appeal number 6726 of 2021, bracket National Company versus Territory Manager BPCL, bracket, and submitted that directions similar to the ones issued by the Supreme Court in the aforementioned cases should be issued by this court. Paragraph. Mr. Jena drew attention of the court to a letter dated 30th June 1993, where exercising its powers under the 1977 Act, HPCL stated that the lease would be renewed for a period of 20 years commencing from 1/11/1993. Paragraph. That period obviously came to an end on 31st October 2013. Stop. Nothing has been placed on record to indicate that HPCL exercised its right to continue beyond the aforementioned date. At this stage, Mr. Das stated that he would need to take instructions whether any such correspondence exists. Paragraph. The repeal of the 1977 Act would mean that HPCL can no longer exercise its rights thereunder to renew the lease. Stop. If it has not exercised any such right any time after 31st October 2013, then even on its own showing, it cannot be asserting a right to continue in the premises. Paragraph. On the question whether HPCL has been paying the market rent as was directed by the Supreme Court in the aforementioned cases. Mr. Das said he would have to take instructions on this as well. Paragraph. To enable Mr. Das to take instructions on both aspects. List on 14th March.
Obliged.
All right.
The Dolly Das case, which my learned senior was addressing, was modified by the Supreme Court.
All right. Affirmed is affirmed is
Modified.
modified. All right. All right.
Obliged.
All right.
Weekly list item number 3.
I am for the opposite party.
None appears for the petitioner. Dismissed from.
Weekly list item number 4. Weekly list item number 4.
None appears. Dismissed from prosecution.
Weekly list item number 5.
My lord, weekly list item number 5, the brief has been transferred. I am junior appellate
Counsel, the
judge.
petitioner states that the brief has been transferred to some other lawyer. None appears today. No other
Yes,
lawyer appears today.
Your Lordship, item number 5, I am appearing, Your Lordship. I am for the petitioner.
Tell us what is the matter about.
Your Lordship, I have already submitted a date chart, list of dates.
Yes.
If that's in your Lordship's record, Your Lordship,
Right.
kindly peruse the date chart, Your Lordship. List of
All
dates.
right. Yes.
Your Lordship, pursuant to an advertisement on 15/10/1979, a lease deed was executed between the opposite partner 1, 2, and the petitioner.
Yes.
Land belongs to opposite partner 1. Finance is to be sanctioned by the OSFC, that is the opposite partner 2, and the one unit of handloom was supposed to be established on the concerned plot. And delivery of possession was given on 26/2/1980. And pursuant to that, you also may kindly turn to the next page of my list of dates. On 24/3/1980, the OSFC on pen and paper sanctioned 94,300 rupees in favor of the petitioner. If I Lordship permits, I'll go brief to only first go to the dispute, then whatever Lordship queries or asked, I'll be there to answer your Lordship. Out of 94,300, only 78,764 was given. In the meantime, due to non-sanctioning of further working capital, the unit could not function, and it was declared a sick unit subsequently. Again, the petitioner invested some money and made it operational. This way, the unit continued. Ultimately, the unit was seized on 9/9/1986 without prior intimation to the petitioner. Petitioner went on giving representation to different authorities. And in the meantime, Your Lordship may kindly see on the last date of my list of dates, I have already mentioned, out of 78,764.50 rupees that has been sanctioned to the petitioner, actually, petitioner has already repaid 47,490 rupees by cash. And Your Lordship, after that, after seizing, the petitioner's unit was also sold. And that is sold for 50,000. Your Lordship, that I have already averred on page 8 of my read petition and para 24. So on record, if it is calculated, then 47,000, 50,000 after seizing industry and the machineries, then the OSFC has already recovered all its money. In the meantime, Your Lordship, because obviously bad time never comes alone, both the petitioner and his husband, both were expired, and now the son of the petitioner, who has been who has been substituted for cardiac arrest, he is hospitalized. For that, I could not take the proper information to submit to Your Lordship. But my contention before Your Lordship will be that once they have taken over the money that have been sanctioned, property belongs to the opposite partner 1. Opposite partner has not moved against the petitioner, and petitioner is possession of and the lease was for 99 years, Your Lordship. And the petitioner is in possession of the lease whole land till date, then they could not have sell out disposes the given the letter to dispose the petitioner. That is not an extra 3. So that's why I have come before Your Lordship.
No. It's not clear what you are trying to argue. You told us some time ago that your unit has been sold
Pardon,
and the
Lordship.
money recovered is in excess of what you were owing OSFC. Isn't that what
Lordship.
you argued?
Then what I say is, the
No,
lease
no.
was for 99
Just
years.
answer yes or no.
Yes, sir. Yes, sir.
If the unit has been sold, no possession has been given to the buyer.
No, possession has not been given yet.
Then what is
Because
this? What is the selling? What is the so-called selling?
This
If
selling,
the man
I
who
was-
bought the property can't get into the property, what is the sale?
Your Lordship, the sale of property was made so clandestinely that I could not know that.
What is this
property was sold.
clandestine? What is to do
I
with
could-
clandestine? There's nothing clandestine about this.
Your Lordship, there was no.
No,
proper
what is this?
paper
So you
publication.
continue, 1 minute. So you are just continuing this property despite
Yes,
it
sir.
being sold.
Yes, Your Lordship. I am continuing with the property.
This is a very happy situation for you, sir.
No, sir. What I'm trying
Yes, extremely happy situation. You have not moved from your property for the last 40 years.
Your Lordship, the property belongs
There's
to.
no unit has been sold. Some poor man has paid for that and not got possession because you are still sitting on it.
Your Lordship, OSFC could have only sold the industry. It could not have sold the property because that is my contention. Property belongs to OP number 1. OP number
Whatever
1
it is,
not-
you are just sitting on the property, correct?
Your Lordship, I am in possession of the property for the reason that it is for 99 years and Tahsildar has not, lease deed has not been cancelled by the Tahsildar.
Which is why you're very happy, sir. If today you withdraw the petition, you don't have to pay anything to OSFC, you will continue the petition, the property.
Your Lordship, if Your Lordship, yeah, Your Lordship,
So you withdraw your petition. That's the
I
end
will
of the matter.
I will be represented with the OSFC, Your Lordship.
Sorry?
I will withdraw with Your Lordship.
Counsel the petitioner
Liberty,
seeks
I
to
will
withdraw this
represent
petition with liberty to approach the OSFC with an appropriate representative.
I beg pardon. I am appearing for the opposite party number 4 who has purchased and
We're
take your
vacating the stay
lordship.
today, sir. We're vacating the stay. Although you never moved to vacate it. All right. The petition is disposed of, is withdrawn. The interim order stands vacated. Yes.
My lord, he has put his signature and he has handed over the possession to me. I am in possession over the property. At page 102 of the brief,
Anyway,
his
sir, we
signature is there.
vacated the status quo order. So,
Weekly list item number 6.
Wait, please, Your Lordship. Your Lordship, I'm appearing for the petitioners here, my lord.
yes, Mr. Patna.
My lord. My lord, I'm here and challenging Annexure 10, my lord, which is a letter of IDCO dated 2/2/2009, my lord, wherein they have rejected my application for an amnesty scheme with a one-line reasoning saying it's not permissible for regularization, my lord. That's my case, my lord. But it has a checkered past, my lord. It's a case where I had given my application to them for an industry, for a small-scale industry. That application has been accepted and they have given me a letter of assurance in 1996, which is under Annexure 3, my lord, at page 32. My lord, may kindly have page 32. That's where the DIC has given me a letter of assurance. Post that, my lord, after 1996, in 1998, I take over a sick industry. They give me, from OSFC, my lord, they give me this lease deed under Annexure 2 only in 2000. That is for 0.141 decimal, my lord. It is admitted, my lord, I must say this before your lordships with clean hands, my lord. I am possessing properties more than 1.141 decimal, my lord, which has been given to me under Annexure 2. That is what I have been since 2000, my lord. There are several letters, several correspondence. I have been asking them that I'm ready and willing to pay. I'm ready and willing to accept and abide by any terms and conditions put forth by IDCO, but please do give it to me, because as originally placed before you, my unit would require a particular.
No, so basically you encroached on land which does not belong to you, and this writ petition is to ask them to sell that to you.
My lord,
Yes.
not,
That's what
not
it
only,
means. You went and
Yes, my lord.
occupied more land, and you filed a writ petition saying they should be directed to sell it to you.
my lord, after
And
that, my lord,
you also passed a status quo order, so you've been comfortably staying on that extra land, not paying a farthing.
my lord, I would wholeheartedly accept, my lord, the first part of your statement, my lord, but with humble request, my lord, the second part I have been time and again requesting them that please ask me, give it to me, any payment that I need to be made shall be made, my lord. And my lord, may kindly have a glance at Annexure 6, my lord. That's my cause of action here, my lord.
What's the market value today of that land?
My lord, I'm not quite sure, my lord, but even today...
You not want to be sure.
No, my lord, because I've not taken...
Because that will be very uncomfortable information for your client.
Not
Where is this?
Not
This
so
is
much.
located in Bhubaneswar. Where is it?
Chandaka, area.
So what is it? Is it outskirts of Bhubaneswar?
No. It is
Heart of Bhubaneswar.
Heart of Bhubaneswar. Chandaka is
prime property
within smart city. There is an industrial estate there.
Okay.
And it is within smart city area.
And your client, we should believe, Mr. Mohanty, your client does not know the value of that property, correct?
No, my lord, I'm not saying that. If I may...
What we'll do is, you can educate us by educating yourself. We'll pass it over. Ask him to tell us the exact market value of the property today. What is the extent of the property?
141 decimal.
141 decimal is how many square feet? At least 10,000 square feet. More than that. 141 decimal is...
No, sorry. 141 they have already been allotted. They have asked for...
May I, my lord, clarify?
150 decimal, I think.
Yes.
150 decimal. So you just find out what the market value of 150 decimals in Chandaka estate is.
May I clarify, my lord?
Yes.
My lord, may kindly have a glance at Annexure 8. I'll place all the things on record, my lord. I'll not shy away, my lord. I'll not shy away from difficult questions.
All right.
My lord, may kindly have a glance at Annexure 6 first. I'll take your lordship to every aspect which is on record, my lord. Annexure 6, my lord. Annexure 6.
No. First, let us get the
my lord, Annexure 8. Annexure 8. My lord, Annexure 8. Annexure 8 is their letter, my lord. It goes letter. My lord, may kindly have a glance.
Yes.
It's a 30/12/2008 letter, my lord. It says
your
it's a
prayer
letter.
Clause, just come to your prayer clause.
My lord, prayer clause. It says encroacher of 0.060, my lord.
We come to your prayer clause. Your prayer clause, you should know what you have done, right? Just come to your prayer clause.
Madam. Yes, madam.
What do you say there?
My lord.
Not to allot land measuring 150
0.015 decimal, my lord.
So that is clearly the land in the... This is your own admission because this is your prayer clause.
Yes, my lord. But may I clarify, my lord? Out of the 0.150, my lord, I have currently only possessed, my encroachment is of 0.060. I am asking for additional land.
But this is extraordinary, sir. I mean, this is an extraordinary repetition where you say, yes, I have encroached. Now please allot land. That encroached land.
60 decimal of land is encroached by him. He
Not
is
60 decimal.
to get more land than the encroached land.
0.060. 0.060, my lord. My lord, if I may clarify, my lord.
You're not amended your prayer clause.
No, my lord, I'm not amended, my lord, because it's on there, on record.
What you have admitted in your prayer clause is 150.
Yes, my lord, 150, but that's not encroached. That's what my prayer is, my lord. My lord, I'm just clarifying.
No, if you say 150 should not be allotted to anyone else.
Yes, my lord, 150 should not be because I need it.
150 right now you're entitled to. That's why this prayer clause.
That's what my prayer clause. I bowed on, my lord. I bowed on. My lord, my humble submission is...
First tell us what is the market value of this 150.
I will try and ascertain, my lord.
Yeah. We'll pass it over. You ascertain. Mr.
My lord
will also find out.
My lord,
if I may only pray two things.
Lawyer must be there.
If I may pray only two things, my lord.
Yes.
My lord, first of all, even today, if they transfer the land, I will pay whatever their terms and condition is. That's my written award contended.
Interest on that market value for all these years you've been encroaching on it.
My lord, but then my lord is asking market value today.
Unless you deposit it within whatever time we give you, there's no question of this continuing to be in possession.
No, my lord, but my lord is asking for... No, my lord is asking me for market value today. Interest of today's market value for 20 years, my lord, will not probably be fair, my lord. My lord is asking for market value today.
Let's see about that fairness and unfairness very soon. We'll find out the market value.
My lord, kindly take it up tomorrow, my lord.
No. Today. We'll pass it over right now. Yes.
My lord, I may have difficulty finding out. I'll try my best.
No. Your client will know in 2 minutes.
I'll just
ask him to talk to some real estate person in Bhubaneswar. He'll tell you in half a minute. Yes.
I'll find area, as far as my knowledge goes, in Chandaka area, 10 crores per acre.
is the market valuation. I'm sorry, the benchmark valuation. Market valuation is double of that.
Whatever, so you just find out. Just talk to anybody there, they'll tell you. Yes. Yes.
Quick list item number 7.
My lord, the petitioners is a small SSI unit operating in industrial estate Paradip, and the proprietor is a scheduled caste lady who initially was allotted a small portion of land to operate her SSI unit. Lords, I have prepared a date that you lords may kindly have it. There is a sequence of dates. In 1982, my lord, the petitioner was initially allotted plot number 46 of the Paradip Idco Industrial Estate area of 14 decimal land. Thereafter, my lord, in 1986, my lord, as the land was insufficient on application of additional land, further contiguous land measuring area 26 decimal bearing plot number 48 part was allotted and possession thereof was duly handed over by the OP Idco in favor of the petitioners. It is pertinent to mention that the petitioner unit encroached some additional land for the purpose of effective functioning of the unit and applied for regularization of such.
So this is a nice pattern, sir, in Orissa. In fact, this can be an education to the whole country.
No, ma'am.
Yes. Even in earlier matters I found, first go and encroach.
Same matter.
First encroach, and then if you get into some trouble, go to the court, get a stay.
No,
they have protected. This is just see that order dated 14 September. Have you seen that order dated 14 September 2006?
14 September, below.
We've said you will not be evicted from the encroached portion provided it is in your possession.
Yes, ma'am. Yes, ma'am.
Extraordinary.
That I know.
Extraordinary. And no conditions, nothing.
Because of their
so for 16 years now, for 16 years, you are comfortably encroached.
Because of their own admission, I will take your lordship to one document that will speak for itself, my lord. At page, my lord, your lordship may see what they have stated. I am entitled to the land along with the additional land if I am subject to payment of certain amount, my lord. That is, my lord, at lordship may see.
Page.
First of all, my lord, 27, my lord, annexure 4, page 27. They have alleged certain facts, my lord, which is really doesn't exist. It's a manufactured fact. False allegation they have made that my unit is not functional. Now their report, I will see that the report, the field inquiry was conducted and the report was submitted in my paper that my SSI unit is fully operating. Now they say that you have changed the whatever that may be, that the allegation they made. Then, my lord, at page 33, they say, however, for consideration at page 33, order dated letter dated 18/3/2005. However, for consideration of regularization of your possession over Idco plot number 48, you are required to deposit a sum of rupees 69,410 only on before 31/3/2005 was the one-time outright purchase cost of above mentioned plot on receipt of the same. My lord, thereafter, in compliance of this letter, my lord, I have deposited a sum of rupees, the entire money, which is money receipt I have annexed at, my lord, annexure 6 series, starting from page 40, page 42, my lord, 44. These are the money receipt and payments have been accepted. They were, as per their own admission and terms and condition, my lord, they have issued the letter. They should have regularized the land and executed the sale deed. They never did it. I went on corresponding with them, breaking my head that please execute the lease deed, that I will get my financer is ready. I will get finance from my bank.
Let us get the plot numbers proper, sir. All right.
Plot numbers will have 46 and plot number 48.
But 1 minute, have you seen the stay order? 14 September stay order, have you seen?
No, my lord, I'm
we'll help you, sir. We are here only to help you.
Yes.
Please show him the order.
I remember
14 September 2006.
Yes, sir.
Please see that order.
Yes, my lord, I have, my lord, I have.
Please read that order, sir.
14 September 2006, my lord. In the interim, the petitioner may not be evicted from plot number 47 without due process of law provided. he is in-
So this stay order is for 47.
47.
You are now not interested in 47 at all.
Thereafter, your lordship may see some further orders have been made.
No,
with
today, let us be clear. You have nothing to do with 47? Are you clear?
Nothing to do with 47, my lord.
No,
47 also
in your
they-
list of dates, there's no mention of
Yes.
47.
47. No, my lord.
In your list of dates, there's no mention of 47.
There is some error in the order. Therefore, I sought modification. Thereafter, lordship may see.
No, the same date. Just see 1/11/2006.
1/11/2006, my lord.
Do you have that order or should we give you the file again?
Counter.
No. Do you have the order 1/11/2006?
No, 1/11/2006, I have not.
So we'll help you again. All right. So orders in your favor also you don't have.
My lord. The old brief, my lord, it was transferred, but then it has come to me, my lord. Sorry, I'm extremely sorry. Yes, this is because of, my lord, when I stated that instead of allotment of 46 and 48, I am encroached the 47 plot. Please don't evict me from 47 because I am entitled to additional land as per the recommendation of the OP number 5 authority, for which the IDCO was insisting me that you should get a recommendation from the.
No, let us be clear.
My lord.
You were allotted 46
and 48 part.
No, you allotted 46 and 48. You occupied that.
Yes.
You occupied 47.
Yes.
And you didn't pay anything.
I was all throughout interested to pay, but they
very nice, sir.
They did not.
I will tomorrow encroach on the secretariat. I will tell the government. I will first encroach. I'll say I'm interested to pay.
Lordship may see the letter what they are saying. You come through the OSF that my lord OP number 5 authority.
Just come to 1/11/2006 itself, sir.
Industry Center, my lord. The general manager, they said, my lord.
Mr. Panda, am I audible to you?
My lord.
Is it okay to ask you some questions?
Yes, much obliged.
Can I ask you to read that 1/11/2006 order?
Yes, my lord.
And read it fully, sir.
This is an application for modification of the order dated 14/9/2006. On prayer of the petitioner, this court as an interim measure directed that the petitioner may not be evicted from the plot number 47 without due process of law, provided he is in fact in possession of the said plot. Now, miscase has been filed to modify the said order, deleting the said observation.
Why do you want this observation deleted? What was the fact? What was the fact that led you file this application to delete that observation?
In fact, not in possession. If he is not in fact in possession, my lord, and the miscase has been filed to modify the said order, deleting the said observation. We are not inclined to modify. My lord, I say that, my lord.
1 minute, sir. I am not done with it. You seem to be done with it. I have not done with it because there is something more to read there.
Yes, my lord.
Please take back that file. Please open that page.
My lord,
please stay on that page.
My lord, my lord.
Plus, tell us why you wanted this observation modified.
That, my lord, I
don't know.
I am to see, my lord, my application, my lord.
Then keep reading down. There's one more order of the same day.
My application, my lord.
1 minute, sir. We are on 1/11/2006.
Yes, my lord.
There is one more order on the same day.
Yes, my lord.
Read
This
that
is an
now.
application for appropriate order. It appears that the date of appearance of the opposite party is fixed to 8/11/2006. The petitioner in this case stated that the opposite parties are now ready and willing to execute the lease in respect of its possession over plot numbers 46 and 48, situated at Paradip Industrial Estate. We make it clear that the pendency of the writ petition will not be a bar for the IDCO if it decides to execute the lease deed with the petitioner urgent support.
So tell us correctly. Don't put off the file, sir. You seem to be in a hurry to put off that file. I don't know why. You don't like that file or what?
I'm sorry. I have read it.
So many interesting facts are in these two orders. That's why.
Yes,
unless you don't want to share those facts with us.
No,
Tell us on this day, 1/11/2006, how many plots were you in possession of?
My lord, 46 and 48.
You are not in possession of 47.
Yes.
But you got a stay order for that.
No, 47 also I am in possession because that's an encroached plot.
Which is why I'm asking you repeatedly. So you encroached on 47.
Yes.
You encroached on 48 on this date when 1/11/2006. You are telling the court, ITCO. You are speaking for ITCO. You are saying ITCO is willing to execute a lease in my favor.
Yes.
So without a lease in your favor, you are occupying 3 plots.
Yes, that might.
1 minute, sir. 1 minute. 1 minute. Yes or no?
Yes. I humbly bow down before Lordship because I rushed to this honorable court with a prayer that ITCO may be directed to execute the lease deed. Even if I have made payments, I was ready and willing to make payments. ITCO was in obligation to execute the lease deed, and ITCO was not executing the lease deed. Therefore, I came before your Lordship, seeking a direction that ITCO should execute the lease deed.
So now, sir, 16 years later, what is the position? You are still in possession of 3 plots.
Yes, my lord, I'm as per.
No, same question, sir. Paradip Industrial Estate, correct? This is?
Yes, my lord.
What is the market value of 3 plots of this size? 46, 47, 48.
Right. Now I cannot say, my lord, but you.
No, we'll make you say it. No, we'll make you say it.
Market value.
No, we'll make you say it, sir. Not to worry.
Market
value. We'll pass this over. We'll pass over this matter. You ask your client to find out what the market value of these 3 plots are.
My right to get execution of the.
We'll come to all that, sir.
We'll crystallize in the year.
So we want to know the facts.
Crystallize in the way back in the year 2000, my lord, when I approached them for execution.
Mr. Panda,
now, my lord.
Mr. Panda, we are a writ court, okay? We are exercising jurisdiction under 226.
Yes, my lord.
1 minute, sir.
Equitable relief, my lord. I am
correct. You, for the first time in all your last 20 minutes, you have said the right expression.
That is a two-sword.
So you know that expression.
Two-edged sword, my lord.
No, do you know the expression you were taught in law college?
No, you are two-edged.
No, 1 minute. If you want equity, you must do equity.
Yes, my lord.
So please, sir, please ascertain the market value of these 3 plots. Please ascertain the current market value of these 3 plots.
Lordship may see that they are delay, a colossal delay they have, my lord, at the end of.
Sir, you went on getting stay orders from us. September you got a stay order. November, just see, you have not finished reading that. Again, that file, yes. You are very allergic to that file.
No, not all. I have already read it, my lord. I have already read it.
Read that first November order.
Yes. Now
we make it clear.
Yes. On prayer of the petitioner, this court, as an interim measure, directed that the petitioner may not be able.
No, the next order, sir, in that
next
same page.
Order. It appears that the petitioner in this case stated that the opposite parties are now ready and willing to execute the lease deed in respect of its possession over ITCO plot number 46 and 47 situated for the industry. At best, at 2006 rate, I am.
Read it.
We make it clear that the pendency of the writ petition will not be a bar for the ITCO to decides to execute the lease deed with.
So till date, no lease deed has been executed.
No.
So can you do this? Can we pass it over? You'll find out the current market value of 46, 47, and 48.
As it was prevailing in the year 2006.
Sir, that you cannot decide. Let's be very clear. Let's be very clear on this, Mr. Panda. Let's be very clear. When this court asks you to ascertain the market value, we are asking you to ascertain the market value as of today.
Not today, my lord, it will be not difficult. Because
no, we will know what is difficult and what is not. Because this is valuable land which you've encroached on for only 16 years.
Encroached because they have wanted me to regularize, my lord. They have stated that they are on payment, they will regularize.
Sir, you first find out the market value.
On payment, I made payment.
Mr. Panda, if you will simply record the fact that you refuse to answer the query of the court, you refuse to disclose the market value, we will simply dismiss the writ petition. That's all.
Market value, tomorrow your lordship may kindly fix.
No, sorry, sir. It's a one phone call away. We're not adjourning to tomorrow.
No, that may be correct because it has to be obtained from the competent authority.
Whatever. Sir, the competent authority is a real estate agent in Paradip Industrial Estate to tell you what the market value is.
Can you speculate?
Everybody knows, sir, what the market value is.
Market
We'll
value.
pass it over if you're interested.
My
If
lord.
you say, sir, I'm not interested in all that, we'll just dismiss the
Learned
repetition by
counsel for the
dictating in
IDCO
order.
is not present probably. Lord IDCO, learned counsel for the IDCO also.
So you are come before the court, you want relief from the court, you have to answer the questions of the
I
court.
have not yet submitted one relevant document, my lord, with your lordship. May I submit?
Yes, yes,
Annexure 11 at page 51.
yes,
They say that my unit was not operational.
right.
Now their report reveals that it was fully operational.
All the more, sir. So a fully operational unit encroached on 3 plots of 46, 47, 48 in Paradip Industrial Estate.
And
So we are passing it over, Mr. Panda.
General manager, that opinion that
We are passing it over. When we call it again, you will tell us the market value.
Competent authority recommended additional land above 5 acres, my lord, for expansion of my unit, my lord.
So you find out market value of 5 acres also. All right. Now that you've given us additional information.
In 2000.
Apart from 46, 47, 48, that other 5 acres also you find out the market value.
Record, my lord. Other 4 acres. They have
Whatever.
They are agreeable for 4
All
acres.
right. All right. Yes. Pass over.
Weekly list item number 8.
May I please, your lordship?
I file a short notes of argument.
Yes.
At what time, my lord, your lordship will take up this?
We can't say, sir, whenever your colleagues relieve of all of the other matters in the list, pass overs will be
After
called.
recess, my lord.
You keep watching the board, sir, you will know it.
Weekly list item number 8. My lord. I am for the petition on the sub item. Well, also may kindly take up the sub item first.
Yes.
The limited grievances lordship, the substantial question of law, when the reference was particularly made to decide whether the termination with effect from 2002 is legal and justified or not, can the learned tribunal go beyond to the terms of the reference? That is the sole question of lordship.
All right. What is the tribunal done?
The lordship tribunal while answering the reference.
1 minute. This shows the facts.
My lord. Second page, lordship. On 16 December 2002, in terms of the clause 31, subclause 1 of the certified standing order of the company, since the OP number was convicted in a criminal case, has been terminated from his employment. Your lordship, on basis of his application, he has received 7,08,542 towards his terminal dues, 12 funeral finance settlement dues. In 28th of October 2004, your lordship, the appropriate government has made the reference. The specific query is that whether the termination with effect from 16 December 2002 is legal and justified. If not, that is relevant for me, lordship. That is the whole point of argument. If not, to what reliefs Mr. entitled to? Lordship, on 23rd March 2006, order of acquittal was passed by the appellate authority. On basis of that, on 11th of July 2006, we have issued the reinstatement order subject to deposit of the amount. The lordship has a glass to the award.
Finish your list of dates, sir, first.
My lord.
Complete your list of dates.
Lordship. Then after receipt of the communication dated 11th of 7, 2006, when it has been directed to restatement of service with the direction that he has to deposit the terminal dues. Subsequently, on 13th of July 2006, your lordship, he has made a representation that he cannot deposit the call for amount. Your lordship, 24/8/2006, the award has been passed by the learned tribunal. Your lordship, while answering the reference at issue number 2, the learned tribunal observed that the termination is legal and justified in terms of the standing order. And while answering the issue number 3, traversing beyond to the terms of reference, has stated that after acquittal, from the date of acquittal to till his superannuation, he is entitled to service back.
Superannuation, sir.
My lord, he has superannuated already.
No.
May I please, your lordship?
Entitled to back wages means what?
Lordship,
from the date of acquittal
has already been died.
1 minute, sir. I'm still asking him some questions. Yes.
From the date of acquittal, your lordship, 23rd March 2006.
That's right. Till when? Back wages will be till when?
12/12/2002 to 22.
That has been
1 minute,
denied.
sir. I don't know why. I'm asking him some question. You just kindly be patient, sir. Yes.
My lord, the Honorable Tribunal has said that he is entitled to his back wages from 23rd March 2006. That is from
Till
the date
when
of
will you
acquittal.
pay those back wages, sir?
Well, sorry, I am unable.
When we use the expression back wages,
My lord.
till when will you pay that back wages?
I have paid the 17 B wages, Your Lordship.
Sir, if the tribunal has asked you to pay back wages from 23/3/2006,
Well,
till when, which date will you pay back wages?
no, I have not paid because reason that
We are just asking you a question, sir. Till when are you supposed to pay back wages? Till which date? From 23/3 till which date are you supposed to pay back wages?
I am supposed to pay on the date of, sorry, my lord, I am unable to get. He has superannuated 31st January 2007. I have paid 17 benefits for 2 months, Your Lordship. Only,
Sir, the back wages, you reinstated him on which date?
reinstated, Your Lordship, 11th of July 2006.
So back wages has to be paid from which date to which date?
23rd March 2006. That is the order back till the date of superannuation.
Not superannuation, sir. You already took him back in service.
He has already superannuated during pendency of the return in the year
No,
2007.
once you put him back in service, he must have joined service immediately.
He has not joined, Your Lordship.
Why?
He has not denied to join the service.
He has not denied to join, meaning
He was denied. Sorry.
I don't know. You put him back in service. That's what your list of dates says.
My lord.
So he joined service or didn't join service?
Not joined, Your Lordship.
Why?
Your Lordship has to see the representation. He submitted by the representation. Clarify that issue.
No. Because he did not pay that 7 lakhs, you did not allow him to join.
My lord.
So he superannuated within a few months after that.
My lord, few months.
So why are you pursuing this litigation? What is the monetary value of this litigation for you?
20,000 to 30,000.
20,000. For that you're fighting.
Substantial question of law.
Same. Substantial question of law will leave it open because the amount involved is so minimal. You see, since the amount involved as a result of implementation of the impugned award is not even around rupees 20,000, the court does not consider it appropriate to entertain the petition at this point in time. Leaving the questions of law open for consideration in some other appropriate case, the petition is disposed of.
Right.
What about the first matter?
First matter,
Lordship, I am appearing for the petition that since the petitioner has been died on 16/4/2009, the substitution petitioner has already been allowed, Lordship. That is 25/8/2009. Only my prayer is only to back wages. The period which he has been.
We are not entertaining their writ petition. Back wages
My
for
prayer
them.
only.
For which date?
He was convicted from.
No, that is not permissible. The current case law says it's not permissible at all. That back wages for the period you did not work is not permissible. That's what the current case law is.
Only prayer is only for back wages only.
No, that's not even permissible, sir. There is case law to that effect.
Lordship,
There is case law to that effect. Have you seen that? It's not even permissible.
The learned tribunal also dealt with the matter.
We just only last week we were shown this very judgment.
Lordship.
You see the prayer in the present petition that the petitioner should be paid back wages dating back to the date of his conviction bracket, which was subsequently converted into an acquittal bracket, is not entertainable in view of the judgment of the Supreme Court of India in Baldev Singh versus Union of India, AR 2006 SC 531. Petition is accordingly dismissed.
Weekly list item number 9.
Pray for next week, my lord.
No, we're not adjourning, sir.
My lord, the Mihir Malik, senior advocate, was the conducting lawyer. My lord, he died out of the infection of COVID-19 virus.
When did that happen, sir?
During my lord, the second wave, my lord, he died.
That is almost a year ago, sir.
My lord, file has been displaced. My lord, I pray for next week.
Then whenever you find the file, we revive it, sir.
Next week,
Answer to the petitioner states that the file has been misplaced. The petition is dismissed with liberty to the petitioner to revive the petition as and when the file is located. Yes.
My lord, next week, you will also make it. I will get that. My lord, next week, my lord. Don't dismiss, my lord.
Sorry, sir.
Because, my lord, this is what my memory goes, my lord. This is regarding the settlement.
You just revive it, sir. Whenever you find the file, you revive it.
Only
we are here only. We are not going anywhere. All restoration applications we normally allow the same day. provided you're ready to argue the matter. Yes.
My lord, I will be ready by next week, my lord. I will be ready.
So whenever, so next week, you first of all search for your file, all right?
My lord,
The day you find your file, 1 minute, the day you find your file, you draft an application. Then the next day you file the application, get it numbered. The day after that, you mention it for listing. All right. If you're ready to argue, we'll immediately restore and hear you. Yes. Call out the next one.
Well, I undertake that next week. I will. Well,
who's in item 10?
Interim order is there.
May I please, my lords?
Interim order is vacated. Yes.
Plus, this case, plus
Yes.
the petition of lordship is a non-banking financial institution, my lords. Plus,
Yes.
engaged in financing of commercial vehicles, my lords. Plus, what the petitioner does, my lords, he finances, my lords, commercial vehicles and gets some interest, and that is the subject matter of, my lords, levy of tax under the Orissa Sales Tax Act and also under that. Whereas the period for which your lordship is concerned in this writ petition is for, my lords, 2005-6. Your lordship, I take your lordship's attention, my lords, to the order dated 6/9/2007.
Mr. Sahu, this is an appealable order.
No, this is an appealable order because your lordship found that, my lords, this is contrary to, my lords, entry 54 list to beyond the scope of, my lords, to
We'll
levy tax.
continue that interim order, you go and appeal, sir. We'll continue that.
That's what has happened. There is a matter, my lords, what I am submitting your lordship, my lords. Today, your lordship have, my lords, WPC 68662. Tomorrow, in your lordship's board, my lords, there is a matter of this petitioner for the other period, 8661 of 2007 in item number 8.
All of that, you go to the tribunal only, sir. It's appealable.
That's what I'm submitting, because in that case, already counter rejoinder filed. And your
That's
lordship,
all right,
my lords,
sir.
the other case, my lords. That's what I am praying, your lordship, my lords.
Yes.
Your lordship, my lords, kindly take up this matter along with tomorrow's matter, so that matter only one single short point is involved. Your lordship, my lords, it is already a matter, my lords, which your lordship, they rely upon one judgment which is not at all applicable out and out, and the transaction is not at all amenable to, my lords, levy of tax. That your lordship, beyond, my
Who's
lords,
on the other side?
Department is
my
the
lords.
tax.
What I am submitting, yes. Tomorrow, item 8 is
No,
there.
let's see where Mr. Sunil Mishra is. Mr. Sunil
My
Mishra. Mr. Padi. You don't have the file.
Perhaps I missed the list, my lord, because name.
All right. Mr. Sahu, so Mr. Padi has missed the list today. So we'll list it tomorrow then.
Tomorrow, yes.
All right. List tomorrow.
Along with item number 8, yes. Fine. Obligation.
All right. All right.
Wiki list item 11. Wiki list item 11.
None appears. Dismiss not process.
Wiki list item number 12.
This matter, Miller, involves, Miller, this is a matter where the revisional orders under the OEA Act under section 38B as well as the order of the OEA collector are impugned. Miller, this matter, what I pray, in this case, senior advocate, Mr. Surya Sundar Das is engaged. But I had to make it ready. Though I have made the date chart ready, but this matter involves, just now my brother
Every time this matter comes up, my friend takes time on something or the other.
I am not obstructing. Let me complete.
Don't raise your voice, sir.
It is up to you to submit. I am placing before my Lord. My Lord, I had in the previous week COVID-like situation. Even now I can't stand. I don't want much time. Any day next week. Because this, just now my brother also supplied as many as 4 Supreme Court decisions. I have to go through and apply my mind. I can do justice to my client. And my senior advocate will argue.
There's an interim order against
I
her.
have to prepare.
When was that interim order passed?
Make it part.
Give us the date of the
next
interim
week.
order.
Miller, I don't want any interim order. I only want next week because I am not able to stand. How can I prepare for the senior advocate to argue? Even now, for Supreme Court decisions is supplied.
What date is the interim order? I'll just check their interim order.
Your Lordship may call it on, Lordship may call it
No,
on.
no, there is no interim order here.
No, there is no
No interim order, my lord.
Huh.
I also know today. My lord, only next week.
Every time, my lord, this odd matter comes on, my learned friend takes time on some plea or the
I
other.
am here. I undertake. I undertake.
Today he's
In the
saying he
name
can't
of
stand
God,
straight.
I will never take any time.
And this is
Let-
5 acres of land in Chandrasekharpur, right in the
I
heart
am
of
not able
Bhubaneswar. Your
to
Lordship has
stand.
seen that
Lord,
area.
I am not able to stand.
This is
Last
right
week I was bedridden.
near that Nalco corporate office, right in the heart of Bhubaneswar.
Sir, we can permit you to sit and argue. If that is the problem,
No.
you can even sit and argue.
I can see that.
Huh.
I do.
Please,
I
you
have
can sit and argue, sir. We have no problem.
My lord, I have-
Problem is only standing, no?
I could not apply my mind to the Supreme Court decisions. I have already-
He's supposed to be aware of the law. So Supreme Court decisions is.
So we'll impose costs, sir. What do you say?
Any
For adjournment?
Next week I don't pray any time. Any further time I will never pray, my lord. I undertake in the court of law. I am an officer of court. I can't state falsehood.
What we'll do is, you kindly sit down. He will just apprise us about the case, whatever the case is. We'll familiarize ourselves with the case.
My lord, I have prepared a written note.
Very
I am
good.
supplying.
Very good. And kindly sit, sir. We do not want you to be
No. If
suffering because you are standing.
If my brother does not allow me, then I have to do my part.
All right.
With much difficulty. I
Mr.
have
Palit
to
is
do my
appearing
part.
for opposite part number 3,
I'm
GA
specially
department.
engaged for the
He's
GA
special
department. The
engagement.
land is under our.
All right.
We are unable to.
So kindly sit, sir. Kindly sit. You can even put the mic close to you. You can sit and argue.
Miller.
Kindly sit and argue. No difficulty at all.
Miller, I can't argue.
No. We don't want you to be uncomfortable. You can pull the mic down, sir.
Miller.
Mr. Palit, you can help him with the mic.
Miller.
Kindly argue.
Miller, I am reading out the.
No problem, sir. No problem.
Miller.
Yes.
Miller, the revisional order dated 29/7/1995 of the Member Board of Revenue Orissa Cuttack, OP number 5 here, in dismissing the OEA revision case number 16 of 1994, exercising its jurisdiction under section 38B of the OEA Act, wide annexure 11, is impugned. And also, the original order dated 23/11/1983 of the OEA Collector Bhubaneswar in rejecting to settle the case land in favor of the petitioner, exercising the jurisdiction under section 8(1) of the OEA Act, wide annexure 4, is also impugned. Miller case property. Miller annexure, acre 0 decimal in Hal plot number 258 and Hal khata number 472 corresponding to Savik plot number 218 and Savik khata number 303/21 Mauja Chandrasekharpur Dist Cuttack, now Khurda, is the suit land, is the case property. Then Miller facts. Present petitioner is the widow of the original petitioner, that is her late husband Sri Daitari Mahanti. Miller, I have to submit that the present petitioner is also no more. She has died. And substituted. Her late husband Sri Daitari Mahanti, and thus is the legal representative of her husband. That Daitari Mahanti, the husband of the widow, a renowned freedom fighter, having both the central and state pension. Then Miller Jamabandi Khatiyan, which is a continuous ROR, Miller, under our Settlement Act, that is treated as record of rights in continuity. That is called Jamabandi Khatiyan, Miller, in our language, local. Permanent lease for agricultural purpose. This is Jamabandi Khatiyan of Kanika Estate. On 21/3/1944, Miller, in favor of permanent lease for agricultural purpose, in favor of said husband of Daitari, husband, namely Daitari Mahanti, by ex-Jamindar of Kanika Estate with respect to an area of 5 acres, 0 decimal in village Nuagaon, Mauja, Chandrasekharpur, Pragana, Patia, District, Cuttack, was leased out in favor of husband Millard of the widow petitioner on 21/3/1944 by virtue of Hattapata, which is a customary Millard in our customs. Previously, ex-Jamindar were issuing Hattapatas, which is as good as lease deed by Katina of decisions that is there. And that part I will, Millard, at that point of time, indicate right. Since 1944, that is the date of lease by Hattapata, tenant has been in continuous possession, raising various agricultural crops till date. Millard then rent to ex-intermediary by Annexure 2. Then Kanika Estate vested in the state on 27/12/1952. Then Millard tenant's ledger. This is an important Millard document. When Millard, I'm submitting out of note Millards with due respect. Millard, when the estate gets vested in the state, then the Jamindar has to do one thing. In respect of tenants under him, he has to file one document, that is the list of tenants before the state, that is called in our local language Ekpadya. Then the Jamindar has to file Ekpadya containing the list of all the tenants under him. Then, Millard, what the state is to do? Then our law says a tenant is a tenant, only he was being managed by the ex-intermediary, and after abolition of state, that is under the state. There is no Millard change in the status of the concerned tenant. And that is declared, Millard, under section 8(1) of the OEA Act. So 8(1) never contemplates any application to be filed or adjudication to be done in respect of tenants' tenancy rights. Because tenants are tenants, only the Estate Abolition Act does one thing, abolishes the intermediaryship. It has nothing to do with tenants' status, right, interest, etc. So tenants are tenants under the state. It will never change any their status. Only they will be treated tenants under the state and they will pay rent to the state. So that is the 8(1) declaration. And no application or adjudication is contemplated under the Act. Then I am reading from the note, Millard. Kanika Estate Gala. Pursuant, then Millard, on 27/12/1952, Kanika Estate vested in the state. Then tenant's ledger. I missed. After Ekpadya is filed, then tenant ledger, the Tahsil office opens a tenant's ledger, recording the tenant's name and in respect of particular land. That is state document. Tenant's ledger is the document of the state, Annexure 3. Pursuant to Ekpadya, as produced by the Jamindar, tenant's ledger opened and prepared in the name of tenant Rayat Daitari Mohanty in the office of the Tahsil Office Cuttack, bearing serial number 357 for the leased out area of 5 acres. In Sabik Khata number 303/21 of Mauja Chandrasekharpur, District Cuttack, fixing the rent of rupees 21/14 anna and cess of 12 anna 6 pies. Thus, by the above fixation of rent by the state government, the royalty right of the tenant has been recognized by the state. By virtue of this Annexure 3, which is an important document, that is tenant's ledger. Then a deemed tenant. That is what I was submitting 8(1) of the OEA Act. Next para. After coming into operation of the OEA Act 1951, Daitari Mohanty continued as a tenant stroke riot respecting agricultural leasehold land as before as declared under section 8(1) of the OEA Act, for which no application and no order is required in town. Then petition for acceptance filed by the tenant before the Tahsildar Cuttack for acceptance of rent as already fixed by the court. Then previously my client filed one application for acceptance of rent because
we've read your note completely. Meanwhile, we have completely read your note. We have now, in the meanwhile, we have completely read your note.
Oh, sorry.
We have already gone. You can sit in here, sir. You can sit in here.
Sorry.
Not a problem, sir. Sit. Kindly sit. Kindly sit. Kindly sit. Kindly sit. I'm audible to all of you, right? Sir, we have gone through your note. We have already read your note. All right. What it turns out is, till date, they have not accepted any rent from you, correct?
Exactly.
Although you've been trying to pay rent, they're not accepting it.
Accepting.
Meanwhile, the land is with the GA department. Meanwhile, this land is in the Bhubaneswar urban area. So those facts are now, can't change those facts.
No.
So if you have missed the bus because of that, you sue them for damages.
No.
In law, you can't be recognized now as a tenant.
No.
As a tenant pursuant to that, whatever,
that
tenant's ledger opened. All that stage is crossed.
To that, I am not completing, my lord, today, but I am just indicating because I am not well to.
No. He will indicate to us.
No.
We expect him to be fair.
Yes,
he
I
will
am
indicate
just
to us.
answering your lordship's query. Once a tenant, then a tenant.
No.
I am just answering.
That policy doesn't apply here, sir. These are statutory tenants.
Yes.
These are not actual tenants.
No.
These are deemed. See, there's something called atonement, right? In the normal civil law, there will be atonement.
Millard.
There is no atonement here. By statute, if you want an atonement, there has to be an actual act of accepting rent from you.
Millard, possibly I am not clear. Millard, what I am submitting, tenancy was there.
It wasn't there, sir.
Let me Millard, 2 lines. Let me the entire conception. Tenancy was there. OEA Act came. It abolished our tenancy status. Tenancy remained there. There is no change. I am just completing. Even though, why this happened, because what your lordship's query, why this situation change in situation happened? Because of the fact that no rent received from me, and I may be subject to correction by lordships. And despite my repeated request before both the Tahsildar, my rent was not accepted. Why not accepted, Millard? That is very pertinent. Because they said that it can't be settled in your name. The settlement of tenancy is a misconception. There is nothing of the sort. Tenancy right is never settled. It is there, it was there. It is only declared. May I pray next week? Any day. I will never take time.
Page 39, your lordship may kindly turn to the order.
Yes.
Of the member board revenue, page 39.
Yeah. Kindly sit down, sir. Kindly sit down.
The member board revenue has done a forensic audit of his documents. These are all, my lords, of the documents that is claiming title on. Lordship may turn to page 39.
Right.
Second para 2.
Yes.
The petitioner in this case is the village so and so, executed a permanent lease. The ex-intermediary, it's in his case.
Right.
The ex-intermediary executed a permanent lease of the suit land in favor of the petitioner through a patta on 21/3/44.
Right.
For the first time, his tenancy, so-called tenancy, comes into existence. Then, my lord, there is a complete silence. All kinds of bogus explanations has been given in the meantime. Then your lordship comes little below that, around 15 lines. For the first time, he files an application on 28/2/83.
Right.
Before the learned
additional Tahsildar.
And this is after 30 years. One. Then the member board revenue fines, your lordship may kindly turn to page, my lords, 8. I'm sorry, page 44, para 12. In this case, the petitioner has relied upon the patta. This is the, my lords, the condition of the patta. This is what the member board revenue finds about the patta. In this case, the petitioner has relied upon the patta dated 21/3/44 given by the ex-intermediary, the Raja of Kanika. The patta in original has been filed before me, and it is signed by a person whose signature has been deciphered as Swapaneshwar Rath by the learned OEA collector in his impugned order dated 23/12/1983. The petitioner has not proved who Swapaneshwar Rath was. He is not the ex-intermediary. He is somebody else. And if he was at all authorized by the ex-intermediary to give leases on his behalf, the petitioner has stated before the learned OEA collector, and it has been recorded by the learned OEA collector in his order, in the impugned order, that Swapaneshwar Rath was the Tahsildar of the Raja Kanika Raja. There is nothing on record to prove this. This is exactly, my lords, what my lords, has been meant by the Supreme Court collusion of lower level officials. This is exactly what the classic case being played out before your lordships. And then, my lords, the next paragraph your lordship will see, he has relied upon 2 rent receipts. These 2 rent receipts, this at paragraph 13 and paragraph 14, the petitioner has also relied upon 2 rent receipts. And then he goes on to explain how this is not true, not
reliable at all. Yeah.
Not probable at all. The petitioner has also relied upon 2 rent receipts. The first rent receipt is dated 21/3/44, the same date on which the alleged Hathpata was given. It has been mentioned that in the impugned order of the OEA collector that this rent receipt was for 1349 Sal. In this rent receipt, 4 years, 1346, 1347, 1348 and 1349 have been printed. And the figures of rent have been recorded against the years 1349. Thus, this rent receipt is dated 21/3/44, which shows the payment of rent in respect of 39 Sal. But 39 Sal corresponds to 1942, which is prior to the date of grant of lease. Now the second one is also in similar fashion, my lords. And so much for his tenancy ledger that he says that Ekpadya, that is the rent roll submitted by the ex-intermediary, and which is known as the term that is Ekpadya in our local terminology, my lords. That is the genesis for opening of a tenancy ledger in the Tahsil office. Now the member board revenue finds that none in the Tahsil office, not the Tahsildar, nobody has signed that tenancy ledger. Such an important entry. And also, my lords,
so the ledger being opened in his favor is not a fact.
And that has not been signed by anybody. And my lords, we have in our counter, the GA department has specifically pleaded that this land belonged to Anabadi. My lords, it was an Anabadi land, and Kisam was Judy jungle. Your lordship knows. And till my lords, this remained. Till my lords, this was in 1930-31. It was on 7/3/30-31 in the Sabik Khata. It was recorded as Kisam Jhuti jungle, and the plot was Anabadi plot, my lords. This remained so till my lords 1973, much after vesting. Till 73, my lords, the land continued to retain that character of an Anabadi Khata. Here, my lords, 2 Supreme Court judgments, they kick in. One is, my lords, Nityananda Satpathi's case, which states, your lordship, I have given it in that other case also.
Correct.
I relied upon that judgment.
Correct.
Anything recorded as Anabadi, my lords, I have also handed over citation. Lordship may kindly turn to second, third, fourth,
Yes.
Fourth flag.
Yeah, we have something.
This is the fourth flag, the pink one.
Yes.
Your lordship may kindly turn to page, this judgment. Para 6.
Yes.
Once a notification under section 3 of the act is issued, the lands of the intermediaries vested in the state of Orissa.
Yes.
Section 5 provides for the consequences of vesting of an estate in the state in terms whereof all the rights of the nature specified therein shall stand transferred to the state. As vesting takes place free from all encumbrances, the intermediaries cease to have any rights thereunder. The plot in question is admittedly being Anabadi land, must be deemed to have vested in the state government, subject to any rights which the intermediaries could have claimed thereon. Under section 5 of the act, the intermediaries, although might not have been physically dispossessed, but they would be deemed to go out of possession. It was open to the state to exercise its rights of possession. And then, my lords, it goes on section 7, provides for an exception for the ex-intermediaries to khas possession, 33 acres in khas possession, and section 8 also cultivating possession.
So on facts, he has not been able to establish that his tenancy continued.
No. And my lords, Fakir set his judgment, that is the third flag. Third flag also. Third flag. This one. This is another Supreme Court judgment, same, my lords,
right.
Land, Bhubaneswar land close by. Here, my lords, paragraph, my lords. Paragraph 15. In para 30 of the aforesaid report in state of Orissa versus Harapriya Bisoi in similar facts, the claim of cultivation of land recorded as Anabadi and Jhati Jungle, that is forest land, in the said case was negatived by this court on the plain logic that such a claim for cultivation can have no basis when the land is described in the revenue records as Jhati Jungle and also Anabadi, that is uncultivable.
So all these people claim
this
to
probably,
have,
my lords, finishes
so
this
this
case.
tenancy so-called is for agricultural purpose.
These are, my lords,
Oh, I see.
agriculture. And then, my lords,
So anyway, once it's included in urban area, that purpose goes.
that is also one more
So
extra.
that's large number of these cases.
And-
All these tenancies are for
Agriculture.
And, my lords, two more things, my lords, two more issues. One is that, my lords, that Sita Maharani versus Chedi Mahato, that Supreme Court decision 1955.
Right.
No title passes unless it's registered. Anything, an agricultural lease, my lords, here very nicely it has been described. Second flag, yellow flag. Second. This is the second flag, my lords. The lordship may kindly turn to the last page, that is para 13. Since it was the case of the respondents, same case as in the present one, that the settlement of the royalty interest with them has been reduced in writing, the hukumnama, it required registration. Since it was not registered, it is inadmissible and no evidence could be given as to its terms and contents of Exhibit D and could not be used for that purpose, particularly as the hukumnama and the receipts in support of it have been found to be not genuine. Same case as in the present, my lords. And this one has been, there's one more judgment, my lords, 2000, my lords, 1964 Patna, page 1, full bench.
Yes.
This here, my lords, I'll place that.
The last judgment.
My lords, last one. No.
That is an unregistered lease deed will not be admissible.
Yes.
All right.
No, It says that even though an agricultural lease can be unregistered, you can have an oral lease. But once such a lease is registered, once such a lease is reduced to a document, it needs registration. Agricultural lease.
Yes, sir.
So therefore, I don't think my learned friend has.
I will answer all the queries of my.
No, you can sit down, sir. You can sit down and answer it.
No,
You can sit down. No, you can sit and answer, sir. No problem.
Milord, I can't answer now.
No, you file a note, then, sir. Orders reserved. Counsel the petitioner is permitted to file a note of arguments.
Milord, 1 minute.
All right.
It will be.
Call out the next matter.
Milord.
Item number 13.
Milord, it will be
Yes.
injustice. Tomorrow, Milord.
One mallet.
Tomorrow.
My appearance will be noted for this.
Who is appearing for opposite part note 3? I am
GA department.
I'm for the.
Milord,
I'm for the GA department.
All right. No.
Is appearing as 13.
Yes.
tomorrow.
Sorry, sir. Sorry.
Milord,
You file a note. You file a note.
Then
You file a note, sir. File a note.
Passed over. Milord, but
No, sir.
today, after lunch, and passed over. Milord, it's not passed over.
All right, passed over. But we're not adjourning. Pass over. Pass over.
Passed over. I will.
Pass over.
Milord.
And after pass over, you can sit and argue. All right.
No,
You don't have to stand and argue.
Milord.
All right.
Yeah, it is passed over to after lunch.
It's passed over, sir.
Possible, sir.
We are unable to give you a precise time. You should pardon us. We cannot give you a precise time. It is only passed over.
Milord.
All right.
I will call the senior
Quickly list item
advocate
13.
engaged here. Because client has engaged this.
Who is in 13? None appears dismissed for non-prosecution. Yes.
Quick list item 14. Item number 14, quickly list.
None appears dismissed for non-prosecution.
Quickly list item 15.
May I please, Your Lordship? The petitioner management has challenged the award under Annexure 4, my lord.
Yes.
Starts from page 20, my lord.
Right.
May I read the schedule of preference, my lord, which is quoted in the award itself?
Yes.
Whether the termination of the service of Sri Babai Charan Jana, advertisement in charge, Samaj. Second, Gorang Charan Naik, electrical supervisor, Satyavadi Press. Third one is Umacharan Mishra, corrector, Satyavadi Press, and Sri Simant Kumar Singh, printing foreman cum supervisor. These are the 4 persons who have raised this dispute through the union before the learned court below, and it was adjudicated. And the subject of dispute was the age is 58 or 60, the age of superannuation. These 4 persons are not very well coming within the purview of working journalist. They are non-working, non-journalist. So during the process of adjudication, in one day the learned counsel who was arguing this matter and conducting the cases, he felt ill, for which they have filed this Annexure 1, the time petition, Annexure 1 and 3. And subsequently, when the same was rejected, they have preferred the writ application, and therein order was passed, which is quoted in page 6 of the writ application.
Yes.
It is dated 29/2/2008.
Yes.
As miscase in the second line, as an interim measures, further proceeding of ID case number 21 of 97 pending in the court of the learned presiding officer industrial tribunal shall be remained stayed for a period of 6 weeks. After getting this order, this was filed before the learned tribunal, but rejecting the said application, the award was passed on 26/2/2008, and it was sent for publication in the official gazette, that is 17. Here the point is, so far the 4 applicants is concerned, I mean to say workmen is concerned. In the meantime, the present status is, so far Babaji Parida and Srimanta Kumar Singh is during pendency of the same by virtue of Annexure 5. They have also withdrawn because since 58, in fact, it is applicable to them and they cannot extend for 6 years, though disputed. They have withdrawn the case and to that effect, Annexure 5, it is appended to this writ application matter. And in the meantime, so for the present status is concerned, out of 4 workmen, 3 of them have been expired. As yesterday I have gathered the information. Madam.
So who is the only person surviving?
The only person surviving is Srimanta Kumar Singh.
He must also cross 60 long ago.
How long ago, my lord? And he has withdrawn because 2 of them, out of the 4 applicants, 4 workmen, one Babaji Parida and Srimanta Kumar Singh, who is only one surviving in this workman person is, my lord. They have also withdrawn because 58 and they have got all their benefits so far the superannuation age 58 is concerned. And that apart, my lord.
So there is no stay here.
No, my lord.
Then what is the point in continuing with this petition?
My lord, only so far the benefit is concerned.
What will be
which has been given by the learned court below. My lord, one para in so, my lord.
All right.
43, my lord.
All right.
43. Kind of a glance to page 43.
Yes.
43, it is a gazette notification of that wage board, GK Sindhe wage board.
Right.
They are in 4.31. May I place it?
Non-journalist is 58 years.
Exactly. 58.
So
that
what?
point, they have been,
so what, sir? Now it will be a few thousand rupees. You say leaving the questions, it is pointed out that.
Lordship, I am appearing for the opposite.
All right, 1 minute, sir. We're not entertaining his petition at all.
My lord. Okay.
Of the 4 workmen involved, 3 are no longer alive. Even 1 has not pressed his claims.
2, my lord. 2
have not, but
2 out of 4, 2 persons are not pressing, namely Babaji Parida and Srimanta Kumar Singh.
2 of them, Babaji Charan Parida and Srimanta Kumar Singh, are not pressing their claims. The 2 remaining have expired.
3, my lord. In the minute,
that's what we dictated. So there are only 4, sir, of which 3 have expired.
Yes.
In fact, of the 4 workmen, it's only Srimanta Kumar Singh who is still alive, and he has not pressed his claim. In these facts, keeping the questions of law arising from the impugn award open for decision some other case, the petition is disposed of.
I am appearing for the opposite party. The issue has already been adjudicated by this honorable court. I am submitting the.
So we have disposed of the writ petition. We have not interfered with the award. You want any more relief?
No, my lord.
Weekly list item 16.
So far 58 is concerned, we have paid all the relief. What is available in Annexure 6.
That's okay.
That we have given so far the 58 years is concerned.
What remaining will be a few thousand, sir. That's nothing.
I filed the judgment that may be kindly noted.
We are not interfering. Yes.
Item number 16.
Enough to tomorrow I have to go through the decision.
Sir, no, not like this. We've already passed over. Sorry, sir. Kindly excuse us. Sorry.
Weekly list item 16.
Yes, my lord. May I please, my lord? My lord, in this case, in the year of 1979, the workman was working in a company, but he was placed under suspension, and thereafter the matter was settled. But in the year of 1994, again he was placed under suspension. My lord, page 6, in the paragraph 6 of my report. Only charge is that 1 rope was stolen by the workman. 1 rope. My lord, the petitioner workman was charge-sheeted by letter number 80 alleged that the theft of a roving cotton rope, which is known in the Odia. It is pertinent to mention here that in the said charge sheet, the petitioner workman was also charge-sheeted for misconduct of unauthorized absence, instigating co-worker not.
So now he's 63 years old. What will he get? He can't go back to work.
Well, perhaps the company has been closed in the meantime. I am not aware because of the.
Yes, it is closed.
Closed.
Then what is the point, sir? Let us not waste our time on this.
Just not the merit is
The workman would be 63 years old. The company in question is no longer operational. The court sees no point in continuing to entertain the present petition. It is disposed of. Yes.
Weekly list item note 17.
None appears dismissal on prosecution.
17. Matter has become infectious.
All right. Counsel for the petitioner states it's become infectious. It is supposed to.
Rita Singh.
Weekly list item 18.
Miller, London senior advocate has come. I have called him.
List item 18. Weekly list item number 18.
The petitioner challenged the order passed by the State Administrative Tribunal, my lord, in allowing my previous service 2 spells, my lord. The lordship, fact of the case is like this, my lord. The petitioner joined initially in the year 1958 as a laboratory assistant in SCS College, Puri, my lord. He was relieved from service on 17/3/2016 with the permission of the employer and joined as a laboratory assistant in the University College of Engineering, Burla. And since 1962 to 68, my lord, he is continued in the University College of Burla, my lord.
So what is his age now? 85?
Yes. 86. Tribunal is allowed 58 to 62, tribunal is allowed. So for 62 to 68 in the work rendered under the Burla College, that has not been allowed for the purpose of counting pension.
Want to still pursue all this, sir?
Because matter has already been decided, my lord.
Yes, yes.
By the tribunal as well by this honorable court, that past service should be counted for the purpose of pensionary benefit. Relying on Chandrasen's case and NN Swami's case, my lord.
Yes.
This tribunal has decided that past service, because initially, my lord, there was Bhadra College, Bargad College and Panchayat College. They were private college, my lord.
Well, it shows the reasoning in the impugned order
Yes,
that
ma'am.
this prayer has been refused.
Yes, my lord. Impugned order, my lord.
Para 10.
Yes, para 10, my lord. The court said, my lord, shall I read, my lord?
Yes, please.
The applicant admittedly served as the laboratory assistant in the University College of Engineering, Burla, under the administrative control of Utkal University during the period from 19/3/2062 to 11/5/68. The next question for consideration is whether the said period is to be counted for pension. Utkal University is an autonomous body. The Learned Council for the applicant has relied upon the provision made in Rule 44(3) of the pension rules in support of his contention that the period of service of the University College is to be counted towards pension. Rule 44(3) provides that an employee of an autonomous body on permanent absorption under the state government will have the option either to receive the CPA benefit which have accrued to him under the autonomous body and start service afresh under government, or to choose to count the service rendered by him under that body as qualifying service for pension under government by foregoing employer's share of CPA with interest thereon, which will be paid to the department concerned by the autonomous body. The explanation below, Rule 44(3) clarifies that the expression autonomous body includes a university. In the instant case, the appellant has not stated to have given option either to receive CPF benefit which accrued to him under the autonomous body and start the service afresh under the government, or to choose the count of service rendered by him under the body as qualifying service for pension under government. It is not his case that he had not received terminal benefits for his past service under the autonomous body, who is not implicated as a party to speak about him. In the aforesaid circumstances, Rule 44(3) of the pension rules will not be applicable to accept his cause that the period of service rendered by him under autonomous body will be counted for pension.
What is wrong with this reasoning, sir?
My lord, law is well settled, my lord, that the past service rendered in a private institution subsequently taken by government is also counted
Unless
for
you
the
opt,
pension.
you have to do several things for that. This is under the rule.
Yes, pension rule. That is under the pension rule.
No, but the rule requires you to indicate your preference whether CPF with interest will be paid or not. Who will play the employer's share? You have to make those options. You have to implement them. Somebody has to come and tell the court, yes, the man was working for us and he gave these options. It's not automatic. You say the challenge in the present petition is to an order dated 8 June 2005, passed by the Orissa Administrative Tribunal in OA number 2577 of 1999. Paragraph, by the impugned order, while the tribunal accepted the prayer of the petitioner that the service rendered by him under the government for the period 3rd July 1958 to 17th March 1962 will be counted towards qualifying service for the purposes of pension, it rejected his plea that the period during which he served as laboratory assistant in the University College of Engineering, Burla, under the administrative control of the Utkal University, from 19th March 1962 to 11th May 1968 should also be included. Paragraph. Counsel for the petitioner sought to make a grievance that the OAT was in error since Utkal University was an autonomous body, and once it was absorbed by the government, the service rendered therein should automatically qualify for the purposes of pension. Paragraph. Having perused the reasoning of the OAT in this regard, the court notes that there is a specific rule 44(3) of the pension rules, which provides that an employee of an autonomous body on permanent absorption under the government will have the option either to receive the CPF benefits that have been accrued to him under the autonomous body and start service afresh under the government, or choose to count the service rendered under that body as qualifying service for pension, foregoing the employer's share of the CPF with interest thereon, which will then be paid to the department concerned by the autonomous body. Paragraph. In the present case, the petitioner failed to state whether such an option was given at all. Further, the autonomous body was itself not impleaded as a party to speak about his having received terminal benefits for past service thereunder. Naturally, therefore, the OAT was unable to accede to the prayer for inclusion of the aforementioned period of service for purposes of pension. The court finds no legal error having been committed by the OAT. The petition is dismissed.
Weekly list item 19. This benefit has also not been given, extended to him because of the pendency of the writ application.
That you file another
58 to 62.
Right, sir. That you know what to do, sir. Yes.
19.
May I please, Your Lordship, my Lord, on behalf of S.K. Patnaik, the matter is infructuous.
All right. Counsel petition
Oblige, Your Lordship.
states that the petition has been rendered infructuous. Disposed of as such.
Weekly list item 20.
None appears. Dismissed on non-prosecution.
Weekly list item 21.
None appears. Dismissed on non-prosecution.
Weekly list item 22.
I may permit a withdraw, my lord.
Counsel, the petitioner seeks
With the liberty to approach the appropriate forum, my lord.
All right. Seeks leave to withdraw the present petition with liberty to approach the appropriate forum. Dismisses withdrawn with liberty straightforward.
Weekly list item 23.
23, my lord. It is a matter relating to grant of land order Jovan lease. And the matter has already been answered by the Honorable Supreme Court against me. The Honorable Supreme Court has said that limitation cannot be taken into account.
In view of the judgment of the Supreme Court dated 27 July 2017 in civil appeal numbers 9895-96 of 2017 bracket State of Orissa versus Malti Biswal, the present petition is dismissed.
Weekly list item 24.
Without recording my submission.
No, we have not recorded it.
Yes.
Weekly list item 24.
The impugned award passed by the learned CGIT being contrary to the direction given by this honorable court and perverse, deserves interference. And
This is item
24.
24.
My lord. Here the OP workman was dismissed, preceded by an inquiry where he was found guilty for impersonation and taking salary of another employee. So there was a departmental proceeding, and he being dismissed, there is an industrial dispute where he filed a claim statement raising the fairness of domestic inquiry issue. So rightly there was an issue to the said effect when as per the settled portion of law, an application was filed by the management. It was rejected to take up the said issue as a preliminary issue. That was rejected. So the management was being constrained to approach this honorable court. That previous order is at running page 8 of the writ application. May I be permitted to place it? My lord, got it?
Yes.
Running page 8. Order dated 2/1/2000. Hard learned counsel for the parties. Admittedly, the opposite party number 1 workman has already entered an appearance. The matter is taken up for final disposal. And as early as 1975, the Supreme Court in the case of the Cooper Engineering Limited appellant versus PP Munde, respondent AR 1975 SC 1900.
Went back to the tribunal for deciding the preliminary issue.
It was directed to take up it as a preliminary issue, and if it is answered against the management, to follow further principles decided by the apex court. So what the learned tribunal did,
yes,
that annexure 7, while answering that issue number 2, it finally passed the award without affording opportunity to the management to prove the case on merit. And your lordship, that finding also with regard to, your lordship may kindly have a glance to the impugned award at running page 48. There were 6 grounds to question the legality of the, fairness of the inquiry. 4 grounds were answered against the workmen. So far as ground number 5 and 6 at running page 48, those were erroneously answered against the management. My lord, I may be permitted to place it. Annex serial number at page 48.
Each for the workman. One Mr. Mahapatra was appearing long ago. Anyone appearing for the workman?
And after receiving notice from this honorable court, the workman also challenged the said award, praying therein to set aside the award and reinstate him with full back wages.
What happened to that?
That is also pending. It has come along with this writ application. Hello.
So who's appearing in that for the writ petitioner? Mr. Mahapatra's appearance seems to have been noted some time ago. You must know who's appearing.
My lord.
You will know who's appearing, sir. You must have received some.
This is a transfer brief, your lordship. In fact, after I read
the counter also filed.
Yes, but this is a transfer brief. After the brief was being transferred, after the sad demise of the previous learned senior counsel, this was never listed. So I have no knowledge as to who is appearing for the.
Mr. N. Mahapatra is appearing. But the award has been stayed.
Yes.
What does the award ask you to do?
Award was to re-inquiry into the matter afresh, de novo. And the workman will be deemed to be under suspension.
No, which means the preliminary issue is decided against you.
Yes. That was also erroneous. Contrary to the documents on record, and that being perverse, that has been rightly challenged before your lordship. And that is also perverse, being contrary to direction given by this honorable court.
How old is the workman now?
Now 50. And a criminal proceeding is also pending against him. And NBW has been issued since 2009. He is absconding.
Then you issue notice for a fresh inquiry. He won't turn up. That will be the end of the matter. Because this imputed award is innocuous. He basically asks you to hold a fresh inquiry.
Your lordship, that
is not been asked to be reinstated.
My lord,
suppose a second writ petition be dismissed for non-prosecution today. What have you to do? Only issue notice to him to come and appear in the inquiry.
My lord, that is contrary.
No reinstatement.
My lord, as your lordship knows, that is contrary to the settled portion of law. Law is well settled since 1965. Your lordship may kindly have a glance to that constitutional bench judgment, which has taken care of all the previous judgments pertaining to the said issue. And rightly this honorable court directed the learned CGIT that in the event, what I may be permitted to place.
No, but they have decided that preliminary issue only.
No, my lord.
Just let's come to the imperial order.
After deciding the preliminary issue, the law is that if it is answered against the management and management comes forward to lead evidence on merit, it has to be permitted so to substantiate the charges on merit. As if the labor court is the inquiry officer, he has to step into the shoes of as if he is the inquiry officer. And there is a deviation.
No. What has the labor court done, please? I think it's completely innocuous. Just come to para 12.
My lord. My lord. That last the effect.
All right, operative portion.
Yes. In view of the above, especially considering the charges to be more serious, I, instead of directing reinstatement of the disputant, direct the management to inquire into the matter afresh after giving full opportunity to the workman to defend himself in the proceeding to be started afresh. That the settled portion of law does not permit. So also the
No. Suppose they find your inquiry is not fair.
Yes.
What is the
I have to be given chance to prove the case on merit before the industrial adjudicator. That is the law.
You mean the workman succeeds in showing that the inquiry is not fair?
Yes.
He doesn't succeed.
No, my lord. With due respect, my answer would be no.
No.
My lord, your lords may kindly.
Procedurally, he succeeds in showing that the inquiry is not fair. He gets no relief.
My lord, may kindly have a glance to that judgment. Para 8. Law is settled since 1965. The issue before the Constitution bench was at what stage the management should pay so to prove the case on merit. Whether it should be at the initial stage or at any stage before the award is passed. Paragraph 8. Before we proceed to, my lord, what?
Yes.
Before we proceed to examine the question any further, it would be useful to bear in mind that the right of the management to lead evidence before the labor court or the industrial tribunal in justification of decision under consideration by such tribunal or court is not a statutory right. This is actually a procedure laid down by this court to avoid delay and multiplicity of proceeding in the disposal of disputes between the management and the workmen. So the genesis of this procedure, the umpteen number of judgments, your lordship, on this issue. What should be the procedure? And ultimately, the it was held in the said judgment that it can be at any stage. The majority view was
No. I think come to para 17.
My lord.
So they're basically accepting the procedure in Shambhunath Goel.
Keeping in mind, your lordship, that para 17. Keeping in mind the object of providing an opportunity to the management to adduce evidence before the tribunal level court, we are of the opinion that the direction issued by this court in Shambhunath Goel's case need not be varied, being just and fair. There can be no complaint from the management side for this procedure because this opportunity of leading evidence is being sought by the management only as an alternative. We paid that, your lordship, and that being rejected, the correctness of the said order was tested before this honorable court. And this honorable court specifically directed you decide that issue first, and if it is answered against the management, we need to have been given chance to prove the case on merit.
No. If it is answered against the management, the worker gets no relief. What is this? I don't understand this.
My lord, worker ultimately, if the award is passed on merit, then only the workman is entitled to get the relief.
No. So on merits, if you show that he is correctly dismissed,
yes.
So irrespective of procedure being fair, the dismissal will be upheld.
Yes.
Then what is the whole exercise of proving that the domestic inquiry was unfair and having it decided as a preliminary issue? Only to completely deny any benefit to the workman. It makes no sense, sir.
My lord, that is the law, your lord.
No.
My lord,
I think you're mistaken there.
No, my lord.
Yes.
My lord.
You're mistaken there. Please read para 17.
My lord, before that, there are other paragraphs pertaining to the said issue. And the majority view was the question before the Honorable Apex Court Constitutional Bench was at what stage such a prayer has to be made by
Sir,
the
it can
body.
never be that after the workman proves that the domestic inquiry is unfair, no relief will be granted to him. What is the purpose of framing that as a preliminary issue, directing the labor court to decide it as a preliminary issue? In fact, the labor court has done the right thing here. It has not reinstated him. It has merely asked you to place him under suspension, asked you to complete the domestic inquiry.
But I may be permitted to place that Apex Court judgment, Your Lordship. There are few paragraphs.
In fact, we are permitting you. I don't know why you are saying permit me, permit me. We are asking you to read it. You are still not reading it.
Paragraph 8. First, I would like to. Paragraph 1. Why it was referred to larger bench?
There's conflict of decision, sir. You don't have to read that.
Yes. Then paragraph 8. Before we proceed to examine this question as any further, it would be useful to bear in mind that the right of a management to lead evidence before the labor court or the industrial tribunal in justification of decision under the consideration by such tribunal or court is not a statutory right. This is actually a procedure laid down by this court to avoid delay and multiplicity of proceedings in the disposal of disputes between the management and the workmen. The genesis of this procedure can be traced by noting the following observations of this court in Workmen of Motipur Sugar Factory, Pipe Limited versus Motipur, reported in so and so, where it has been quoted. It is the first judgment on this issue. Thereafter, it was followed a number of judgments. If it is held that in case where the employer dismisses his employee without holding any inquiry, the dismissal must be set aside by the industrial tribunal only on that ground, it would inevitably mean that the employer will immediately proceed to hold the inquiry and pass an order dismissing the employee once again. In that case, another industrial dispute would arise and the employer would be entitled to rely upon the inquiry which he had held in the meantime. This course would mean delay, and on the second occasion, it will entitle the employer to claim the benefit of domestic inquiry given. On the other hand, if in such cases the employer is given an opportunity to justify the impugned dismissal on the merits of his case being considered by the tribunal for itself, and that clearly would be to the benefit of the employee. That is why this court has consistently held that if the domestic inquiry is irregular, invalid, or improper, the tribunal may give an opportunity to the employer to prove his case, and in doing so, the tribunal tries the merit itself. So this principle,
it's all ultimately to benefit the employee,
yes,
not the employer. Come to the Shambhunath Goyal's observation, para 3. You will now understand the context.
My lord.
The rights which the employer has in law to adduce additional evidence.
My lord.
This additional evidence is only for showing that the inquiry was fair, not the evidence in merit, sir.
My lord, there are other judges, even Shambhunath Goyal's case also. I have not brought that judgment.
No, you now read in para 15.
The rights which the employer has in law to adduce.
You come to para 15.
Para 3, I am placing, your worship. The rights which the employer has in law to adduce additional evidence in the proceeding before the labor court or industrial tribunal, either under section 10 or section 33 of the Industrial Dispute Act, questioning the legality of the order terminating the service, must be availed by the employer by making a proper request at the time when it files its statement of claim or written statement, or makes an application seeking either permission to take certain action or seeking approval action taken by it. So here, rightly we filed an application seeking such a leave, and that being rejected, the correctness of the same was tested before this honorable court, and this honorable court's observation has been quoted in para running page 8. I may be permitted to...
You read it, sir. When you started your arguments, you read that whole thing. And that's how we came here.
But the concluding para of that order. In view of the above, the impugned orders under Annex 4 and 6 passed by the tribunal are quashed, and the matter is remitted back to the presiding officer, Central Government Industrial Tribunal, come Labour Court, Bhubaneswar, to take up issue number 2 as preliminary issue and record his findings thereon, and thereafter to proceed in accordance with guidelines framed by Apex Court in so and so.
Correct.
So thereafter he did not. That is contemptuous also. In the honorable...
Sir, what is the Apex Court's guidelines? We are coming to that again and again. You are not reading it. Unfortunately, you are not reading this judgment.
I have your lordship and
Where if you don't want to read paras 15, 17, we will not compel you to read.
No, madam.
Because you want to selectively read what you want to
No,
read.
madam, I'm placing it. As your lordship, this is I'm placing. Should I place annexer para 15, your lordship?
Yes, we've been asking you to do that, and then don't again ask for permission for para 17.
I'm sorry.
We're hoping that someday you'll come to para 17.
I'm sorry. I should not misunderstand.
Ha.
The question again arose in the case of Shambhunath Goel's case as to the propriety of waiting till the preliminary issue was decided to give an opportunity to the management to address evidence. Because after decision in the preliminary issue on the validity of domestic inquiry, either way, there is nothing much left to be decided thereafter. Therefore, in Shambhunath Goel's
So have you
case,
understood this context therefore?
Madam.
So the management says you have to do it in a sequence.
Therefore,
right? First decide whether the inquiry was fair.
My lord.
Then go into merits. This is what the management repeatedly says.
Yes.
This is why this law is developed like this.
My lord.
But if you've in fact got the court to decide the preliminary issue,
My lord.
this exercise is not necessary because that issue itself will answer whether the inquiry is fair or not. You have to give a management a chance to correct that. It's the other way around. This sequence, you came to this court, you got it remanded.
Madam.
You got it remanded saying decide this preliminary issue first.
My lord.
What does decision means? Once a decision is arrived at, that decision has to be implemented, sir.
That decision.
Here, the labor court decided, at your instance, they decided that preliminary issue separately.
My lord.
They decided against you.
My lord.
But did not grant him relief, saying they are giving you one more chance to hold an inquiry. What more can you ask?
It should have been. It should have
What
been.
more can you ask? You are saying, forget whether I held the inquiry rightly or wrongly. I must still go and, have you uphold my termination. That's an absurd argument.
My lord, that is the law, your lord.
No, it is not the law, sir. I'm sorry to say it is not the law. It's a wrong reading by you of the law. That's not the law. This para 15 tells you that is not the law.
Thereafter, I may be permitted.
You can read whichever. That is not the law.
In this judgment, the court, after discussing the earlier case, including Shankar Chakrabarti versus Britannia, this court reported in so and so, which was the judgment of this court. Subsequent to that of Cooper Engineering Supra, the following principles were laid down. We think that the application of the money to seek the permission of the labor court or industrial tribunal.
So it is the other way around, sir. So in the preliminary question,
my lord,
suppose the management succeeds.
Yes.
The management proceeds to lead evidence.
No, my lord. My answer would be the second, my lord. The answer to
you completely misunderstood what the judgment is.
Then the scope of leading further evidence is squeezed only to the limit of the quantum of punishment.
No, the management says, sir, sorry, sir.
My lord.
You have to see it from both sides. It's not only about the management succeeding, right?
My lord.
If the employee is given a chance to show that the inquiry was unfair,
my lord,
right? Suppose he fails, he should still be given a chance to say on merits I should not have been dismissed. Correct?
It is either way, your lordship. even the management fails to prove that inquiry is not fair.
What else remains? What else remains?
The management.
What else remains, sir?
Management should be given chance to prove the case on merit. That is the law.
So once the procedure itself is unfair, then what remains? In fact, they should have just stopped it then and there. If the procedure fails, everything fails.
And apart from this, also on merit, so far as finding of the.
Suppose it was a hire and fire case. All right.
It is not a case of hire and fire.
Anyway, if you don't want to engage with the court like this, we will not compel you. When the court starts the question saying suppose, and you say no, forget it.
I'm sorry.
You argue with yourself, sir. You are not. I don't think you are in a frame of mind to engage on a legal issue. Yes.
My lord, even on merit also.
Yes.
With regard to finding of the learned tribunal.
Yes.
Your lordship's interference is required, being that finding being perverse. Your lordship may kindly have a glance to that finding.
Just refusing to read. Advantage to workman. It will put to notice the fact that I am likely to do fresh evidence. The rebuttal evidence to read. Therefore, eliminates the delay likely in permitting the magistrate to make a belated application.
My lord, running page 48.
You don't want to read that para 17.
My lord.
I expected you will not read it.
My lord, I will read.
That's why I told you in the beginning itself. You should read para 17. You'll understand this entire thing.
Well,
What context it has been said.
keeping in mind the object of providing an opportunity to the management to adduce evidence before the tribunal of the labor court, we are of the opinion that the directions issued by this court in Shambhunath Goel's case need not be varied, being just and fair. There can be no complaint from the management side for this procedure because this opportunity of leading evidence is being sought by the management only as an alternative plea and not as an admission of illegality of its domestic inquiry. At the same time, it is also advantage to the workmen in as much as they will be put to notice of the fact that the management likely to adduce fresh evidence. Hence, they can keep their rebuttal or other evidence ready. This procedure also eliminates the likely delay in permitting the management to make belated application whereby the proceedings before the Labour Court of the Tribunal could get prolonged. In our opinion, the procedure laid down in Shambhunath Goel's case is just and fair.
Correct.
Yes.
So if right at the beginning, if you prepare to lead full evidence, it is up to you to lead that full evidence. But if you insist, no, I want only the preliminary issue to be decided first, which is what you did here. You came to this court, you got that award set aside saying, ask him to decide the preliminary issue first.
Not award, Your Lordship, that was an interim order.
All right. But you wanted him to decide that preliminary issue first.
Because our application was rejected.
So having therefore gone to that route, you have to take that to its logical end. Anyway, we're not with you on this, sir. We've heard you long enough now.
My Lord, this also, on merit also,
no question of merit, sir.
I would like to satisfy Your Lordship that finding is also.
So we are going to give effect. We agree with the tribunal that once the inquiry was held to be unfair, in fact, the tribunal need not have given you one more chance to hold an inquiry. If they've done it, we won't interfere with that. You say this is the second round of litigation at the instance of the management.
My Lord, that finding of the tribunal, may I be permitted to place it to satisfy Your Lordship that it doesn't deserve any kind of it deserves interference by this honorable court.
No, sir. We've gone through it. We've heard you at length on that. This is the second round of litigation at the instance of the management. Full stop. Agreed in the initial round, agreed by the award on merits against it by the Labour Court. The management came to this court with petition civil.
It was an interim order.
All right, interim award. All right.
Interim order rejecting our application.
All right, sir. All right. 9927 of 2007. In which an order was passed on 2nd January 2008, setting aside the said interim order and remanding the matter to the tribunal. Open condition to take up issue number 2 as preliminary issue and record his findings thereon, and thereafter to proceed in accordance with the guidelines framed by the Apex Court. In the case of the Cooper Engineering Company Limited, versus Sri P.P. Munde, 1975 2 LLJ 379, bracket SC. Paragraph. As a result of the above order, the Labour Court, the tribunal on remand took up the preliminary issue first, that is the fairness of the domestic inquiry held by the management prior to dismissal of the workman. Full stop. In the impugned award dated 18/12/2008, the tribunal came to the conclusion that the domestic inquiry was not fairly held. The reasoning was as under. Reproduce the whole of para 12 paragraph. Mr. S.K. Mishra, learned counsel for the petitioner, insisted that the tribunal had erred in not proceeding with the merits of the matter by permitting the management to adduce evidence on merits. And asking that a fresh inquiry should be held. According to him, this is contrary to the decision of the Supreme Court of India in Karnataka State Road Transport Corporation versus Lakshmi Devamma, AIR 2001 SC 2090. Paragraph, this court has carefully perused the said judgment. Full stop. In interpreting the decision in Cooper Engineering Limited versus Munde, the Supreme Court in Karnataka State Road Transport Corporation, Supra, observed as under in para 14, reproduce para 14. It then discussed the decision of the Supreme Court in Shambhunath Goel versus Bank of Baroda, 1983, 2 LLJ 415 bracket SC, where the Supreme Court observed as under. It then reiterated the principles in Shambhunath Goel, where after discussing the above decisions in Cooper Engineering and the Supra and the earlier cases, it was explained as under C to C. Finally, in Karnataka State Road Transport Corporation, summarizing the above position, it was held in para 17 as under D to D. Paragraph. As the court understands it, the above procedure was to balance the rights of both the employer and the workman. Full stop. If the employer succeeded in showing that the domestic inquiry was fair, that would not bring matters to an end, since it would still have to show that the dismissal on merits was sustainable. Full stop. It was with this in view that it was observed that the management should be permitted to lead evidence right at the beginning, both on the question of the fairness of the domestic inquiry as well as on the merits of the dismissal. Full stop. Conversely, if the workman was able to show that the domestic inquiry itself was unfair, then the consequences had to flow without again waiting for the entire merits of the dismissal to be gone into. Full stop. In effect, therefore, evidence had to be led at one stage and not at several stages. Paragraph. In the present case, the submission of Mr. Mishra that notwithstanding the management having failed on the preliminary issue, no benefit should be granted to the workman, and that the management should still be permitted to lead evidence on merits is based on a misconception of what the Supreme Court has held in all the above decisions. Full stop. It can never be that with a clear procedural infraction in the domestic inquiry, the workman will still get no relief whatsoever as a result thereof. That is not what the judgments in Shambhunath Singh Supra, approved by the Supreme Court, reaffirmed by the Supreme Court in Karnataka State Road Transport Corporation, says. Paragraph. In the present case, the management itself came to this court and insisted that the fairness of the domestic inquiry should be decided as a preliminary issue. And accepting that plea, this court remanded the matter to the Labour Court. Full stop. Having not succeeded at the issue on remand before the Labour Court, the management cannot insist that the said order should not be given effect to, and that it should still be permitted to lead evidence on merits. Full stop. The court therefore rejects that argument. Paragraph. In the impugned award, the Labour Court has proceeded, the tribunal has proceeded to give the management another chance at setting right the legal error of an unfair domestic inquiry by permitting it to hold an inquiry afresh by placing the workman under suspension. Full stop. The court, since this is at the instance of the management, the court is not inclined to interfere with the said relief given to it in the present petition. Full stop. In other words, the impugned order of the tribunal does not call for any interference. The petition is dismissed.
Oh,
The interim order stands vacated. Right.
The other writ application that is there.
The second one is dismissed for non-prosecution.
List item 25.
The impugned order is at Annexure 10, page 79. The impugned operative person is at page 82, paragraph 5.
I may be allowed to submit a note giving the latest position.
Let's page 82, paragraph 5. May I please, ma'am?
Yes.
Thus, while the applicant cannot make his preference between two contract appointments to be the basis of adjudication, the main burden of his grievance would lie on in the prospect of regularization. That can be taken care of as discussed by ensuring that the applicant's years of service in the WASH department as well as the service rendered by him in the PR department are taken into account for the purpose of placing him in the list of persons to consider him.
So both the contractual appointments, they say added together and treated as for the purpose of regulation.
Regulation, but while directing for regulation, they have relied upon the office memorandum, which is not applicable to the junior engineers. They have relied upon the circular, which is applicable to the NMR workers.
Oh, what is he? What is it?
I have given your lordship. I kindly turn to
before
order number 5
begins. May I place what are the impediments in implementing this judgment? Your lordship, kind turn to page 7. Page 7 of the
report.
report.
What have we done? We granted a stay.
No, my lord.
No, my
lords have
Order number, we're just asking him if you do not mind.
My lords have refused to grant any stay. So, your lordship, may I pray?
So, did you implement the order?
My lord, can I just?
Your lordship, kind turn to page 7. In view of the impediment,
your lordship allows me 2 minutes.
Sir, we'll allow you more than 2 minutes, but you only have to wait for your turn. That's all.
Your lordship, kind turn to page 7. The 15th line from the top towards right side, the line starts with if his claim.
Yes.
If his claim for contractual appointment in WASH department is acceded to, similar claims would be advanced by other contractual appointees in sister departments and it will give rise to unwarranted administrative inconvenience. Furthermore, well, this is the impediment. So may I pray you, Lord, since this order was passed in the year 2008 and in the meantime, so 13 years have elapsed. So your Lordship may kindly observe that this order shall not be treated as a precedent in respect of other employees.
All right.
Your Lordship may kindly look at what I have submitted.
He said something in your favor. Did you listen to him?
No, I have, my lord, I
My
was
lord, my
taken
lord,
into
may-
contractual service. Thereafter, I was regularized. Thereafter, I was taken into the permanent service. Thereafter, I have already been promoted.
He says, don't interfere with the order.
No, I have no objection.
Then please sit down.
My
Let
lord,
us dictate
I have
the
no
order.
objection.
My lord, I have my intervention application also over there at flag E.
We are not entertaining this kind of a matter intervention, sir.
My lord,
We are not entertaining interventions in this kind of a matter. You see, counsel for appearing for the petitioner state submits that in view of the fact that no stay was granted of the impugned order of the tribunal for over 13 years now, and in view of the subsequent developments, the only relief that is being prayed for is that the impugned order, while not being interfered with, should
My
not be considered to be
statement
a precedent
may
for
not be
other
recorded.
cases.
Well, my submissions may not be recorded. Your Lordship may dispose of accordingly.
Now you are saying you actually submitted that. All right, having heard learned counsel petitioner and noticing that the impugned order has not been stayed with this court and has in fact been implemented in the meanwhile, the court directs that this is disinclined to interfere with the impugned order. So how it is clarified that the order will be treated as being special, peculiar to the facts and circumstances of the case of the opposite parties and will not constitute a precedent. The petition is disposed of.
We will item 26. Item number 26.
May I please, your Lordship? Here, my lords. The award of the Learned Tribunal has been challenged, right? Annex of 7, my lords.
Yes.
Here, the background of the case, my lords. This petitioner is a trade union, my lords. You know, there is an Oswald chemical fertilizers has been established in the year 97 at Paradip. And my lords, thereafter in 2005 to 6, the management has been transferred to IFCO, my lords. Accordingly, IFCO has been made a party. And this union, there are 182 employees. They are working, they are the members of this union. They were working under OP number 2, my lords. That is contractor Bhagavan Parida, my lords. They have been disengaged. And thereafter, my lords, the reference has been issued by the government. And I would place my lordship. That is, Annexure 7 is the impugned order, my lords. That is the schedule of reference, that is page 60.
Sir, in the last 11 years,
my lords, there is last 11 years.
What has happened, sir?
I have no instruction now. What is the status of this workers?
Then we can't help you, sir. Who's for the management?
Well, I am applying for the opposition 3 and 4. But the specific finding by the Learned.
No. What is the factual position in the last 11 years?
21 years, my
12 years, sorry. 2009.
12 years. 9 is the.
Right. In the last 12 years, what has happened?
Nothing happened.
Lordship may give me 2 weeks time.
Kindly see just one finding by the Learned Tribunal. The entire picture will be clear. Kindly come to page 71. And only for 2 minutes. 71. The finding of the Learned Tribunal. Page 71 is sooner 1. It is not disputed that the workers who are employed by the contractor Bhagavan Parida, both the management and the workmen have admitted this effect. The management asserted that the workers left the services voluntarily and there was no retracement. So the burden lies on the management to prove that the workmen left the job voluntarily. In the decision reported so and so, their lordship held that the burden of proving that he voluntarily left the services then falls on the applicant one management. Management witness 1, the contractor deposed that all the workers who are working under him and exhibit A is the work order and exhibit B is the labor license. He used to supply the laborers as per need. The laborers left job voluntarily when the management took steps to reduce the work and they went on strike without giving a notice. There was a conciliation proceeding before the labor commissioner, but by that time he was not doing any work. The management agreed to employ the workman. After conciliation, he called the workmen to join their duty and issued notice accordingly. Exhibit C is the notice. When the workman failed to join, he intimated the DLO under Exhibit E, and he again also issued the notice. And Exhibit F is the notice. But the workman did not join. Management witness number 1 was subject to cross-examination, but nothing was elicited from him to check his veracity. Exhibit B, the license reveals that he was permitted to employ 183 laborers, even if for the sake of argument, it is held that he has no license. Then as per the contract labor so and so, the contractor and the principal employer can be prosecuted, but the status of the workman remains unaffected. Exhibit C and F are the notices issued by the contractor requiring the workmen to join their duties. And Exhibit E and F reveals that only 7 workers joined the work. So the evidence of management witness number 1 receives support from the documentary evidence, which shows that the workers voluntarily left the service and failed to resume their work in spite of notices. This version of the management witness number 1 also receives support from the admission made by workman witness number 1, who admitted in his cross-examination that from 20 to 2001 they went on strike, and till now they have not joined. Whereas in chief, he deposed that on 24 to 2021.
The question I'm asking you is not answered here. In the last 12 years, what has happened? That is what I've been asking him. I'm asking you.
My lord,
give me 1 week time at least.
No, we're not giving you time.
My lord, as it is, as per this order, they have nobody had turned up and nobody has been given.
There's no question of now putting you back in some contractual work, sir.
I hope, my lords, because they might have some working there. At least give me 1 week time, my lords.
No.
I'll find out.
No, we're not giving you any time, sir. Sorry. We're not adjourning the matter.
Because, my lord, so far this finding is perverse, my lord, because that is not based on facts, my lords. What is the finding of the Law and Tribunal I am placing before your lordship?
All right.
That is Annexure C, your lordship may see.
Yes.
What my learned friend is submitting, Annexure C, that is in Orissa, my lords.
Right.
Annexure C, they said that they have been directed to join the duty, but they didn't go.
Right.
That is their stand.
Right.
Your Honor, Lordship, you see that is dated 29/2001. That is Exhibit C. That is in Orissa. Here, this notice has never been sent to neither the union nor to the workmen. This notice issued only to Labor Commissioner Bhubaneswar, DLC, DLO. If they say that they have issued notice to the workmen to join the duty, absolutely this notice is no more that it is not issued to the management, it is issued to the labor union or the workers. There are 182 workers. What this finding is that totally against the finding fact of the case. So
your own witnesses admitted that you are on strike. Just see this paragraph.
Yes, that is that witness. He says that we are on strike. That is not disputed. But the date when they retrenched, what they say, just I am placing before your honor, that is the WS filed by Oswald Chemicals. That is OP number 4. OP number 4. They have filed a WS before the tribunal. What they say, base 44. My lords, page 44. That is paragraph 5.
Yes.
This is that is the Oswald Chemicals and Fertilizers OP number 4. 5. That in the regard to item 1 of the schedule of reference, it is humbly submitted that the first party management number 2, Messrs. Bhagavan Parida was a labor supply contractor under the first party management number 1, that is Messrs. Oswald Chemicals Limited, Paradip, and was supplying the laborers for various miscellaneous jobs in the DAP and the PAP departments of the principal employer, Messrs. Oswald Chemicals, Paradip. He was issued with the work order for supply of laborers to work with the above 2 departments for 89 days, which was extended time to time up to February 2001. And accordingly, the contractor engaged 124 unskilled laborers in a DAP plant.
This is your case, this is not the finding. This is what your case was. But when you led
My case,
evidence,
we
you would not
should
prove this.
give some compensation because this is a retirement. We have not issued any
Not
notice.
retirement, sir. You claim it to be
This is a
retrenchment.
This is a
There's a
termination.
different concept. You were claiming you were retrenched, not retired.
No, termination. This is a termination.
So it's not retirement.
No, sorry. This is, my lords, this is a termination.
Termination by the contractor, not by the principal employer.
No, this is the termination by contractor.
And the contractor says you refuse to turn up for work because you were on strike.
No evidence, my lord.
There is evidence, your own evidence. This is the whole problem. You're not reading the portion. See the portion which you are supposed to read, which is against you.
Document is there, my lords. Annexure C is there.
All right.
Annexure C is there. That doesn't speak that is.
When witnesses come before a court and speak, what should the court do about that?
The witness. I would place before your lordship. That is the.
Please come to page.
Your lordship, I would like to draw your lordship's attention.
Please come to page 72, sir.
Page 72, my lords.
Middle. So the evidence of MW1. Please read from there.
That is left the job voluntarily, my lords.
There is a sentence beginning so, comma, the evidence of MW1, about 10 lines from the top, sir.
So, right. So the evidence of MW1 received support from the documentary evidence which shows that the workers voluntarily left the service and failed to resume their work in spite of it. This is a totally.
Sir, please continue reading if you do not mind.
What he says, this version of MW1 also received support from the admission made by
WW1. W means what? Workers witness.
Who submitted in his cross-examination that from 14 to 2001 they went on strike and till now they have not joined, whereas in chief he deposed that on 24 to 2001 they were retrenched from service. If admittedly from 14 to 2001 the workers were on strike, they had not joined, the question of retrenchment on 24 to 2001 doesn't arise, and this admission clearly shows the worker left the job. My lords, purely because this finding is clearly, my lord, that is annexure C, because that is not been issued to the management, that is the trade union.
Continue reading. Continue reading.
Next, my lords, WW1 deposed that they were engaged by the Oswald through contractors Bhagwan Parida and Nirmal Swami, and they were performing their work and getting ₹50 per day. There was a strike on 14 to 2001 following dismissal of 18 workmen, but on 17 to 2001, the strike was called off, and again on 44 to 2001, the services of all the workmen were terminated without any notice. WW2 deposed that he was working under the contractor in the Oswald factory. There was a high-level meeting between the minister, commissioner, and collector, and it was decided to re-employ the workers. As already discussed, WW1 contradicted his own version by admitting that on 14 to 2001 they were on strike. The version of WW number 2 that there was a settlement and the management agreed to re-employ the workers as per Exhibit 7 does not receive the support from Exhibit 7 itself. Under Exhibit 7, the DLO was directed to prepare a list and to submit it to the authority for re-deployment. Nowhere under Exhibit 7, the management agreed to re-employ the workers. As the workmen voluntarily left the service and refused to join, they are not entitled. So for this Exhibit 7 matters, I am placing that Exhibit 7 matters. Exhibit 7, that is the agreement. I have stated my writ application. So Lordship, my lord, page 14, my lords, of my writ application.
If the entire evidence of MW1 is revealed that Exhibit C, the notice dated 29/2001, had been issued to LC, DLC, and DLO, and personal manager of OCLF, only which is supported by Exhibit D. But the Exhibit C has never been issued to Union as claimed by MW1. Paragraph 15, that on conjoint reading of paragraph para 13E, C and D of minutes of the high-level meeting held on 26/10/2002, Exhibit 7 makes it clear that management OCFL agreed to give priority in the matter of engagement of BCN contract laborers, except who are deployed in construction works. It is really unfortunate to say how the Learning Tribunal took the view that Exhibit 7 does not speak that. The management did
These are
not
all your
agree to-
repetition submissions. All right.
My lord.
Thank you, sir. The repetition is dismissed. We'll pass it.
Yesterday.
Yesterday, that matter, judicial service matter, which has been, judgment has been reserved. But today I'm filing the list of citations.
All right.
Weekly list item number 27.
27, I am for the opposite party, number 1.
None appears. This is not possible.
Weekly list item number 28.
This case may kindly be listed along with the read appeal number 127 of 2010 and 128 of 2010. All the three WA arises out of a common judgment passed by the single judge, my lord.
What is that judgment? Let's see this. Then this order will cover those two writ appeals. Let us see what is this.
All the original documents are available in the WN 127 of 2010. All the original documents are original judgments.
Tell us what the matter is about, sir.
The read person was dismissed on the ground of limitation.
So that's all. We don't need any documents for that. You convince us it is not, it's a bad order. Tell us what is wrong with the impugned order, sir.
Annex 1, my lord.
Let's read it.
Page 15, my lord. May kindly see. Page 15, ordering portion at page 19, my lord.
Yeah.
7/4/2010. Had the Lord Council for the petitioner and the Lord Council for the opposite party number 3A to 3G. In this batch read person, the petitioners assess the combined judgment passed by the commissioner consultation in revision case number so and so, and the combined order was passed on 27/10/2019. The certificate of the order input was delivered and as appeared from the last page of the certificate copy on Annex 1 on 29/2006. Thereafter, the read person has been filed on 6/2/2008. Thus, it is evident that the read person have been filed after delay of more than 17 years. In Virendra Chaudhary versus Bharat Petroleum Corporation and others, 2009, Volume 1, CLR SC 294, the Honorable Appeals Court has held that although there is no period of limitation provided for filing of a read person under Article 226 of Constitution of India, ordinarily read person should be filed within a reasonable time. A discretionary duration under Article 26.
So come to para 11 of your writ appeal. That is your explanation now. Para 11 of your writ appeal, internal page 10 of your writ appeal. Para 11.
Read appeal.
Para 11 of your writ appeal, internal page 10.
That it is submitted that with penance of the revision cases before the Lord Commissioner, the person.
Sorry to interrupt you. Para 11 of your writ appeal. You have filed a writ appeal, sir.
Read appeal.
130 of 2010. Writ appeal 130/2010. Para 11. Just show the paper book. Sir, we are giving you a paper book of your own appeal. You can read it from there. No. Kindly read para 11, sir.
That it is submitted that the appellant had filed the read persons on 6/2008 after the expiry of 17 years. The appellant had submitted the read person that during penance of the revision cases before the Lord Commissioner, they are fully depending upon the response number 4A and 4B. And the response number 4A, 4B, they are the proper defendants, my lord.
Whatever.
To defend their cases, who are assured them to defend their case in proper manner. But it is unfortunate to say neither the defendant the case of the prisoners properly nor intimated them about disposal of the revision persons by the Lord Commissioners on 27/10/2019. by which order Law and Commissioner was pleased to set aside the order passed by the Law and Deputy Director and orders passed by the consultation officer. The appellants had abhorred just before filing the petition. They only came to know from the villagers opposite party about disposal of the cases.
All right.
Thereafter, they filed the petition for session.
Noted the other two
The order
referees
passed by
mentioned.
the Law and
Take it
Commissioner.
on board and that's what's. Yes, sir.
My lord. And S1 or 4A, 4B were the pro forma opposite party of the in the lower court, my lord. They are the pro forma, not the contest opposite party. My humble submission is that refusing to condemn below can result in a meritorious matter being thrown out at the very threshold, the cause of justice being defeated. As against when relay condemn, the highest that can happen is that a cause would be decided on merits after hearing of the parties, my lord. So, my lord, that deed petition involves a bunch of records, my lord. That was not heard only on this ground, though it was admitted. So, my lord, this was reported in this judgment.
No. So the explanation. Sir, are you able to hear me?
Here, the 87 Supreme Court, 1353.
Are you able to hear us? Are you able to hear us? Are we able to hear you or not?
Minor? No, minor, no, minor.
You're not able to hear us?
No, minor.
Subuchina nahi? It's not audible. Now it's audible.
Just now I heard.
It's audible. You have offered the explanation in para 11 only.
My lord.
That is the explanation you have offered.
My lord.
You say this appeal is directed against an order dated 7th April 2010, passed by the learned single judge, dismissing writ petition, a bunch of writ petitions, including WP Civil number 1982 of 2008, out of which the present writ appeal arises. In the said writ petition, challenge was raised to an order to a common judgment dated 27th October 2010, passed by the learned Commissioner Consolidation Orissa in certain revision cases. Full stop. The writ petition has been dismissed by the impugned order of the learned single judge on the ground of delay in laches. It is noted in the impugned order that delay is more than 17 years and that there was no satisfactory explanation for the inordinate delay. Paragraph. Counsel for the appellant argued that dismissal of the writ petitions at the threshold on the ground of limitation would deprive the appellants of an opportunity to remedy a wrong, and therefore it was obligatory for the learned single judge to have further examined the writ petition on merits as well. Paragraph. This court is unable to agree with the above submission. Full stop. In fact, by way of providing an explanation for the inordinate delay of 17 years in approaching the learned single judge, the appellants have offered the following explanation in para 11 of the writ appeal. It set out the whole of para 11. The court is not at all satisfied that the above explanation is either reasonable or convincing. Full stop. The court finds no error having been committed by the learned single judge in dismissing the writ petition on the ground of laches. The appeal is dismissed. The other two writ appeals taken up by special notice in view of the order passed today in writ appeal number 130 of 2010.
127 of 10.
What was that, sir? 127 and
127 of 2010
Ha,
and 128 of 2010.
ha. These appeals are also dismissed. Call it in its matter.
Quickly, item number 29.
Sir, sir, in this case, kindly, I am in virtual, my lord. Pradipta
No.
Kumar-
Tell us what the matter is about.
My lord, my name may be recorded. Pradipta Kumar Mahanti, senior advocate. I am
Yes.
engaged.
Yeah.
And the threshold, my lord, this NESCO on my oral prayer, your lordship kindly substitute a TPNODL.
Okay.
It has come from 1/4/21 and this NESCO has been vested with
All
TPNODL.
right. At the oral request of Mr. Mohanty, learned senior counsel for the petitioner, the petitioner is substituted by Tata North Orissa.
TPNODL. That is Tata Power, TPNODL.
North Orissa Distribution Limited. Tata Power North Orissa Distribution Limited. Yes, sir.
My
Yes,
lord,
tell us.
here, my lord, I am in a humiliating position. Your lordship, I know that your lordship may ask the question, but this order of GRF is under challenge, and this, my lord, I don't know the history, and this is an order, and the case is in nutshell is that for the traction line for Jakhopura railway, that was taken, power supply was given, that is for 6,000 MVA initially.
Yes.
Then thereafter it was enhanced up to 13 kVA.
Yes.
13 kVA, and your lordship will find ultimately the deposit was made, that your lordship can find in page 23. 2 crores, lordship kindly see page 23.
Yes.
My lord, this is the second agreement after enhancement up to 13,000 kVA.
Right.
They deposit, lordship kindly see this clause 3, the quantum of supply, subject to the provisions hereinafter contained, and during the continuance of this agreement, the licensee represented by the engineer shall supply the consumer, and the consumer shall take from the licensee a supply up to but not exceeding contract demand of 13,000 kVA. Then lordship kindly clause 5, security deposit. The consumer pursuant to the ORC distribution condition code 2004 has made security deposit of 2 crores 37 lakhs, so and so is the total amount. And in the spreading over previous year.
Anyway, all that the GRF has asked is for you to adjust the amount from here.
Adjustment that, my lord, exactly what your lordship rightly pointed out. Regulation 22B says that there cannot be any refund. Only adjustment can be done for the subsequent review being made for the security deposit. So that aspect has not been considered. So in the spreading over these years.
So these are railways. No heavens are not going to fall if you comply with this order.
Only
These are the railways, sir.
Pardon, Lord?
These are the railways. Your
Railway.
opposite side of the railways.
Railway.
They're not some individual consumers. They're not going to go away anywhere.
No,
You
that
get
I
all
am
your
not
dues.
saying. I am not saying. But so far 22B is concerned, that has not been considered. In the meanwhile, for the subsequent years on review, that can be adjusted. There is no question of review refund. There is no provisions under the code also. So that aspect only lordship I beg to submit. In the meanwhile, that must have been, if that can be sorted out with the railway for the adjustment if there is any excess payment on the security deposit.
So there's no need to interfere, sir. Having heard learned senior counsel for the petitioner, the court is of the view that the
only that
directions
observation may
issued
be made below.
by the GRF do not call for interference. The petition is dismissed.
Only, my lord, my contention 22B has not been taken into consideration.
No, it's
There
okay,
is
sir.
no question of refund.
All right.
Only adjustment. That lordship may kindly permit that adjustment. We can do that with that observation. That I beg to. Well,
I think the GRF has asked you to only adjust. It has not asked you to do anything else. The same thing the GRF has asked you. Yes.
That your lordship may clarify, my lord, that is not there. That will create problem.
No, the GRF actually says you can adjust.
To refund, the lordship kindly see page 38. We therefore direct the opposite party to refund and or adjust. That only lordship say. Refund question does
Once
not
it says /adjust means what? Yes.
Weekly list item number 30.
None appears for the petitioner. Dismissal, non-prosecution.
Weekly list item 31.
None appears, dismissal, non-prosecution.
On behalf of CDA matter.
All right.
Mr. Mahapatra, name of Mr. Mahapatra.
All right.
Weekly list item 32.
Petitioner challenges the notice under Annexure 6 demanding the petitioner to deposit rupees 350 into 35 in respect of shop room.
Some 350 per month. Why are you fighting all this?
No, it is not the property of the DT. It is
Sorry?
State government property. The property in question is state government. The civil suit is pending, second appeal is pending before my lords regarding title. And how can the petitioner be directed to deposit the rent to the DT? And DT is not the owner. And the opposite party is the executive.
You can't pay 350 a month. What is the shop you're having? What is the shop you're having? You're not able to pay 350 a month.
Yes, ma'am.
What are you running? What is this? What is this?
Confectionery business.
Sorry?
Confectionery business.
What business?
Confectionery business.
Confectionery.
Confectionery business.
You can't earn, you're not earning 350 rupees a month.
Can I say, because this property.
They're not sitting here in 226 to interfere with 350 rupees a month payment.
That due to DT.
That's true.
That
That's
is
what.
that. Another aspect, my lord, my title, what the case land is pending for my lords.
All right. That will be considered separately. You say the court is not inclined to interfere with the impugned order.
No, subject to result of the second appeal, my lord.
Oh. Dated 25th January 2010 of the Commissioner of Endowments, right? No, Sub-Collector Executive Officer Anandapur requiring the petitioner to pay 350 rupees per month to the deity for running a confectionery shop. The writ petition is dismissed. What's this connected RSA?
That is second appeal pending regarding title. The petitioner claimed title over the suit land.
So this you can't come in a civil suit, no?
No, civil suit is regarding the title on adverse person.
No, can you maintain a civil suit after the Ochari Act?
He is claiming that I am in adverse possession in respect of the DT's property.
Because it is not DT property, the property of the government. It is recorded in the name of the government by the Annexure 1.
Let us see the appellate order. What is wrong with it?
I have not heard the.
No, then we simply dismiss it.
I held no power in that case.
Then it's okay. None appears for the appellate.
No, my lord, let it come next week. I will satisfy my second appeal.
We are not adjourning it, sir.
Next week.
We are not adjourning it. Sorry.
Second appeal may be called next week.
Sorry.
Satisfy my lord.
No, we are not adjourning it.
Then my lord,
You either argue it today or we are not adjourning it. Yes.
Second appeal cannot have.
Sorry, sir. Sorry.
That is for reference. It has a come. The second appeal. Because it is connected matter, that's why it has come.
No, it's okay, sir.
That's why next week is going to come. I will argue my lord.
You anyway have not filed your wakalatnama in this? In RS 421, have you filed your wakalatnama?
No, man, I have.
If you have not, you then don't make a submissions.
No, because they are connected matter, I undertake to argue my lord.
No. That's not how it works.
I will file my wakalatama.
No. We are not adjourning it, sir. Sorry.
Second appeal, how can I argue this?
Don't. You ask for restoration whenever you're ready. You say none appears, dismiss for non-prosecution. Yes.
Weekly list item 33.
Right, please, Your Lordship. Your Lordship, the order of the Labour Court deciding an entitlement in favor of the workman and directing the petitioner who is not the employer to pay, that is under challenge, Your Lordship.
Yes.
Your Lordship, this Lordship may come to, there are 3 to 4 dates, Your Lordship.
Yes.
I'm sorry that I have not been able to provide a chart, Your Lordship. But 1997, Your Lordship, there was a subsidiary unit of this petitioner company that was as GESW, Your Lordship, General Electric Scientific Works, Your Lordship. That was transferred to GESCO, that is a company, Your Lordship. That is at page 3 of the writ petition, which I have stated. Then, Your Lordship, it became a non-revival zone company. So the company was closed on 11/6/1998, Your Lordship.
Yes.
Then on 17/6/1998, the statutory dues of the respondent number 1, who was the workman under that GESCO, that was paid, which is at Annexure 1, Your Lordship. May kindly have a glance.
Who's appearing of the workman here?
None has appeared, Your Lordship.
No, have they been served? One
Lal
Lal Train Samantray.
I'm sorry, Mr. L. Samantray, Lalat Samantray.
Lalat, where is he?
Yes. Today I saw him in the court of
he is in the government panel, so we can't appear, my lords. Kindly the matter be taken up tomorrow. He will interest someone, my lords.
Yes.
Or a counsel for the opposite party workman is supposed to be now in the government panel.
Yes.
Time is sought for making alternative arrangement. List on 22nd March.
Obliged, lords.
Weekly item number 34.
None appears this one. You are in 34.
I have appeared for OP number 3.
None appears to the petitioner dismissal not possible.
Weekly item number 35.
May I please, Your Lordship?
None appears. Yes, Mr. Mishra.
May I please, Your Lordship? My lord, a DT's property section 19 application was filed for permission before the land commissioner for permission to sell on the ground that the land is not useful. It is in occupation of the petitioner since last 8 to 10 years prior to the making the application, and therefore it was sought to be sold at the rate of rupees 1,50,000 per acre. Now, on this application, the learned commissioner considered, and learned commissioner decided that it should be sold at the rate of rupees 1,65,000 per acre, and the mango tree that was existing on the land were also valued at rupees 1,000 per tree. At this juncture, I humbly beg to clarify one thing. Now, these lands are in front of the residential houses of the respective petitioners, which leads to the road. So that is the only passage on which they can come to the road. They have no other alternative passage. Fact means permission was granted to sell. However, a suo motu revision was initiated by the May I proceed, madam?
Yes.
Now, a revision was initiated. In revision, the amount was enhanced to 2 lakhs per acre, and it was directed that within 2 months we should deposit the amount in question. My lord, we deposited the amount within 2 months. That will be evident from the fact that the executive officer opposite party number 3 also has furnished a list where we have deposited. After deposit of the amount, the sale deed was not executed by the executive officer. As a result of which, an explanation was sought for by the assistant commissioner of endowment from the executive officer as to why, despite the order of the original authority, namely commissioner of endowment, and revisional authority, namely the opposite party number 1, the sale deed has not been executed. Then an application was filed by the executive officer seeking for permission for extension before the learned commissioner of endowment. That came to be rejected. A revision was preferred. Now, subsequently, the petitioners realized since the revisional authority had fixed the time limit, a miscase was filed for extension of time. That miscase has been rejected, which is being impugned in this writ petition. Previously, the order of the commissioner not extending was also challenged in a writ petition, but that was not entertained. Now, under Annex 2, I may be pardoned, that is in Orissa. I am extremely sorry I have not given a translated copy. I was called upon either to vacate or to purchase the land in question at the market rate, because now the value has increased manifold. That is also being challenged in this writ petition, that is Annex 2. Now, what has happened, your lordship will kindly see, so far as the execution of the deed is concerned, it is evident that because of the laches of the learned executive officer, the sub-collector opposite party number 3, the sale deed has not been executed, and he himself filed an application for an extension of time, which came to be rejected. And also, my lord, he was also asked to explain why he has not executed. All these things reveals that because of the negligence on the part of the authority, the sale deeds could not be executed in the favor of the petitioners. But one more thing I beg to humbly submit it for your lordship's kind consideration is that fact remains, my lord, these lands are in front of the land of the petitioner. Way back prior to 91, the executive officer said that they were possessing the land from 8 to 10 years prior to 91, that is almost from the year 1980, and it is the only space leading to the road. So what I humbly beg to submit subject to your lordship's kind consideration is that they have deposited the amount also in 3691. That amount, if it is accounted for these 30 years, and also if I am asked to also pay at a reasonable market rate, whatever, my lord, your lordship will consider. This is my submission for your lordship's kind consideration. Because that is what, if I am permitted to just explain, which is written in Orissa at page 16 of the writ petition, उक्त जगह वर्तमान बजार दर रे किनिबा निमते इच्छुक अथवा 7 दिन भितरे निम्न सरकारी कार्यालय रे दरखास्त करंतु किबा उक्त जगह दखल 15 दिन भितरे छाड़ी दियंतु. That means either if you are interested to execute the sell deed within a period of 7 days at the present market value, you do it. Otherwise, you vacate the land in question. Even today, my lord, I have taken instruction, my lord, that the petitioners are also ready to take it at the market value. The only thing that they are praying for your lordship's kind consideration is the amount they have deposited way back in 1991 also may be proportionately valued as it would be today, because it is with the parties. It has been deposit has been made and deposit is not in dispute, but an explanation was sought for from opposite party number 3 as to why the sell deeds were not executed despite deposit being made. So this is my submission for your lordship's kind consideration, because if that land is also, because they have said that it is not useful for the DT, and that is why application was filed by the executive officer for transfer. My lord, what I humbly beg to submit, if the land is not given to the petitioners, they will have no pathway to go to the road also. And they are in occupation, and they have also extensions of their houses over this land in question. So keeping in view this position, I humbly pay your lordship may consider this submission of mine.
No, but you'll have to pay the market value, sir. This is
that I have to. I have nothing to dispute. But what I humbly beg to submit, my deposit that was made in
no, so the impugned order asks you to do that only.
My only thing I beg to submit, my deposit that was made in 91 also may be proportionately calculated to this date so as to, my lord, deduct that. That much I am
They'll
paying.
adjust whatever you've paid, they'll adjust, but you'll have to pay the remaining.
I have to pay the remaining, but that amount is lying with them since 91.
That's okay. How much interest should it earn? Some 4% it will earn, nothing more.
And one more thing I beg to point out, as a matter of regularizing the brief, my lord, I'll pay the market rate. I humbly, my lord, I bow down to your lordship's, my lord, observation. I only pray.
Then there's no need to question the impugned order at all, sir. If you're prepared to pay market rate, that's the end of the matter.
I will pay, my lord. Your lordship may direct a time limit. I will pay, my lord. Let them fix the market value.
Mr. On instruction states that the petitioner is prepared to pay the current market value for the property in question. In that view of the matter, the impugned order does not call for any interference. It only is clarified that amounts already paid by the petitioner will be, yes, will be adjusted against the amount calculated by the opposite parties while communicating the amount, calculated the basis of the present market value, to be paid by the petitioner. The communication be sent to him not later than 21st March 2022, and the date of payment will not be beyond 25th April 2022. It is made clear that the petitioner does not make payment within that the aforementioned time of the sum to be calculated and communicated to him by the opposite parties. The opposite parties will then proceed in accordance with law. Right.
I'm deeply obliged. As a matter of regularization, may I just point out one thing, my lord?
Yes.
Petition number 4.
All the substitution applications are allowed. Yes.
And so far as petition number 1 is concerned, I couldn't file. The legal heirs will approach, my lord, the authority.
All
that lords may clarify.
The legal heirs of petition number 1, whose statute have expired, are permitted to approach the opposite parties for the above purpose.
Right. Deeply obliged, man. Deeply obliged.
Weekly list item 36.
For the opposite party. 36. 36.
My lord, I am for the petition.
Yes, tell us.
My lord, this is a single bench matter. My lord. I pray it may be listed before the assigned bench.
Single judge, is it?
Challenge the award of the EPF tribunal rejecting the appeal on the penal damages levied.
Single judge matter. All right. List before the roster bench of the single judge on 14 March.
Weekly list item 37.
May I please, your lordship?
Yes.
In this matter, my lords may kindly see the order dated 15/7/2021, wherein my lordship directed to release this matter after the disposal of the full bench judgment.
That's not come out yet.
No, my lords.
All right, awaiting the judgment of the full bench. This on 2nd May.
List item 38.
May I pray your lordship, my appearance may kindly be noted in item 37.
All right.
38, may I please, your lordships? The matter will be taken up along with WPC number 698 of 2010, my lords. In the meanwhile, we will entrust the matter to some other council, my lords.
No.
Mr. Samantray cannot appear, my lords, in this case. He is a government advocate, my lords.
All right. Council petitioner seeks and is granted time to make alternative arrangements before the next date. List on 16th March.
Yes, sir.
Wiki list item 39.
None appears dismissed. Not.
Wiki list item 40.
Item 40, may I please your lordship?
None appears dismissed. Not.
Wiki list item 41.
My lord, item 40, my lord, I am appearing. Item 40, my lord.
40.
Yes.
My lord, item 40, the order of the industrial tribunal is under challenge at Annexure P.
Yes.
The industrial tribunal has directed reinstatement of the workmen with 50% of the back wages.
Right.
My lord, the case was that he was given intermittent appointments for 2 years and there is substantial break. The findings is at page 11, my lord, your lordship may kindly see. The intermittent appointments were from 14/6/93 to 6/9/93, and then, my lord, after almost 1 month later, 11/10/93 to 9/12/93, and likewise from time to time until 8/2/95. So there is no continuous appointment, my lord. Even a superficial break is also not there. There is a substantial break. The tribunal says, my lord, paragraph 8. It is true that the workman was not given continuous employment, but the appointment was intermittent with little gap.
You have to read the earlier paragraph, sir.
My lord, paragraph 7 I am placing, my lord. In its written statement, it has been admitted by the management that the workman was given 85 days engagement as a helper from 16/3/93, and on expiry of the same, he was again given appointment for another 85 days from 14/6/93 to 6/9/93, and from 11/10/93 to 9/12/93, and likewise from time to time up till 8/2/95. Exhibit 1, 1 by 1, 4 and 5 are few such appointment letters which were issued to the workman. These do not disclose that the engagement was contractual in nature or it was against a particular job. On a reading of these letters, appears that though the workman was given periodical engagement for 85 days, 60 days, etc., he was allowed to be governed by the certified standing order of the management company. Besides, he was also allowed to enjoy all perquisites and amenities of the company except living accommodation. Exhibit 2 and 2 by 1, the bonus payment statement show that he was given a personal S number so and so and was also being paid bonus every year. These thus indicate that in the garb of tenure appointment, the workman was issued appointment letters.
So it's very clear, sir. Therefore, you gave artificial breaks.
Your lordship may kindly see
for 300 plus days.
The last appointment order, your lordship may say see at Annexure 1. It is against a leave vacancy. Annexure 1, page 8.
So the fact remains, it's a factual finding.
This is an expert.
Yes, worked for 308 days, sir. You are not going to sit and appeal over that factual finding.
My humble submission in view of Annexure 1, it is against a leave vacancy. No substantive appointment was given to him.
You see, the challenge in the present petition is to an award dated 30th March 2009, passed by the Central Government Judicial Tribunal, come Labour Court, Bhubaneswar, bracket Tribunal, in TR Industrial Dispute Case number 125, 2001. Paragraph, the following issue is referred to the Tribunal for Adjudication. Sorry, to the, Tribunal for Adjudication. Take from the top of page 10, question. The stand of the management was that the workman was only periodically engaged and did not complete the requisite criteria of minimum days of work. In the written statement, it was admitted by the management that the workman worked for 85 days from 16 March 1993, again worked for 85 days from 14 June 93 to 6 September 93, then again from 11th October to 9 December 1993, and thereafter from time to time till 8 February 1996. Full stop. It is this that persuaded the tribunal to hold that refusal to employ the claimant from 9/2/1995 onwards without retrenchment compensation would be violative of Section 25 capital F of the Industrial Disputes Act 1947. Paragraph. The tribunal has rightly rejected the plea about the workman not having been continuously employed. Full stop. However, it was noticed that the re-employment was with artificial breaks. Paragraph. Having heard learned counsel the petitioner and having perused the impugned award, the court finds it suffers from no legal infirmity. Full stop. Indeed, the finding that the requirement of Section 25 capital F of the Industrial Disputes Act 1947 was not complied with, has not been able to be satisfactorily countered by the petitioner. Stop. In the circumstances, the relief granted by the tribunal of reinstatement with 50% back wages does not appear to suffer from any legal infirmity. The petition is dismissed.
Weekly item 41.
And therefore the workman in that case.
All right. None appears. Dismissed for non-prosecution.
Weekly list item 42.
This is award passed by the Pure Labor Court, Sambalpur, Millard. The reference was made by the government under Section 10 that whether the Lordship kindly turn to page 38, whether the termination of services of Sri Rabindra Gadia daily wage labor by way of refusal of employment with effect from September 2005 by the management of Hirakud Power System Orissa Hydropower Corporation Limited, Kurla District, Sambalpur is legal and are justified. If not, what relief the workman is entitled to? Miller, the contention of the management is that he was never a employee, he was never a workman under the Chiplima hydroelectric project, Miller, and he was never engaged and not a single scrap of paper has been filed by him.
Let's read the order.
Miller, the award is after
page 38 it starts.
Miller, the award has been passed that the reference is answered on contest, but without any cost. The termination of service of Sri Rabindra Gadia daily wage labor by way of refusal of employment with effect.
So where are you reading? Where are you reading?
Miller, page 47.
Sir, award. I asked you to read page 38 onwards, sir. Come to para 9 if you don't mind.
Miller.
Page 43.
Yes, page 43. As per scheduled question, whether the termination of the service of Sri Rabindra Gadia daily wage labor by way of refusal of employment with effect from September 2005 by the management of Hiragun Power System Orissa Hydropower Corporation Limited, Kurla December is legal or justified. If not, what relief the workman is entitled to? The workman filed some documents which are marked as Exhibit 1 Exhibit 7. Exhibit 1 is the Xerox copy of temporary pass. Exhibit 2 is the Xerox copy of, of the application dated 5/4/99 filed by the workman Ravindra Gadia. Exhibit 3 is the application filed by the workman Ravindra Gadia on dated 7/8/2007, addressing to the Honorable Minister Sri Jai Narayan Mishra, Commerce and Transport and Labour and Employment Department, Government of Orissa. Exhibit 4 is the certificate issued by the Assistant Engineer, Electrical, Chiplima Powerhouse, Chiplima, in favor of a workman. Exhibit 5 is the application placed by the workman Ravindra Gadia before the MLA Sambalpur. 6 is Xerox copy of certificate issued by the subdivisional officer, main subdivision 1, West Special Chiplima. Exhibit 7 is the Xerox copy of the letter dated 10/8/2000 placed by the workman Ravindra Gadia, addressing to the Assistant General Manager Electrical Hirakud Power System Chiplima for his engagement. Millard, your lordship. Then I am also reading thereafter. The workman in the evidence stated that he was working as an NMR under the direct control and supervision of Electrical Operation Division Chiplima during 84 to 87 and during December 98, and later on he was re-engaged in 2005 to 2006. Whenever the authority required his presence as an NMR, the workman has not filed any document regarding his appointment, nor filed any document regarding his wages. Moreover, he claims that he was working as a daily wage labor. WW2 stated that he knows the workman who was working at switchyard of the management from 98 to 87. WW2 was working as a helper with one Sri Rai Babu, operator. He was further stated that the workman was working and cleaning the grass inside the compound of the office of the powerhouse. 11 minutes, para 11. Admittedly, the workman has not stated the exact date of his termination from service. He has not given any exact date and month, and when he got his job as a daily wage laborer, nor stated when the engagement as an NMR by the management. MW2 Saroj Kumar, para 12 minutes, manager Generation Division Chiplima stated that in his evidence that he was never seen workman Sri Ravindra Gadia, nor detected any document nor any register maintained in the office to show that the workman was working as an NMR at Chiplima Division. Previously, it was under government, which was known as Orissa Electricity Board. After privatization, it becomes Orissa Hydropower Corporation. There is no such master role for the concerned period, that is, for the period from 1984 to 1986, nor from the period 2005 to 2006 to know whether the workman, after putting his signature on the master roll, was drawing his monthly salary from the management. The workman has also not filed any document regarding
Who's for
payment
the
of
workman
wages
here?
by the management.
1 minute, sir. 1 minute, sir. Who's for the workman here? Who's appearing for the workman? Who is appearing for the workman? You are appearing for the workman.
No, I am for the opposite. Opposite. Workman.
Workman. On behalf of Mr. J.K. Khuntia Mali.
Shall I read?
Yes, please. You do not have your paperwork also?
No, my lord.
No need.
No, my lord. Mr. Khuntia went to his village for casting his vote today.
Oh. Counsel for the respondent workman is supposed to have is in some personal difficulty. List on 10th May.
List item 43.
Counsel the petitioner seek leave to withdraw this petition. Dismiss withdraw.
List item 44.
My lord, 43 Karthik Jana, Central Government Council appearance may be noted.
All right, sir.
Item 44.
None appears dismissed from consideration.
List item 45. List item number 45.
None appears dismissed from
Weekly list item number 46.
None appears dismissed.
Weekly list item 47.
May I please, your lordship?
Yes, please.
Lordship, this application is relating to reconstitution of villages in schedule area. Here, the reconstitution as of now has been done in light of Orissa Gram Panchayat Act, Panchayat Extension to Schedule Areas Act 1996 is there. Pursuant to that, there has been an amendment in the government amendment by state government in 1997. However, so far the villages are concerned, it has not been reconstituted. Lordship may kindly come to page 12. Page 12, section 4. Section 4, 4A, 4B. A village shall ordinarily consist. Sorry, 4A. State legislation on panchayat that may be made shall, that is in consonance with the customary law.
Sir, just come to para 5 of the counter affidavit.
Lordship.
Para 5 of the counter affidavit.
Yes. They have done as per Odisha Gram Panchayat Act. But
No, 1 minute. Please read para 5.
Lordship, in reply to paragraph 1 and 2 of the writ petition, it is only submitted that the averments therein are not correct. The PESA Act came into force with effect from 1996. Odisha Gram Panchayat Act was amended in 1997 in consonance with the provisions of PESA. The government have already taken steps for reorganization and delimitation of grams wards in the year 2001 by government notification number so and so. Therefore, it is not correct to say that the reconstitution of wards Gram Panchayat have not been made in consonance with the provisions of PESA Act. Lordship, here what they have been saying.
No, you have not filed any rejoinder.
Lordship, as of now, there has been no redrawn of the villages.
How do we know that? This is filed in 2011. How do we know that? In fact, this counter affidavit is filed in 2012, almost 10 years ago.
Yes.
And you have not filed any rejoinder. So why should we not believe what they are saying?
No, even they have not placed any document to that effect.
What is your submission, sir? Simply saying they have not redrawn is neither here nor there.
Lordship, I have also given example of Andhra Pradesh state. In order to
not Andhra Pradesh, forget all that, sir. In Orissa, in the last 10 years, what has happened? Have you filed any affidavit?
Not yet, Lordship.
So you are yourself not interested in the matter, sir. It is because we are listing these matters today that we are taking it up. By yourself, you are not interested in these matters.
Lordship, challenging the similar provisions. Another petition has also been filed in 2016.
Then you
in fact, once after notice is being issued.
That if you wish to, you pursue that then.
Lordship, once after notice is being issued.
Withdraw this petition with liberty to pursue another petition filed in 2016 for the same relief.
May I please, your Lordship?
With liberty is prayed for. Yes.
Because that was in respect of 2017 Panchayat election, which has already been also, that has been completed. And now we are
either file a fresh petition, then you withdraw this and file a fresh petition.
Yes, Lordship. That would be.
The petition seeks you to withdraw this petition with liberty to file a fresh petition.
Great.
This is withdrawn with liberty spirit. All right.
Weekly list item 48.
None appears. Dismissed. Non-prosecution.
Weekly list item 49.
None appears. Dismissed. Non-prosecution.
Weekly list item 50.
Item 50, Your Lordship, no instruction, Your Lordship.
No instructions. Dismissed.
Weekly list pastor matter item number 6.
May it please, Your Lordship.
Yes.
Your Lordship, may I be permitted to say, my Lord, here, my Lord had asked me to take my lord, here, my lord had asked me to take instruction, my lord.
Yes.
My lord, the instruction that I've received from my clients are as on date, my lord. The IDCO is giving leases of in that same area for 1 acre of plot at 1 crore
So
rupees.
you
my
withdraw
lord.
this to pursue that then?
My lord, my entire problem is this, my lord. My lord, my humble submission is, my lord, may kindly see, I have no problem paying the market rates, my lord. I have absolutely no problem paying the market rates. My lord, may kindly see Annexure 10, my lord. If my lord my lord passes an order that they should consider, and my lord, they should give me in market rate, my lord, I have no problem, my lord. My lord, may kindly have a glance at Annexure 10 at page 41. My lord, the issue starts at page 37, Annexure 6. My lord, they themselves have come up with a amnesty scheme. I'm not an amnesty scheme today, but my point is they are hell-bent on not giving it to me, although it was vacant, my lord. And although they had sanctioned my initial plan, my lord.
Anyway, all that is over now.
My lord.
If you're prepared to pay the market value, you can make a representation, they'll consider it.
My lord, on that issue, my lord, if my lord says that I'll pay the market condition, market rate, my lord, I have no issues, my lord.
All right. Counsel for the petition had been passed over. To enable Mr. Mohanty to take instructions. Yes, Mr. Patnaik.
My lord, I am appearing for IDCO, my lord.
Yes.
My lord. In item 6, my lord, my instruction is this. My lord, they are the encroachers and they have encroached upon these lands, my lord. So,
You don't,
my lord,
they themselves are saying that, sir. So you do not have to. That whole petition is drafted saying we have encroached.
yes.
He hung or he's making submissions. You may have to reconnect, sir. Refresh your connection, Mr. Patnaik.
My lord, if I may as well, my lord, if my lord looks at the order sheets, my lord.
Sorry, my lord, I was not able to hear.
No, you may have to refresh your connection. Yes.
My lord, in fact, IDCO has not even filed their counter in this case. My lord, in fact, from 2005 to 2010, in spite of notice being sent, they did not appear. Hence, this court in 2010 only granted us an interim order, my lord.
But IDCO has filed a counter.
My lord, it has not been given to me, my lord, yet. No.
It's filed in 2020, 11th March 2020.
My lord, I mean, recently, my lord, has not been served on me.
Anyway, so you're prepared to pay the market value?
We are prepared to pay market value. My lord, may kindly record my statement, my lord.
Yes, Mr. Patnaik.
Yes, my lord.
He's prepared to pay the market value.
Yeah, my lord, the market value as on today, my lord.
Yes, obviously.
And if, my lord, that is as per our rules and regulations, then only we can. Sorry.
You have to unmute. Allow him to unmute. Mr. Patnaik, you have to unmute.
Yes, my lord. But my lord, because they are the encroachers, so there was encroachment proceedings, my lord. Now, if they want to pay it in the market rate, let them give a representation to the authorities.
That's what he's saying.
Yes,
Counsel for the Mr. Soumya Patnaik on instructions informs the court that the petitioner is prepared to pay the market value, current market value for the land in question, which forms the subject matter of the prayer clause in the petition. Mr. Patnaik, appearing for IDCO, states that if a petitioner makes a representation to that effect, it will be considered in accordance with the extant rules and policies of IDCO, and a decision communicated thereon to the petitioner in a time-bound manner. Paragraph. the petitioner will make his representation not later than 21st March 2022, making the above offer, which will then be considered by ITCO, and a decision thereon will be communicated to the petitioner not later than 25th April 2022. If ITCO accepts the offer and gives a time-bound direction for deposit of the market value, it will be made clear that if the petitioner fails to comply with the direction, it is liable for eviction in accordance with law. No further directions are called for, the petition is disposed of.
Grateful, my lord. Grateful, my lord.
Yes.
Pastor matter item number 7.
My lord. So far as plot number 46 and 48, my lord, I have cleared all the outstanding dues. That is the admission of the ITCO at page 47. I have cleared all the outstanding statutory dues. Page 47, my lord, annexer 8.
What is the market value, sir? What you are holding on to?
Market value, my lord, I have ascertained from my source of the client, my lord, which is 17 lakhs per acre. But it has to be verified from the source of
No, what is the total value of your plot? Don't ask us to do arithmetic, sir. What is the total value of your plot? Current market value of the plot?
Current market value, it has to be calculated, my lord.
Sir, we are not, you are testing our patience, sir.
No, my lord.
I will simply dismiss the petition now. Don't test our patience. We gave you time for this.
My lord, if, my lord, ITCO will...
You will calculate, sir. This calculation, don't ask two judges of the High Court to sit and do it here.
No, your lordship cannot calculate. ITCO will calculate, my lord.
You will calculate, sir.
My lord, as per my...
If you are interested in getting your petition considered by the court, you have to do this.
My lord, my submission is that 17 lakh per acre, my lord. And the...
You simply say you refuse to answer the question.
7 is measuring acre 0.1 or 25 decimal, my lord. My lord, if 17 lakhs is my submission, whether ITCO is accepting that or not, that's a part to be considered, my lord. I need to apply for that, my lord, before the ITCO. So far as plot number 47 is concerned.
We'll pass the same order, Mr.
My lord,
you're appearing in this as well.
My lord, kindly see in my para 5 of my counter, my lord, that plot number 47 and 45, the revenue plot number such and such in Paradip Industrial Estate. The petitioner has also encroached one of the GRP, which is the land has been duly allotted in favor of area GRP by the ITCO, my lord. But the petitioner has not implemented that GRP company, my lord, till date. And
so only one plot. He's not talking of other plots. Only plot 47, is it?
Yes, sir.
He's not interested in 46, 48 and all that.
No, 46, 48 are duly allotted, my lord. I have paid all the statutory dues.
No, my lord, kindly see, my lord. 47, my lord, in our rejection.
Page 47, my lord. Annexer 8. Page 47, your lordship, may kindly have a glance.
My lord, may see annexer 14, which is our rejection letter.
That has been withdrawn by the annexer 15, my lord. Next annexer that has been withdrawn.
Annexure 14 is a Bank of India letter, sir.
Annexure 14 has been withdrawn by the annexure 15, lord. My humble submission is annexure 8, my lord.
Yes, Mr. Patnaik.
Yes, my lord. My lord, my submission is this, that plot number 47, which was to be allotted to MS Nuts on allotment letter 17/10/2007, due to that encroachment was not able to hand over. Now, if my lord is considering, let them pay that market rate. If let them make a representation once again to the authorities. We'll consider that representation. Yes, my lord. If the land is available, that also has to be seen, my lord. If that particular land has not been allotted to anybody else.
All right. You say, counsel for the petitioner on instructions states that as far as plot number 47 is concerned, comma, which is the only plot for which the petitioner is seeking reliefs, comma, the petitioner is prepared to pay the current market value and will make a representation to the ITCO in that regard. If such representation is made, including the such offer not later than 14 March 2022, it will be considered and a decision thereon be communicated to the petitioner not later than 18th April 2022. If the
My lord, he
payment
has also,
subject to, in light of the ITCO's extant rules and policies, and subject to the said plot not having already been allotted to anyone else.
my lord, he has also encroached the adjacent lands to that plot number 47 also. So
This will also be subject to the petitioner vacating any other land that the petitioner may have encroached upon in the meanwhile.
That's okay.
Full stop.
So far as 46 and 48 minute, I
No
have
further
cleared all the
directions are called
statutory
for,
rules.
the petition is disposed of.
And my lord, let them execute this lease deed, my lord, in favor of 46 and 48. They have admitted
No,
it.
he says dues have not been paid for 46, 48.
Their letter I am reading, my lord, first paragraph, with reference to the letter referred to above, caption subject, it is intimated that MS International Food has cleared the statutory all outstanding dues of IDCO plot number 46 and 48 and represented for regularization of the same in favor. My lord, when I have deposited since 2006, my lord, thereafter I come.
What is your stand on that, Mr. Patnaik?
Yes, my lord. That's 46
and 48.
Which page are you reading?
Yes,
Page 47 at annexure 8, my lord. IDCO letter. Page 47 at annexure 8. First paragraph. And the proceedings and the money received I have paid. They did not execute the lease deed. I did not obtain the finance from my banker. I approached this honorable court in the writ, my lord. Additional cause of action was that an encroachment which should have been regularized. Twofold writ application I have filed before your lordship. They are not executing the lease deed, my lord. Lordship may direct me to pay the market rate in so far as the encroachment area is concerned, my lord. But so far as the legitimate allotment, 46 and 48, I have paid the statutory since 2006. That has been held off.
because my lord, here my lord, my answer to 5.1, it is that it is submitted that plot number 46 of industrial estate, Paradip, an area 14 decimal was allotted in favor of the petitioner by letter dated 5/7/1982 on HP basis for establishment of food and cattle feed and poultry feed, a mineral mixture manufacturing unit. The possession was handed over in 22/7, my lord. Thereafter, my lord, it was also the second plot, my lord, 47. Then, my lord, 46 and 42. As per the requirement, the possession of land was handed over thereafter, but the petitioner, instead of utilizing the such land, has given the same on rent to others, my lord.
It is disputed,
He
my
has
lord.
not-
Your lordship may see annexure 11, their own report, my lord, in my favor,
my
not in
submission
their
is
favor,
at
my lord.
current 9.
IDCO authority's own report is favoring my submission, my lord. It is against the submission which is being advanced by.
No, whether you sublet or not is not the.
No, not sublet, my lord. Your lordship fully functioning. Your lordship may see annexure 11 at page 51, solely relying, and that has not been denied. Hit by principle of non-traverse, my lord. In the counter, they have not denied this, disputed this document, my lord.
Anyway, they said in their counter that you have subletted to others.
No, counter is cannot be accepted in view of the report, and counter doesn't speak of any disputing this report, my lord. Sound totally silent. That means they have admitted this. They are accepting this document.
Yes.
Record can be called for and can be checked, my lord. It is the report of 2003 of their own inspecting officer.
That is 2003, sir. This is now 2000. We are now in 2006.
Yes, but they say that I have subletted. I have not, my unit was not functional. That has been disputed by their own authority. I also visited MS International Food Products. The unit is engaged in for manufacturing of dry fish. The land allotted for them is not sufficient to accommodate the dry fish.
What do you say to the 18/4/2006 letter, Mr. Patnaik? Annexure 8,
Annexure 8, my lord.
page 47. You had only said the matter of encroachment has to be sorted out first.
My lord, I'm reading it out. With reference to letter referred to above, on caption, it is intimate that MS Food Products has cleared the outstanding statutory dues for 46 and 48 and represented for regularization of same in their favor. As per the records, the unit has been encroached ITCO land measuring such and such, and a portion of ITCO plot by measuring 0.125. Therefore, before considering the regularization of plot number 48 in the favor of encroachment related matter, it is to be sorted out first with remeasurement of ITCO plot number 46, now under consideration of the said unit, my lord.
No, now that
my lord,
if he pays the market value for 47 and you accept it, then you should now act as per this letter.
Then also, my lord, we have to see whether that plot number 40, my lord, first 47 is now settled as per my lord's order. But with regard to 46, my lord, we have to see whether he has allotted it to somebody else or not.
He can't allot it to anybody, sir. What is this? What are you saying?
He may have given it to somebody else on rent, my lord.
No, that is not said in this letter. His point is that in this letter, you make no mention of any letting out to anybody else.
No, my lord. This letter, my lord, we have only stated that because there was encroachment, so we have to remeasure this plot number 46. Now under occupation of the said unit that we have stated.
All right. You say
we say that we accepted it in that position.
In favor of the petitioner in respect of plots 46 and 48, Mr. Patnaik states that subject to verification on whether the said plots have been let out to anyone else by the petitioner and subject to clearance of all statutory dues, the necessary steps will be taken once the issue regarding plot number 47 is sorted out.
They have already stated that I have cleared all the statutory dues. Number one, Annexure 11, their own report, they are not confronting it. They are accepting it. Annexure 11 report may kindly be reflected in the order. Annexure 11 at page 51. Your lordship may see their entire counter to my read.
That's a 2003 report, so we don't know what has happened after that.
No, 2003 report, now the 2006, they are saying that subletted.
All right.
Now, field inquiry has been.
Maybe you did it later.
And my lord, so far as the inaction prevailed at the end of the IDCO for the 10 years, so from 82,
anyway,
not executing the lease deed,
right,
held up all my rights, my lord, for financing, expansion was stalled, my lord, because of their laxity.
All right.
Well, it is a social benefit oriented legislation, my lord, and IDCO authority is acting like draconian authority, my lord.
All right, sir.
And they are not, they are acting to the detrimental to the intention of the statute, my lord. IDCO acts.
All right, sir.
Item 12.
Achha.
So you can also, if you also want to sit and argue, you can argue. Your friend had problems. I'm saying even if you want, you can sit and argue. No problem. You're okay. No. Mr. Das, you're okay.
Yes, in fact, I have recovered.
All right. No. I'm really saying if you want to sit and argue, you can.
No, I have recovered 3-4 cases. Normally, what I'm doing, 4 or 5 cases a day, maybe.
No, which is why I'm saying I have actually neither this Patnaik nor I have any such issues. Any lawyer wants to sit and argue, you can argue in our court. No problem at all, sir.
Well, that is the reason where I am coming to have the physical hearing for the simple reason. In our office, when I sit and argue, my lad, then I find I'm deficient, my lad.
I see.
Once I stand up and argue, I'm totally confident.
All right. Very good.
My lad, in fact, my landed friend was having some health issues.
No, that's why we asked him to sit and argue. Sir. No problem.
That is why he could not brief me correctly. But still, then, Milad, from my note prepared earlier,
all right,
I have not been able to assist your lordship because today my
sir, we'll permit you to file a written note of arguments. No problem at all.
I will. I will do that. Lordship may kindly appreciate 2-3 aspects. Well, let me not open the file. Well, what is sacrosanct as far as the government is concerned? They are relying upon 2 judgments or 3 judgments of the Honorable Apex Court.
Right.
Brindaban Sharma, 1995 Supreme Court. then
Satpathy.
Harapriya Bisway, my lord, then that Sethi. Three cases that lying upon by saying.
No. The main case is this, sir. Nityananda Satpathy.
No, I'll answer to all my questions read by Mr. Palit Palat. Look, there is a typographical error in that Brindaban Sharma case, for which the matter has been reopened in the Supreme Court, still pending. Look, Section 5I of the Orissa Estates Abolition Act, that says, Balad, any lease which was granted or any transfer effected prior to 1/1/1946 are not to be touched by coming into force of the Orissa Estates Abolition Act in the year 1952, my lord. But any lease granted after 1/1/46, my lord, if at all the ADM finds that the lease was granted by due process of law, then he has to refer it to the Board of Revenue for the purpose of ratification. But what happened in Brindaban Sharma's case, I believe probably that the OLR publication, that book was given, there was a printing mistake. In Brindaban Sharma's case, the Honorable Apex Court held that any lease granted prior to 1/1/46 is to be sent for ratification. Based upon that judgment of 1995, Balad, all subsequent judgments have been delivered, and now it is before the Honorable Supreme Court in another case. Of course, I cannot give the number. It's not being re-argued on this point, Balad. And on this point, I will never say, my lord, that the judgment of because your lordship, maybe, my lord, it will be sharking away from, my lord, saying it is par inquirium, because it's a Supreme Court judgment. But I put to myself a question. Here is a statutory provision, and here is a judgment of the court, even the Apex Court, which has not taken the statutory provision correctly or has not interpreted the statutory provision correctly, my lord. Then your lordship will be definitely, my lord, under the jurisdiction to say that the statute is valid. So now if your lordship sees 1/1/46, Section 5I, that says any lease granted prior to 1/1/1946 cannot be touched, remains unaffected. Admittedly, my lord, this present case, my lord, the petitioner, I've forgotten, the petitioner is dead, and thereafter, my lord, her legal heirs have been substituted. Like the petitioner's husband, who was a freedom fighter, my lord, before 1/1/46, got this land on lease from the Kaniga Raja.
That itself is a question, sir.
Sorry, my lord?
That itself has been put in doubt.
No, here I will straightway jump to the conclusion by my lord, accepting what the lordship says, my lord. What is the scheme of OEA Act, my lord? The scheme of the OEA Act is that if a person is a tenant under the ex-intermediary,
you are not a tenant there, sir.
Starting
point itself is
that is the public
for you.
That is the public document. I just
starting trouble.
No, that is the public document, my lord. I will come to that, my lord. Annexure 3 and 4 are the public documents.
The sooner you come to it, the better.
So, Lakshmi, kindly appreciate, my lord. There is a judgment of this honorable court.
Sir, judgments will come later. Facts will come first.
Yes.
No,
I'm coming to the fact.
The sooner you come to the facts, the better.
Well, yes, I am coming to the fact now, my lord. Before 1/1/46, Pilad, the property was leased out, Pilad, to Daitari Mahanti.
Not true, sir.
Pilad, let me explain the fact. What is it? They can't say no. They are saying it is for agricultural lease and it's not registered.
So the lease itself was not signed, sir.
Well, I'm coming to that.
The documents. You are saying I will come. You are not coming.
Yes, sir. Lordship, may kindly see, my lord. The document on page 18, my lord. That is it is in vernacular. My lord, just say Patnaik and my lord, Annexure 1. Well,
not signed by anyone. The finding is it is not signed by anyone. So the best way to present an argument when you're against an order of a member board of revenue is to go to those findings which are against you and tell us why those findings are wrong.
I have totally understood, my lord. Now, Lordship, may kindly see that Annexure 3, my lord.
Yes.
Look, this is the rent roll. This is a rent roll prepared by the my lord, estate abolition collector.
Whose name?
Well, this is
Prepared not by the ex-intermediary.
No, this is by the
Not
state.
signed by the, they don't even know who the gentleman is. What is his name?
Well, this is a
No, his name is mentioned in the member board of revenues order.
I'll just come factually just let me see that.
That is this is what the member board revenue has discussed. You come to that paragraph.
Well, I'll come to that finding straight.
So you can't come 10 years later, you have to come now.
Lakshmi just sees this document. I'll come there, Malad.
You come there,
Yes, Lakshmi just kindly sees this document, Malad.
Sir, this document we will see in light of what has been discussed about this document.
Malad, under section 74 of the Evidence Act, Malad,
right.
This has got evidentiary value.
Only if the person who put his name on it is before the court, not otherwise.
Just sees who has done it, Malad. It is the revenue authority. It is a revenue authority. Malad, this is a document which is prepared by the revenue authority, by state evaluation collector, on getting an information from the ex-intermediary. Otherwise, the document would not have seen the light of the day.
We don't know. Many documents see light of many days.
Then, if that is so, Malad, then what this when our own High Court says, Malad, if someone says the document is fraud or this document is somehow obtained, then they have to approach the competent court of law to declare that to be a fraud.
Who has to approach?
Like the state, Malad.
No.
No, that document, that judgment of Justice Honorable Justice Naidu, I was citing straight to Malad.
You first, sir, the problem is you do not want to come to the facts.
I am coming, Malad.
You do not want to come to the order, which is under challenge.
Malad, it's not a problem. I'll come, Malad.
Since we have been at the bar,
yes,
we know if you're weak on facts, you'll keep on citing judgments.
No,
lawyers who open their argument saying, see, this judgment, that judgment, Supreme Court, this court means facts is very weak.
So I'm showing the
if you're strong on facts, you will first argue facts.
I'm showing them. Now, Lordship, kindly see the copy at page 38. At page 38, Malad.
Yes.
Malad, with your Lordship permission, before that, Annexure 11, if your Lordship permits me to read at Annexure 9.
No, we want you to read.
We don't the sub-collector.
We don't permit you.
Okay.
We permit you only to read Annexure 11 first.
That's right. This is a revision under section 13B.
Not like that, sir. Please come to the critical paragraph which is against you.
Lordship, he has held in my favor.
Lordship, you will not be here.
Paragraph 8 at page 42. In his submissions before me, the learned lawyer for the petitioner pointed out that the petitioner was inducted as a tenant by the ex-intermediary, and after abolition of the estate, he was required to continue as a tenant under the estate by virtue of subsection A1 of section 8 of the Act. But in spite of documents establishing his tenancy and his continuous possession, the revenue authorities are refusing to recognize him as a tenant.
All right. Now come to, this is all your submission. Come to para 12.
Para 12.
12 is what is against you.
In this case, the petitioner has relied upon the patta of 21st of March 1944, given by the ex-intermediary, the Raja of Kanika. The patta in original had been filed before me, and it is signed by a person whose signature has been deciphered as Swapneswar Ratha by the learned OEA collector in his impugned order number so and so. Let me pause here for a moment. Who does the regional authority come to such a finding with regard to whether that has been deciphered by whom? But this is not, doesn't come within the domain. Then, Malad, petitioner has not proved who Swapneswar Ratha was, and if he was authorized by the ex-intermediary to give leases in his behalf. Lordship kindly says, Malad, an ex-intermediary could either grant lease by himself or he could grant lease through one of his employees. But that question now cannot be raised.
Why?
It is a 30-year-old document. Once it is a 30-year document, then it has the contents also go. It is not that the document can be said no. If it is not correct, if the Board of Revenue doubted the authenticity of these documents.
No. Who is this man is not the ex-intermediary.
Well, this was by the ex-intermediary.
This person who is named, is he the ex-intermediary?
No, he is not. He was an authority.
So it is admitted, therefore, he is not an ex-intermediary.
No, ex-intermediary is a Kanika Raja Malad.
So and he was not a Kanika Raja.
And he was an employee under the Kanika Raja.
Else, you have to show that he is authorized.
Well, after so many years,
if you are relying on this document, you have to prove the document.
But here the question is that this is not a civil court where the trial goes on. So I
Then
can
you go to the
produce
civil
evidence.
court. Then if you think this is not a civil court, you better go to the civil court.
No, then I am not questioning Annexure 3, the rent roll.
No, the question is the other way around.
May I explain that's the scheme within 2 sentences. What is the scheme of the OA Act? Once a notification is made, then if any lease is granted prior to 46, no, it is not to be touched. If granted after, then ratification. Then what happens? Then if the ex-intermediary wants to possess certain land in khas possession, then he has to make an application to the authority that these are the lands under my khas possession, I want to retain. And if there is a tenant under the ex-intermediary, then he has to submit a list of the tenants to the estate abolition collector.
So you are stuck at that very first level to show that you were in fact a tenant under the ex-intermediary.
Well, so I'm just coming to that, Now, of course, in the year 2022, I cannot say, what happened in 1946.
Sir, you are not able to say it even in 1995.
Well, that is the reason I am
You are not
emphasizing.
able to say it in 95. You are not able to say it in 91.
You
are not able to say it in 85.
Well, I am able to satisfy Lordship in all these points, because Annexure 3, Lordship may kindly see that is a public document. The public document says they prepared by the government authorities, Not only it's a public document and under Section 74, but also there is a presumption under Section 114 of the Evidence Act, because here is a estate abolition collector who has done in due discharge of his duty. He has made a mention in Annexure 3, Then anybody questioning that, has to go to civil court, It's not me. And thereafter, rent has been accepted from me. Once the rent, that's Basiruddin Saha case, ILR 1961, contact case 595. The division bench of this honorable court said, if state accepts rent from someone, then state accepts him as a tenant. If at all state wants to do away with the tenancy.
To accept. You had to file 2 applications to get the state to accept. The state was refusing to accept any rent from you.
What has been done here,
Your friend's list of dates says that. The state refused to accept rent. You have to go on filing petitions for acceptance of rent.
Yes, I had filed application,
So that argument goes.
Well, they accepted rent, but
they did not, sir. If I kept filing petitions for acceptance of rent.
Let me say, I will not state anything wrong, I am stating from record itself. If there is anything wrong in my statement, your Lordship can shut me down.
We are not shutting you down, we are pointing out.
Well, I am coming.
Even now, we are not shutting you down, sir.
No, if I am
pointing out your friend, your learned friend sitting by your side has given us this note, which says that the state refused to accept rent. You have to go on filing petitions.
If I am stating anything wrong, I will be automatically shutting down.
No,
I am not stating anything wrong on record.
Sir, you are not capable of being shut down. In fact, you are not shutting down. Despite my telling you. And I am not shutting you down. I am only asking you to read the same note your friend gave us.
As far as I know, your Lordship, by having argued so many matters, in fact, we know each other's anatomy very well. I can't say that,
No. See, the point really is on facts. One has to be very clear.
Exactly. I am just placing the facts, exactly. And have they said, no, this is not a document not issued by the estate abolition collector? They cannot say. If a document has been issued by the estate abolition collector, and that document has not been challenged anywhere, which is the 30-year document and has been done by the collector, in discharge of his official duty, Section 114 presumption, Section 74 a public document, it has got evidentiary value. And if at all they want to do away with the evidentiary value, then they have to challenge it before a competent court of law. So that is what the judgment of this honorable court. Since I will not come to the judgment before we are completing the factual aspect. Now, Lordship, kindly come to again page 12, para 12 at page 44. Well, 8th line from the top. There I had stopped. The petitioner, Lordship with me, the petitioner has stated before the learned OEA collector, and it has been recorded by the learned OEA collector in his impinned order that Swapneshwar Ratha was the Tahsildar of Kanikaraja. There is nothing on record to prove this. How can we prove it in the year 2000? It has been held by our High Court in the case of Mangusamy and so case that acceptance of rent by an agent is not sufficient to establish tenancy unless agent was specially authorized to grant leases and to recover the rent. In this case, there is nothing on record that the person who has signed the lease deed was authorized by Konica Raja to give such leases. Secondly, this document is an unregistered document and cannot be relied upon. Just here, Ballad, I'll take a lordship to section 117 of the TP Act. Ballad, section 117 is with regard to agricultural lease, Ballad. The agricultural lease under section 117 is out of the purview of the Ballad or the Tenancy Act, Ballad. I just read section 117. None of the provisions of this chapter apply to leases for agricultural purposes, except insofar as the state government may by notification published in the official gazette declare all or any such provisions to be so applicable. In the case of all or any of such leases, together with or subject to those of the local law, if any, for the time being in force, such notification shall not take effect until the expiry of 6 months from the date of application. There has been no notification by the state government to that extent. So if it is a agricultural lease, the question of registration doesn't arise. And Millard, at this point of time, allows me to state this small judgment, Millard, of the Honorable Apex Court. 1994, Volume 6, SCC, page 591.
Again, page 591.
Yes.
Carry on, sir. Carry on, please.
Paragraph 4.
Yes, yes. Please read. You don't have to wait. Yes.
It is then urged that the lease was not signed by the respondent, and it being a unilateral act of the Lambardar was contrary to the provisions of the Transfer of Property Act. Since under section 117 of the Transfer of Property Act, the agricultural leases are excluded from the operation of the Act, the provisions of section 107 didn't apply to it. Nor is there any merit in the submission that if the Transfer of Property Act did not apply the principles contained therein, would be applicable to agricultural lease. In view of a specific provision in the Transfer of Property Act, excluding agricultural leases from the operation of the Act, and the Tenancy Act of the state having provided for execution of the lease, which does not contain any provision like section 107 TP Act, the principle of 107 can be extended to it. So, Millard, what I humbly submit here at this point of time, this finding of the Learned Board of Revenue does not get the sanction of law, Millard. Then thereafter, it may be affected by an oral agreement, and when so affected, no registration is required. Millard, this is what it is. How could he get it from and where from? I don't understand. But he has rewritten the Millard section 117. But if the transaction is reduced into writing, then in case of a lease from year to year, or any term exceeding a year or reserving a yearly rent, registration would be required under section 17 of the Registration Act 1908. And if unregistered, then the lease will be inadmissible in evidence under section 49 of the Registration Act, and otherwise, for its term will be precluded from section 91 of the Evidence Act. This has been laid down in the case of so-and-so, which is irrelevant. It would be clear that the lessee or patta cannot be taken into consideration because it is unregistered, and no reliance can be placed on it because it has not been proved by the petitioner if the person who has signed the patta was authorized by the ex-intermediate to give such leases. The petitioner has also relied upon two rent receipts. The first rent receipt is of 21st of March 1944, the same date on which the alleged patta was given. It has been mentioned in the imprint order of the learned OEA collector that this rent receipt was for 1349 Sal, In this rent receipt for 4 years, 1346, 1347, 1348, and 1349 have been printed, and the figures of the rent have been recorded against the year 1349. Thus, the receipt dated 21/3/44 shows payment of rent in respect of 1349 Sal, but 1349 Sal corresponds to 1942, which is prior to granting of the lease of 4044. Now, this strengthens my case. Even prior to the formal grant of the lease, because of my possession with the ex-intermediary as a lessee, the rent receipt was granted. But obviously, there cannot be any tendering of the rent prior to creation of tenancy. Now, this is a preposterous finding. Such a finding doesn't get the support of any law. The next rent receipt is dated 16/3/1948. Through this rent receipt, rent for 4 years have been shown to have been paid. The years in the rent receipt have been overwritten. Overwritten figures look like the rent for 4 Sals, 1350, 1352, 1355, and 1356 have been paid through this receipt.
I hope you don't say even this works in your favor.
It does.
This also works in your favor, sir. You might say that. So
no, bloody. Malad, the judgment of Malad, our own High Court, with regard to rent receipt, Malad. Before citing this judgment, I'll just cite the judgment of Honorable Justice Naidu. Hundred 109 Ballad, volume 109, 2010 CLT 639.
all right. You put it in your notes, sir.
Yes.
Yes. Please proceed. Please proceed.
Yes. Once my learned friend gets it, I'll face
You
it.
put it in your notes.
Yes.
Yes. Carry on, sir, please.
Yes. And Malad, yes, sir, I've got it.
So you can put it in your note.
I
Just
will.
carry on now. Carry
I'll
on.
put it.
Ah.
Then, Milad, the third document relied upon by the petitioner is the certified copy on 8/7/81 by Kotak Tahsil Office. The certified copy has been filed before me. From a careful examination of this document, it is seen that on the top of the document, note has been made 1315, one same repetitions, Milad. Let me skip over that also.
It's better you skip because you're
That's
suddenly
all.
realizing all of that is going against you. So you want to quickly skip over all that. That's very good. It's a good sign that your case is getting weaker and weaker on facts. See, the most difficult portions you say, let us skip over it.
Well, why I'm
Unfortunately, both of us have read all of this.
okay, well, let me read 15.
No, you don't need to read now. We have read it. You have decided to skip over it. So
No.
let's get to the next point.
For
now.
the purpose of skipping over, my lad, it's not to weaken my case. It's the repetition of same things.
All right. So you come to your next point. What is the next point now?
It has been claimed by the petitioner that since 1944,
yes,
after the alleged creation of tenancy, he is continuously in possession of the suit land.
All right.
Revenue Inspector Kalaranga, in his report of 25th of May 83, has stated that during his spot inquiry, it was understood from the locality that the petitioner was in possession of the suit land since long, reclaiming this land every year. But no note of possession by the petitioner against the suit land has been recorded by the settlement authority. And here, there is a well-known principle, settlement record of right, it has a rebuttable presumption always. And because the name has not been reflected in the remarks column, then I am not in possession. But this is something which is a thought which can never can fit in with any legal proposition. In the record of mutation appeal, number 15 of 1992 at page 13, there is a mention how the plot has been recorded in the year 1973-74 settlement and 1988 settlement. In the year 1973-74 settlement, plot number 258 has been recorded with classification Unnata Jogya, Unnata Jojana Jogya, with an area of 184.18 in Khata number 472 classified as a Rakhit in the name of said government. There is no possession note of the petitioner in any portion of this plot. Malad, what could be the better document than Annexure 3 to show my possession, Malad? If my the Board of Revenue, Malad, ignores Annexure 3, Malad, the tenant's ledger, and says, I mean, not in possession, what best document could be given, Malad? In 1988 settlement, plot number 258 has been recorded with an area of this with Unnata Jogya, Jojana Jogya, classification in Khata number so and so, recorded in the name of General Administration Department. It is further seen that in the same Khata, 2 subplots and an area of 790 acres, 0.790 and 7.500 acres respectively has been recorded. And against these plots, illegal possession of Dhruva Sahu and Sebati Rautre have been recorded respectively. This shows that in the 1988 settlement, the settlement authorities, while recording plot number 258, has carved out smaller plots out of this and recorded illegal possession in the name of the encroacher in 2 cases. Now, let me put a question to myself. Was it ever an issue before the Board of Revenue? Well, he has gone beyond. So this anything going beyond the Millard issue is perverse. Then had the possession of the petitioner to the extent of 5 acres out of this plot be a fact, then the settlement authority would have carved out a smaller plot out of the main plot number so and so and recorded his possession as is and done in respect of 2 other plots referred to in earlier, where illegal possession of Dhruva Sahu and Sabitri Rautre has been recorded. This presumption in law that the petitioner is not in possession, raised on the basis of entry in the settlement record, does not stand controverted by the report of 25/8/83 of Revenue Inspector Kalaranga. Well, the Revenue Inspector also has a duty to act based upon an instruction to find out as to who is in possession. The Revenue Inspector Kalaranga finds me in possession, and because of something recorded in the record of right, in the remarks column, if not recorded, then could it be presumed that the report of the inspector is wrong and what has been written in the record of right is correct? I therefore hold that the petitioner has not been able to prove his possession of the suit land. It is also to be noted that subsection 1 of section 8 of the provides that any person who immediately before the date of vesting was in possession of any holding as a tenant under the intermediary shall be deemed to be a tenant of the state government. Thus, under law, possession of the holding immediately before the date of vesting is crucial. Konica Estate vested on 27 December 2052, which works out to 1359 Sal. Petitioner has not proved his possession of the suit land in 1952. He has also not shown payment of rent of so and so Sal. So it cannot be held that the petitioner was in possession. Well, this is a pure Millard factual error. Why is a factual error, Millard? In the rent roll prepared by the Tahsil, by the Millard Estate Abolition Collector, my possession is mentioned, and from which, and also I have been shown to be a deemed tenant because of that document. Well, about that document, there is no whisper here by the Board of Revenue, Millard. Relying on these documents and finding on possession, the fact of tenancy cannot be accepted. But that's all, Millard. That's the finding.
So all the remaining thing you put in a note.
Yes.
All right, orders reserved. The petitioner is permitted to file a written note of both petitioner and the parties are permitted to file the written note of arguments within 1 week. All right.
Millard, just Lordship permits me
that you put in a note, sir. Justice Naidu's judgment, no?
No. This is Justice Mahapatra's judgment.
If you put it in a note, sir, you put it in a note. No problem.
If I say and put it, I'll not take much time. Millard.
No, it's all right, sir. We'll read it anyway carefully.
That's right.
That much we can tell you. Yes.
I have full faith and confidence.
All right. Sir.
And one more thing, Millard, has been argued by my learned friend that it has been taken away by the transferred to GA department. But to answer to that particular query, if a property right is created, doesn't matter whether before GA department or any other department, my right over the property when gets established by a document of the government.
Anyway, you put all that in your, you
Yes,
put in your notes.
yes.
All right.
Supplementary list.
Yes.
Supplementary list, fresh admission, item number 1.
May I please it lordship?
Yes.
This is an appeal where the two questions have been referred for your lordships. Substantial question follow. That is question number 1, because the business is carried on.
Disallowing 4,02,000.
4,02,000
towards transportation
charges being supplied by the trader himself, stockist. That will be, that is carriage annual, the expenses. This will be arrive only in the purchase. This should not have been disallowed because the confirmation letter has already been issued by Annexure 1. That Annexure 1, page 10, my lord. The party himself has given that this is his expenses he has already incurred for transportation charges. That is 4,02,600. That is Annexure.
Let's see how the ITAT deals with that.
That ITAT has not considered, and ITAT has already overlooked and rejected both the things. That is that I am coming to. That is page 50, my lord. Bottom portion, that is 3.5 para bottom portion. We decide accordingly, confirming the impugned addition, this out of to the extent of 5,56,240. That is 4,02,600 plus 1,53,600. That they have rejected and confirmed this addition. In spite of the confirmation letter is there, they should not have disallowed because chance of confrontation could have been also given. I could have given a chance to examine the person stockist that where this letter is given, and this cannot be profit, net profit, because a trading receipt that is only purchase inflated. The person supplying me the
what's the tax effect? How much tax you have to pay on this?
Tax effect will be 4,02,000. Effect will be about to some 35%, etc. Then expense, that is interest also will come.
All right, we'll confine it to one question then.
Then another 2 questions.
Nothing, so that's 1,53,000 and all. We're not doing that.
Also big one.
All right, admit. Was the following question of law is framed for consideration was the ITAT right in disallowing a sum of rupees 4,02,600 incurred towards transportation charges? Question mark. The complete set of paper books be served on council for the. Will you take notice, sir? Mr. Mahapatra. Mr. Shivanka is already there. All right. List for final hearing on 10th May.
10th May.
May. Fresh admission, item number 2.
None appeals.
May I please your lordship? In this matter, the petitioners praise for a direction to the opposite party number 5 and 6 to conduct an inquiry regarding the illegal act of the opposite party number 4 and 5 in appointing the contact teachers within the knowledge of the.
Not, these are all service matters, madam. There can be no PIL in this.
PIL matter.
No. PIL on a service matter cannot be entertained. We say PILs in regard to appointment of teachers will amount to issue within the realm of service law. Leaving it, therefore, no PIL in this regard can be entertained. It will be open to the petitioners to seek other appropriate remedies in accordance with it.
Obliged.
I'm for the school and master.
Yes.
Supplementary list, item number 3.
Some letter must be, just show me the paper. in view of the fact that petition has not even been listed once and several years have elapsed, it is not possible to ascertain the current status. The petition is disposed of.
Supplementary item number 4.
On behalf of Mr. Panda, permitted to withdraw.
Counsel, the petition seeks leave to withdraw this petition. Dismissed as withdrawn.
Item number 5.
May I please, your lordship. Which is the limited prayer before a lordship is to provide a road for the school, on the basis of which I have made a representation on Annex 2 series at page 12, my lord. Sorry, I have not filed the English version of the ODI documents.
All right.
So
The
by the
petitioner's representations back at Annex 2 series shall be examined by
OP
the
number
collector.
OP number 3, my lord.
Katak, bracket OP number 3, and after giving a hearing to the petitioners, the reasoned order should be passed not later than 2nd May 2022 and be communicated to the petitioners not later than 9th. The court clarifies it is not expressed in view in the matter.
Supplementary item 6.
In this case, my lord, the grievance of the petitioner has already been met in.
All right. Counsel, the petitioner states that the petition has been rendered infructuous. Disposed of as such.
Supplementary item 7.
May I please, your lordship.
Yes, please.
This is the second joining of the petitioner, my lord. He had earlier filed an application PIL, my lord, seeking direction for a protection of a cow, the prohibition of slaughter of cows, and my lord also cruelty to the animal, my lord, and so also to illegal cow challan and illegal transportation of cows, my lord. In paragraph 5, my lord, I had mentioned, my lord, I have mentioned,
Sir,
my
can
lord.
you give some instances?
My lord.
Can you show us some instances?
My instance, my lord, annexure, my lord. My lord, I have annexure, my lord, 14, my lord.
There's no annexure 14.
Annexure 13, my lord. UP Cow Slaughter Act, my lord. That has been amended, my lord.
No, no, this is the UP Act, sir.
My lord.
We are
But
in
here,
Orissa.
my lord, they have, though this honorable court direct given a direction to the
Give
state
us some
council.
concrete instances, sir. This broad sweeping things will not help us. Give us concrete instances of any violation of any law or cruelty to animals, something. Give us concrete instances. It's a PIL after all, sir. You'll have to make some extra effort.
My lord, in Orissa, my lord, each and every day, my lord, illegal cow transportation challan, my lord, happening, my lord. For
Which is
that
why
is-
it will be very easy then for you to.
My lord, so many cases are registered.
That's
My
what
government can say, my lord.
So if there are so many cases, you should
My
not
lord,
at least a few.
my lord, at least my lord, in Jagatpur PS, my lord, there are so many cases government can say, my lord. But so many cases, man, in Orissa.
Correct.
And illegal cow challan and illegal cow slaughter, my lord, going on in the Orissa, my lord.
So, Mr. Ragada, that's precisely what we are saying.
My lord.
If there are so many cases, you should be
My
able to bring us a few before us.
My lord, then I, my lord, given time, my lord, I will file the additional affidavit, my lord.
Mr. Ragada seeks time to file an additional affidavit.
1 week.
By the next date, list on 4th April. All right.
My lord.
Supplementary item number 8.
Item 8, my lord, similar. My lord, similar matters, my lord, I plead to adjourn it for 9th of April, my lord. The matter relating to inclusion of the present petitioner in old GPF rule, my lord, instead of new one.
What is this? I don't understand. What's the connected matter? I don't understand. What is this matter about?
The matter relating to
Connected matter, your lordship, sorry for interruption. 9 is also same. That is WPC number 34422 of
All right. List both these on the
2021.
same date. All right. List
All right.
both on same date. All right.
Orders item number 10.
None appears dismissed on prosecution.
Supplementary item number 11.
Right. The matter is disposed of since no directions are possible to be issued.
Supplementary list item number 12.
Dismissed for non-prosecution.
Supplementary list item number 13.
Let comment back one of the factor. Is it the lease was granted for the year 2016-17 to
Nothing
2021?
survives, sir. The matter has been rendered infructuous because of the subject matter.
Whether it is
Petition disposed of.
continuing or not, I am taking.
It's okay. We'll solve you of that problem, sir. Right.
Supplementary item 14.
None appears dismissed for non-prosecution.
Supplementary item number 15.
Item number 14, permit to withdraw.
14 is permitted to be withdrawn.
Item 15.
Can you alert infructuous?
15 infructuous. 16.
Item number 16.
None appears, dismissed for non-prosecution.
Supplementary item 17.
May I please, Your Lordship?
Yes.
This case, my lord, the annexure 1 is under challenge, my lord. The petitioner, my lord, and the being the president of one organization, my lord, namely Anchalika Janamancha, my lord, filed a repression on, my lord, before the opposite parties, my lord, stating that therein that, my lord, the Vedanta Aluminum Limited, my lord, but there are polluted waters and, my lord, so many things are, my lord, came to the
You have not made them a party, sir.
My lord, I have made them.
No. None of the opposite parties is that.
My lord, 5, my lord, 5. Opposite 5, my lord.
Oh, like that.
My lord.
You have not put the company straight off. So you made a representation to whom? Pollution Control Board.
My lord.
All right. The petitioner's representation, bracket annexure 2. What's the order of the pollution control board?
My lord, 1, my lord. Annexure 1, annexure 2, the my lord, pollution board. Earlier, my lord, verified that area, my lord, given a report, my lord.
Earlier.
My
All
lord.
right. The petitioner's representation, bracket annexure number 1,
my lord,
shall be examined by the. So that representation is not given to the pollution control board. It's given to the Vedanta.
Now, since my pollution control board, Vedanta and others, my lord, pollution control board already, my lord, given a report, my lord.
No. Sir, let's understand. The representation has to be made to an authority,
my lord,
saying that the company is violating your order. Not the other way around, sir.
My lord, may be permitted, my lord, to file.
You withdraw, yeah. Counsel petitioner seeks leave to withdraw this petition with liberty to approach the concerned authorities with a proper representation. And after following up on such representation to seek appropriate remedies in accordance with law. All right.
Supplementary list item 18.
None appears, dismissed for non-prosecution.
Supplementary list item number 19.
19 receipt, kindly permit 1 week time to remove the defect.
All right. Defects be removed within 1 week thereafter.
Supplementary item 20.
None appears.
Item 29, please, Your Lordship.
Yes.
Here, my lord, the present petitioner, the farmer, challenging the order dated 8/5/2021 under annexure 1, my lord, passed by the observant 2, where the observant 2 has reorganized the primary agriculture cooperative society
I think
limited.
we already dealt with this, no? We dealt with this primary agricultural
Yes,
cooperative
primary.
reorganization. We issued a PIL. I think we dealt with this.
Yes, my lord, in that, in this case, it was initially listed before Lordship and your Lordship were directed whether appeal or any other alternative remedies there. So, my lord, I was, Lord, appeal provision is there, my lord. Any?
No. Appeal is not, it's not appealable.
Yes, 14.
109(2)(b), I asked you to examine.
Yes.
Is it appealable under 109(2)(b)? No. All right, you say notice. Mr. Das accepts notice on behalf of the opposite parties. Reply we file within 8 weeks, adjourned up to the next day.
1, 2, 3, 4.
Let's go. 27th June.
Yes.
Right, sir.
My lord, I have filed a miscase, my lord.
Miscase also notice on that. All right.
I pray, my lord, for stay, my lord.
No questions. Yes.
For admission item number 21.
For item 21, I am appearing before your lordship. Lord, so before I begin with the matter, actually, the Sarojini Biswal has died, the petitioner, and a substitution application has been filed.
All right. That application is allowed.
Yes, my lord. But now, with regard to the merit, if your lordship kindly see, this is a peculiar case. In fact, so far as I have come across on section 38B of the OEA Act. If your lordship looks at the cause title at annexure 1,
yes,
it's 9.
Snehalata Biswal.
Snehalata Biswal filed this application on section 38B. If your lordship looks at 38B,
yes,
section 38B doesn't postulate any party to file any application, my lord. But what has happened here, the property in question vested in the state, and Sarojini Biswal as an intermediary filed an application for settlement on the OEA principle, lease principle, that was accepted, and the land has been settled in our favor in respect of 2 acres or decimals. The present petitioner before the opposite party number 1, who was the petitioner before the OEA authorities, she challenged the order before the in the commission, the consolidation authorities. That was challenged, an appeal was filed, that was dismissed, a revision was filed, that was dismissed. She slept over the matter, and in 1987 and then 1995, she filed this application under the OEA Act Section 38B. Her application was entertained. Her claim is specific that she obtained a Hathapata from the ex-intermediary. And on the basis of the Hathapata, she was a tenant.
Mr. Mishra, I just was reading the order dated 17 July 2019.
My lord.
Just read that.
17 July 2019.
Order of this court.
My lord, order this was heard actually before, my lord, previously.
Issue notice to OP number 3.
No, 17 July. 17 July 2019.
I'm sorry, my lord, extremely sorry, I don't have the copy.
Just read this. You saw that? Just show it to. Hey, just show it. Which bench is this? Some other?
No, it was Justice Panda, my lord. I think Justice Panda, sitting in division, heard the matter.
No. It says, this order says
that her counsel,
the counsel has been elevated
to the bench.
So, was another lawyer engaged?
I don't know.
Because that will be the main contesting party, no, sir?
Yes, contesting party.
Is this issue alive still?
Yes, but actually she is in possession actually. The land was settled in her favor under the OE Act.
No, if somebody's entered appearance is one thing. So she was supposed to intimate the court if she's not interested in the litigation. So we presume she's not interested, sir. All right. On 17th September 2019, the following order was passed to this court. Paragraph thereafter, there has been no appearance on behalf of opposite party number 3 till date. The presumption, therefore, is that she is not interested in the litigation any longer. So it will be noted here that the present round of litigation, which culminated in an order dated 23rd March 1996 being passed by the Board of Revenue under Section 38 capital B, was at the instance of opposite party number 3. To stop, this petition itself had been entertained more than 30 years.
Yes, sir.
After the land in question had been settled in favor of the present petitioner. While issuing notice in the present petition way back on 23rd May 1996, the impugned order of the member Board of Revenue had been stayed. Mr. Mishra and the senior counsel for the petitioner states that throughout the petition has remained in possession. To stop with opposite party number 3 being the main contesting party not being interested in pursuing the litigation. The court sees no reason why the impugned order dated 23rd March 1996 should not be set aside. It is accordingly ordered. The petition is disposed of.
Supplementary list item 22. Item number 22.
State. Mr. Mudli.
22. I'm sorry.
Sorry.
I'm very sorry. My lord, May I pray your lordship to take up because it will be lengthy argument.
And who's for the other side?
Mr. Misra, senior counsel.
Ah,
I'm there, my lord.
I see. All right. At the request of
Can I just bring your lordship notice one thing, my lord?
Yes.
The three orders, one order has been passed in three analogous matters, my lord,
Right.
by the member board of review, my lord.
Right.
There are 3 writ applications pending before this honorable board.
Okay.
In one of the cases, the counter has been filed.
Right.
Other 2 cases, actually, it was transferred brief. Last date, actually, it was given to me. In WPC 1189 of 2015, counter has been filed.
All right. So that is
So
to be
all
heard
the
with
3
this.
cases may be taken up together.
Another case number is, sir, 1189 and another.
So one is 17364 of 2007, 1189 of 2015, and 10757 of 2005.
Yeah, the last one is on board today. All right.
Yes, yes, madam.
List along with the other 2 writ petitions for hearing on 12th May.
Supplementary item 23.
May I plead your lordship? May I plead your lordship?
Yes, please.
My lord, the original petitioner died in the meantime, that is on 22/4/2012. So I have filed the substitution petition.
Yeah, we are allowing that, sir. You come to the main matter now.
My lord. Now, the facts of the case is that the lease was originally granted in favor of Surendranath Mahapatra. He had subsequently alienated the said property in favor of one Suchala Misra by registered sale deed in the year 1985. Thereafter, the said Suchala Misra had alienated the same in favor of the deceased petitioner, and prior to that, the ROR was recorded in the name of the husband of Suchala Misra and son of Suchala Misra, that is the vendor of the present petitioner. My lord, the original registered sale deed is under Annexure 2 of my writ petition.
So what is under challenge here is the Tahsildar's order.
Yes, my lord.
That's appealable, sir. The Tahsildar's order is appealable.
The order was passed under section 3P of OGLS Act, my lord. Orissa Government Land Settlement Act 1962.
Is it an appealable order, sir?
My lord, it is appealable, but my humble submission is that
there is no stay of the order also. In the last 20 years, no stay.
But I am in physical possession, my lord.
So
my lord, I am in physical possession.
Stay happy, sir. Nobody is disturbing our possession.
My lord, the crux of the matter is that I have never been served any notice. Though it was, though the impugned order was passed.
If you want to file an appeal, when permit you to withdraw to file an appeal.
My lord, delay is there, so delay may be.
That because of the pendency of the petition, will explain it.
My lord, the
petitioner seeks leave to withdraw this petition with liberty to approach the appellate authority in accordance with law. If such appeal is filed not later than 21st March 2022, accompanied by an application for condonation of delay, explaining the delay on account of the pendency of the present petition, it will be examined with the appellate authority in accordance with law.
My lord,
it is not expressed any view on merits. Yes.
One thing I may submit, my lord, the impugned order was passed in the year 2002, and the present writ petition was passed filed in the year 2009.
Yes. So, whatever explanation you given here for the delay, you will give it there also. Yes.
I do not have any knowledge regarding the impugned order. That is the.
All right. Same explanation you give. If they believe it, they will believe it.
Supplementary item 24.
Sir, no instruction.
No instructions disposed of.
Supplementary item 25.
None appears disposed of non-prosecution.
Supplementary item 26.
None appears dismissed for non-prosecution.
Supplementary list item number 27. 27.
27 I have for opposite petitioner 5.
I am appealing for OP number 8.
Opposite petitioner 5.
All right. Put down the appearances. Dismiss for non-prosecution.
Weekly list item 20, supplementary item 28.
My lord, today I may not match your lordship speed, my lord. My lord, matter may kindly be taken up on any Monday, my lord. Because this is for the interest of CMC and BMC, my lord.
All right. At the request
any
of
Monday.
Petitioner who appears in person list on 18th April, sir.
Obliged.
Supplementary item 29.
Show me that clip. Last legal services. Okay. The affidavit dated 18 June 2015 has been perused. The court is of the view that the issue raised in the petition requires to be examined on a constant basis and monitored by the Orissa State Legal Services Authority. Consequently, a copy of the letter of the petitioner along with the aforementioned affidavit shall be provided by the registry to the Secretary, Orissa State Legal Services Authority, for appropriate steps. The petition is disposed of.
Supplementary list item 30.
In this case, my lords, is a matter relating to the my lords, formation of village forest committee, my lords. By the order dated 8/6/2017, my lords, your lordship directed the state council to file the counter affidavit, my lords.
No, we have not filed, my lord, but if the cause of action survives, the petitioner may approach the DFO and he is praying for creation of Bana Suraksha Samiti. Now, if the and meanwhile, my lord, much time has passed, so lordship may permit the petitioner to approach the DFO, then he will take application.
All right. Counsel for the petitioner states that he may be permitted to approach the district forest officer.
Yes.
Divisional forest officer. Puri, for appropriate reliefs. The petition is disposed of, is withdrawn with liberty.
Supplementary list item 31. Item number 31.
May I please, sir? Hello. May I please, sir?
Yes, please.
This is a PL, Miller. The matter relates to discharge of untreated water to river Kathojodi, Miller, at Kotak, Miller, at Khannagar, Miller. The fact of the case is that, my lord, a sewage treatment plant was set up at Kotak in the year 1980, Miller. Am I audible, Miller?
Yes, please.
Miller. Your lordship may kindly see annexure A by 5 of the opposite party number 5, Miller.
What's the current position, sir?
It is still continuing, my lord.
Can you show us some photographs?
Miller,
just produce some photographs. We'll immediately constitute some team by the Pollution Control Board to go there.
Tomorrow I will file photographs.
Counsel for the petitioner states that the problem of discharge of untreated effluents into the Kathjodi River is continuing. He undertakes to produce certain photographs, video clips on the next day.
Miller.
List on 21st March, sir.
List.
Supplementary item 32. Item number 32.
None appears dismissal.
Supplementary list item number 33.
None appears dismissal.
Supplementary list item number 34.
I am appearing as an amicus curiae. Court has appointed as amicus curiae, but the petitioner is represented by counsel also, Mr. B.S. Tripathi.
Mr. Rathamalad, the justice.
Also, I am appearing as amicus curiae.
So just
myself and Mr. Rathamalad. Myself and Mr. Rautrai have been appointed as amicus curiae by my
Right,
lords.
right, sir.
For a limited purpose, whether a judgment passed by a division bench with reference to the rule of this High Court rules 2015, whether the correctness of the judgment is to be only examined by us and to bring to your lordship's notice. That's all.
Oh.
25/3/2021 order.
Oh.
Lordship kindly.
So I don't think that today your lordship have time. Mr.
Oh.
Tripathi can agree also that
It will definitely take some time.
Because this is a case of senior secretary of this honorable court, madam.
What's past such an order? Oh. Jadunath Sahu.
Yes. The only question for consideration in that case is whether the rule 2015 is a prospective or can it be construed to be retrospective. The rule provides that a particular qualification and eligibility criteria, whether can it be violated. That is the question for consideration which Mr. Tripathi can address to your lordship. But I found that the judgment, it has been dealt with very vividly. So all the references of the Supreme Court and other things, and the division bench has delivered a judgment.
Yes, ma'am. Lord, I am covered by that judgment because in that judgment, madam, if you also look at that judgment, in that judgment, madam, it was held that the consideration made by the DPC was not correct. Because the persons madam considered were not having that eligibility criteria. But also look at para 5, the cost of the issue has been dealt with.
Who's appearing for the opposite side? No notice has gone in this.
On
I am
behalf
for
of
the
Mr.
state.
Mahapatra, I am appearing for OP 6 to 12, my lord.
All right. No notice has formally gone in the petition or not?
Yes, ma'am.
Notice, yes, my lord.
So you have filed a reply.
Yes, ma'am. We have filed counter. They have also filed rejoinder.
And you also directed madam to produce the record also. It was also produced madam before Honorable Justice Mr. When my lord
The
was-
record here today.
Records not with me, my lord.
Because records will be necessary, madam, because
All right. The records will be produced by the opposite parties on the next date. List on 16th May, sir.
15th May.
16.
Supplementary list item 35.
16th May.
Item number 35.
I am for the opposite part number 3.
This will take some time, sir.
My lord, I am for the opposite part number 3.
It will take some time. It will take some time.
Will it take time?
No, my lord.
It
Because
will be over in 5 minutes.
my lord,
Will this case be over in 5 minutes, sir?
I am for the opposite part number 3. My lord, I can finish it within 2 minutes.
Petitioner is not there.
Petitioner is not there.
Oh, who's for the petitioner? We just pass it over once.
Supplementary item 36.
At item 36, I am appearing for the municipality OP number 4.
My lord, I am for the petitioner, my lord. My lord, the office file has been misplaced somewhere. So may I pray next week, my lord, I need it. The matter
What is the
related,
matter about you, tell us?
my lord, the matter relating to construction of a illegal construction over a non-majority land, my lord. And if the construction be made, my lord, the ingress and outgress of the petitioners
All
will
right. Your
hamper.
representations, is there any? Okay. The petitioner's representations.
Lord, I have filed a counter.
Ah.
If Lordship would kindly see page 6 of my counter. This litigation was earlier brought to the notice, brought to this honorable court. And this honorable court by a specific order has permitted the municipality to go ahead with the construction and complete the same. But it's in the shape of a PIL. Now the other person has come up before your lordships opposing the action of the municipality. Lordship may see, kindly see that order annexure, Lord, page 5, 9934 of 2004.
Right.
And your lordship will find that there is a clear order passed by this honorable court permitting construction with certain conditions, Lord, with regard to making provision for passing of this water.
This was passed way back in 2006, sir.
Right, my lord. 2006 only. My lord, by some litigation or other, now the construction is almost complete now.
Oh, it's complete.
Yes.
Mr. P.K. Rathwell, learned counsel, appearing for opposite party number
4,
has drawn attention to the fact that a detailed order had been passed with this court on 9 January 2006 and writ petition civil 9934 of 2004, where this court had specifically permitted the construction of a passage, is it?
Lord, it's a construction of a market complex which may, by making
market
provision.
Complex. All right, market complex subject to certain conditions.
Yes.
Specified in the order. Mr. Rathe informs the court that this said construction is almost complete. In that way, the matter no further interference is called for. The petition is disposed of.
Supplementary item 37.
Lordships. It is a second round litigation, my lord. Here the petitioner. Lords may kindly see the last order, my lord. Order dated 27th of January. Lordship had asked me to file the location of the Anganwadi center and to get instruction whether an approach road is there or not. I have already filed, my lord. Lordship. There is an approach road to the Anganwadi center which has been used for construction work of Anganwadi center, and the present status of the construction is that it is almost complete except coloring and finishing work, which may kindly be seen. That is wrong, Lord. I will say that is wrong, Lord. Lord, the State Council which was saying that the approach road is there, that is a disputed land. That is a restaurant order is there.
What land?
Yes, that is a disputed land, Lord.
What is it?
Yes, that is restaurant. That forcibly they broke the boundary of a person. That has been stayed by, that has been restrained by the court below. Person can see that I have got the order. They are only there. Yes, Lord. Yes, this is the order, Lord.
You have to give him a copy, sir. You put it on affidavit.
Yes, I'll give affidavit. But the false allegation, in fact, he can also answer to the affidavit. Yes, also better. It will better if they will file counter.
No, I have filed that affidavit. I have filed those documents.
Maybe that the counsel of the petitioner always states that he will file an affidavit.
Yes.
To counter the above submission.
Yes. I'll give the entire documents
to be filed before the next day. List on 19th April.
Oblast.
Yes, supplementary list item 38.
Let's say fix date.
19th April. 38.
May I please alert? On the last occasion, your lordships had directed the state to file a counter.
Yes, your lordship, we've sought for instructions, your lordship. Somehow we need few more weeks, your lordship, to file it.
Ms. Patnaik seeks and is granted a last opportunity to file affidavit within 8 weeks. The joint offense. List on 17th May.
Oblige, your lordship.
Supplementary list item 39.
Item 39, I am for the petitioner. They have filed an affidavit stating that they have a ramp facilities is present in almost all the booths. But your lordship, as per the instruction I have received, every work has been done the day before, the day on.
At least they got done, sir.
After the order of this court, they have done.
Keep the kind of pressure on.
I have filed an affidavit.
Vigilant and you keep the pressure on.
So I can file a pen drive, your lordship, if you see the original situation of that place.
Which one?
Pen drive. I have the situation of the polling booths.
Sir, only 2 more days are left, correct?
Yeah,
only one more day.
One more day.
But then urban bodies will have the same problem.
They don't have braille in
everything has been done. Everything, Lord, I have shown the affidavit through additional secretary, and he has been.
You better thank this young lawyer.
Yes.
Putting a pressure on you, which is welcome.
Right.
Your lordship, the braille, they have accepted that braille is not available in
braille is concerned.
Let them make that available on at least on municipal elections.
Yes.
Section 42 of the Gram Panchayat Act rule provides, in case of a voter who is physically incapacitated or is blind, the presenting officer shall, at the request of such voter, allow him to take a companion to the place set apart for voting. This has been done in terms of this provision everywhere, and none has been deprived of
if any visually challenged, okay. On you, we'll put one more pressure on you now. If you find any visually challenged elector who has not been able to vote, you tell us.
Yes, they have voted, but with the help of someone else. Your Lordship, as per Conduct of Election Rules 1961, Section 14, recording of votes of blind voters, and they have specifically stated that there should be a braille.
No, that is a Commission of India. That is nothing to do with this.
But there is a law for that.
We have a voting system here.
Mr. Rautre, you'll have to upgrade.
That's right. Provided the financial also know the constraint of finance.
No. In fact, we don't know any such constraint. There should not be any constraint.
Right. The EVM system is not here, Milord.
So we'll keep this petition on till the urban body elections are over. All right. You say, counsel, the petitioner states that even now braille facilities are not available, and hopefully they should be made available at the time of the urban bodies election. Mr. Rautre, senior counsel, states that an affidavit will be filed specific to this issue before the next date.
Yeah, so far the Gram Panchayat election is concerned.
Meanwhile, the SEC will not slacken its efforts in providing proper access to differently abled persons, even during to the polling booths, even in the urban body elections. List on, when are those urban body elections?
April, on the month of April they have.
April. So we'll have this on 6th April, Mr. Rautre.
Yes.
6th April. All right.
And we also direct the State Council also, because they have to cooperate.
Very much. Mr. Das is here. Mr. Das is here. All right.
Obliged.
Supplementary list item number 40.
May players. Illegal construction over a government land. Last accusation opposite button 7. After I have already served copy. He has to file the counter.
Mr. Napoleon Sani.
My Lord, may kindly see paragraph 9 and 13 of the counter affidavit filed by the opposite partner 3 and 4. Yes, the land have been pursuant an order passed by the Land Municipal Court Baleswar.
Mutation.
Yes, in TS number 490 of 92.
Allowed in favor of Vijay Kumar Pradhan. He's only opposite party 7, I think.
Yes.
So, Mr. Napoleon, where is Mr. Napoleon?
My Lord, my humble submission is the ROR published in the year 1987 in favor of the government. Subsequently, 1993, one title suit filed before the municipal.
1 minute. Where is Mr. Napoleon Sani had filed for opposite party number 7?
Now, this order has to be challenged.
The mutation order.
Yes, that order.
The decree which has been passed in title suit, that has to be challenged.
Yes, that order was challenged by the government, but government just challenged, they filed the appeal. Subsequently, non-appearance, the case dismissed. And in also title suit, government has
all the more then that person will come and argue that it's all final now.
Yes.
If you're interested in challenging, you should challenge.
So that is a government land, my lord.
Yes, Mr. Mudli.
93, this order was passed by the land court below.
It is government land. How is it mutated? You file a response to that counter.
Regender.
None appears for opposite party number 7, although one Mr. Napoleon Sani, Kabiraj. No, Napoleon Sani, advocate, has entered appearance. No counter affidavit has also been filed yet. A last opportunity is granted to opposite party number 7 to do so. The registry will telephonically inform Mr. Napoleon Sani to remain present on the next date. 4th May.
Sorry, my lord, item number 25, my lord. That there was an error of network. I was there, but
tell us what is the matter about? Tell us.
Regarding record of right, my lord, creation of record of right by virtue of the order of this honorable court, the lease has been restored Despite that, and accordingly, the Tahsildar has directed the record keeper to record the land in favor of the petitioner.
So
Despite
it's in
that,
structures now.
the stage Miller, in the meantime, one suit is where there was fraud in transaction. One suit is pending. That is civil suit number 2306 of 16.
You are for the
Before
petitioner, correct? You are for the petitioner.
Yes, yes.
So it's in, you want to pursue the other civil suit.
Yes, that observation, because in the counter it has been stated that
All
that
right.
land.
Counsel, the petitioner states that he will pursue the civil suit, details of which have been mentioned with the counter affidavit of opposite party number 1 in accordance with law. Granting the petitioner the permission to do so, liberty to do so, the petition is dismissed. All right.
Passed over matter item number 35.
My lord. Item number 35, my lord. The opposite party number 3 is the private opposite party who has to file counter, my lord. In this case, if my lord, my prayer will be allowed, then he will.
Where are you? Say you have to appear.
My lord.
I think your camera is not on.
Yes, my lord.
You are appearing in person.
No, my lord, I'm advocate, my lord, because I am.
But you're not attired properly, sir.
I'm sorry. I'm sorry, my lord. I'm sorry. Actually, I am ill and I need some time, my lord.
Counsel for the petitioner is not in a position to appear in virtual mode. In the interest of justice, list on 10th May.
God bless.
Item